ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಆಡಿಯೋ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಹಲೋ, ಕೋರ್ಟ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
Page wise adjournment. List number 1, page number 1, serial number 1 to 5, page number 2, serial number 6 to 15.
Serial number 11, my lord, informed to Jagan Mohan. I see 2 weeks time, my lord.
Serial number 12.
11, my lord, Anand.
11. Yes, at the request of counsel for the petitioner, leaves this matter after 2 weeks.
Entry matter is
number 14, my lord.
Entry matter is required to be extended, my lord.
Interim order granted earlier is extended.
Trial court settlement ಆಗ್ತಾ ಇದೆ sir. Trial court settlement ಆಗ್ತಾ ಇದೆ.
14.
Next month.
14.
Yes, my lord.
Yes, at the request of counsel
Interim
for
order
the petitioner.
extended.
Next week, interim order granted earlier is extended till next.
Please, my lord.
Page number 3, serial number 16 to 20. Page number 4, serial number 21 to 26. Page number 5, serial number 27 and 28. Page number 6, serial number 29 to 31. Page number 7, serial number 32 and 33. Page number 8, serial number 34 to 37. Page number 9, serial number 38 to 41. Page number 10, serial number 42 to 44. Page number 11, serial number 45 and 46. Page number 15, serial number 47 to 49. Page number 16, serial number 50 to 52. Page number 17, 50, serial number 53 to 55.
Serial number 61 week.
55.
Please.
You are appearing for
Chandrakanta.
Chandrakant R. Patil.
And for the appellate, one matter.
International IFR stay, yes, at the request of counsel for,
I am for
Appellant.
appellant in
yes,
55/1. I am
Yes.
for appellant in that case, my lord.
yes, madam, you have any objection?
The condoning delay without
No.
interest, my lord.
No, he wants time 1 week.
Yes, my lord, it may be
Yes, at the
granted.
request of appellant, leave this matter next week.
58, please, my lords.
Page number 18, serial number 56 to 58.
58,
Hmm.
maybe not press for dismiss as not press because mandamus as called for as for has been granted by another court in the same connected matter. Maybe dismiss as not press.
Yadurna,
58.
now that you are withdrawing that writ petition itself.
Yes, yes.
What is that recalling?
Recalling
You
that
file in a memo,
memo,
for withdrawing that.
maybe
will recall
dismiss
and
as
with-
not press. Yes.
Yes, memo could be dismissed.
But this one.
IA 1 of 2022, recalling what?
Yes, dismiss for default agittu.
Matter reach ada kodi. Yes, we'll pass an order when the matter is.
Please, please.
Page number 19.
60,
59 to 62.
60,
Arvat-
Arvata? Yes, you get the records? Yes. Yes, at the request of counsel for parties, leave this matter next week.
Serial number 59, my lord.
Date may be given, my lord.
No, when you are getting records,
But one thing, not delay is there.
now that,
Writ petition.
then you have to wait for that constitutional validity matter. That is 28th ಇದೆ. Let us say after 2 weeks,
13th ಹೋಗಿದೆ.
Huh?
13th ಗೆ.
1/3.
1/3.
then-
Then get in.
13th September. Why? The matter was not heard on that day. Yes, then leave this matter after 3 weeks.
Malash, 49, Malash. Serial number 49. 2 weeks, Malash.
49.
49, wait, mister. We have, yes.
Page number 20, serial number 63 to 68.
Serial number 63, my lord.
Hmm.
Matter may be taken up next week, my lordship. And
Yes, have you informed other side?
I will inform my lordship.
Yes, at the request of counsel for the appellant. Leave this matter next week.
Please.
Page number 21, serial number 69 and 70.
Serial number 11. For respondent, petitioner objections file ಮಾಡೋ ಇವತ್ತು ರೆಡಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ.
ಅವ್ರು ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ next week.
Page number 1 for preliminary hearing, serial number 1, Sappannanavar Basavaraj for petitioner.
Appear for petitioner, my lord, kindly pass over, my lord.
Yes.
Petitioner, my lord, kindly pass over, my lord.
Password.
Serial number 2, C Shankar Reddy for petitioner.
Yes, Shankar Reddy. Password.
Serial number 3, H Mohan Kumar for petitioner.
What is that annexure D?
Annexure D is the order made by the Assistant Commissioner.
Hmm.
I have not been able to obtain certified copy. It's dispensation ಕೇಳಿದ್ದೀನಿ.
IA 1 of 2024 is filed for dispensation of production of annexure D. You are challenging that annexure D.
Yes.
Production of annexure IA is allowed, production of annexure D is dispensed at present for a period of 4 weeks.
Please.
You furnish that certified copies. Yes.
Lord, this is the second round of writ petition before this honorable court. On remand, the Assistant
Grantor
Commissioner,
a purchaser.
ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, there is no transfer at all.
Yes.
But by misleading certain facts, the purported purchasers,
Hmm.
they got the khata changed in their name
Hmm.
and transferred to some other persons.
Yes.
Therefore, there is no transfer.
Yes.
That has not been observed by both the Assistant Commissioner
Then
As well as-
why you have approached the TSC then, if there is no transfer?
not the, by mistake, that was mentioned before the assistant commissioner that there was a transfer. But on perusal of certain records,
Yes.
more particularly the encumbrance certificate which I have produced at page 20 annexure B. ಇದರಲ್ಲಿ ನಮೂನೆ 16ರಲ್ಲಿ ಕೊಡ್ತಾರೆ ಯಾವ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ನಡೆದಿಲ್ಲ 1960 ಇಂದ 1985 ವರೆಗೆ ಅಂತ.
According to you, when you have sold that property?
67ರಲ್ಲಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ನಾನು ತಗೊಂಡಿದ್ದೀನಿ 67ರಲ್ಲಿ ಅಂತ. ಬಟ್ ಇದರಲ್ಲಿ ಇಸಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿಗೆ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ಯಾವ
See, now
sale
you are
ಇಲ್ಲ.
saying that respondent has purchased this property from X.
Yes.
X has said that you have sold it to him. Has they produced that any sale deed that
No,
grantee
they
has
have
sold that?
not produced sale deed either before the assistant commissioner or before the deputy commissioner.
What is that AC and DC held?
ಅದರಲ್ಲಿ ಅವರು 67ರಲ್ಲಿ ಸೇಲ್ ಆಗಿದೆ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. But no sale is forthcoming.
No, even assuming that there is a sale, is there any violation?
Yes.
What is
No
the
violation.
date of the grant?
Date of grant is on
1955.
2055.
55.
According to
And
the
payment.
TSC, what is the date of sale?
Sale is 3667.
67.
ಹೌದು.
Yes.
67 ಅಲ್ಲಿ ಸೇಲ್ ಆಗಿದೆ. Well within the prohibitory period.
Yes, heard. Issue notice. Government advocate is directed to take notice for respondent number 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate. Issue emergent notice to respondent number 3 to 16. Yes.
Bill number 4,
Obliged.
Vemarati as per petitioner.
Yes, Vemarati. Yes.
Serial number. Admission matter, serial number 5, Prithvin Prahalad for petitioner.
If I seek for a week's accommodation in this matter, Lordship.
Yes, they want week's time. At the request of counsel for the petitioner, leaves this matter next week.
Grateful, Lordship.
Serial number 6, Ajit A. Shetty for petitioner, Bimbadar M. Gaudar.
I appear for the
And
response.
for the petition.
Yes, mister.
ಇದರಲ್ಲಿ that petitioner is residing in Udupi, depend on her old age parents. That's why we are filing in the city for transfer the case. Petition. My husband, the respondent has filed a petition of conjugal rights in Bangalore. He is residing here.
Bangalore.
Yes.
Has she filed any case?
In Udupi is there
What is that case she has filed?
for divorce.
Wife has filed divorce.
Yes.
Which is that case?
MC number 49 of
49
2020, my lords.
49 of
2020,
20.
which was already dismissed, my lords.
dismissed for what?
My lords, on merits.
Merits.
Please, my lords, cruelty has not been proved. And my lords, she has filed one more false dowry harassment case, my lords, in CC number.
But that has been tried in that Udupi only.
Please, my lords.
Yes.
Then, now that your restitution of conjugal right, is there any issues due to marriage?
Please, my lord.
Yes.
A daughter,
Is there, a daughter is there.
What is the age?
around 7 years,
7.
It is with whom?
with the mother.
Mother.
Then there is an
My
income.
lords, absolutely, my lords, I don't have any other issues, but my lords may kindly come to document number 1, my lords, of my statement of objections. My lords may kindly see it is a complaint, my lords.
No, your statement of objection is not there.
My lords, I have filed statement of objections. It is filed on 19/8/2024, my lord. (19/8/24) I have.
Yes, we'll pass it over. We'll get that from the
Please, ma'am. Or else, my lords may kindly have this matter by day after tomorrow, ma'am.
Yes, next week. Yes, leave this matter next week.
Problem.
Case number 7, Bagoji Vijay Kumar for petitioner, Rupesha B, D.R. Sridhar.
And for the petitioner,
ಆಗಿದೆ
Matter settle
settlement
ಆಗಿದೆ,
ಆಗಿದೆ
settlement
ಬಂದಿದ್ದಾರೆ.
ಹುಡುಗಿ ಹೋಗಿದ್ದಾಳೆ, ಗಂಡ ಮನೆಗೆ ಹೋಗಿದ್ದಾಳೆ.
ಕರೆಸ್ತೀನಿ ಅಂತಂದಿದ್ರು.
Withdraw that.
ಅದಕ್ಕೆ ಅದನ್ನ ಅವ್ರು ವಿತ್ಡ್ರಾ
ಅದು
ಮಾಡ್ಕೊತಾರೆ.
withdraw ಮಾಡ್ತಾರೆ.
ಇಲ್ಲಿ
Dispose
ಮೇ
ಮಾಡ್ತಾರೆ.
ಬಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್.
No, they are withdrawing that.
ಹಾ, ಬಿಟ್ಟು.
ದೇ ವಿಲ್ ವಿತ್ಡ್ರಾ.
Now you withdraw the CP also. Why that CP?
ಅದಕ್ಕೆ
Yes.
ಅವರು
Learned counsel for the party submits that parties have settled a matter out of court. Hence he has filed a memo for withdrawing this CP. Memo is taken on record. The above CP is dismissed as withdrawn. ಆಯ್ತು ಬಿಡಿ, ಅವ್ರೇನ್ ಬೇಡ, ಸೆಟ್ಲ್ ನಿಮ್ಮಿಂದ ಮಾಡಿದಾರಲ್ಲ,
ತಂದಿದ್ದಾರೆ.
ಒಪ್ಕೊಂಡಿದಾರಲ್ಲ, ಆಯ್ತು.
both the parties are present.
ಏನ್ ಹೊಟ್ಟೆ ಇರೋದಕ್ಕೆ ಒಪ್ಕೊಂಡಿದಾರ? ಆಯ್ತಪ್ಪ, ಒಳ್ಳೇದಾಗ್ಲಿ, ಯಾರು ಚೆನ್ನಾಗಿರಿ. ಓಕೆ ಓಕೆ, ಮಗು ಇದೆ, ಚೆನ್ನಾಗಿರಿ. ಓಕೆ. ಮೇಡಮ್ ಮೆಮೊ ಕೊಟ್ಟಿರಿ, ಮೆಮೊ ತಗೊಂಡು ಪ್ರೊಸೆಸ್.
Serial number 8, Raj Prabhu S for petitioner, Yog Erale E, Nishant SK.
Yes, mister. Yes. Learned counsel for the petitioner has filed a memo dated 28/8/2024 seeking leave of this court to withdraw this writ petition. Memo dated 28/8/24 is taken on record. The above petition is dismissed as not trust.
Serial number 9, Kanta Rajappa MD for petitioner, Iremated Maheshaya.
For petition, wife petition, my lord. The transfer Davangere to Chitradurga, my lord.
Where is your friend?
The respondent,
Once password
and next week,
next week.
kindly interim order may be extended.
None appear for the respondent. At the request of counsel for the petitioner, leave this matter next week. Interim order granted earlier is extended till next date of hearing.
Please.
Serial number 10, Avani Chokshi for petitioner, V.D. Raviraj.
I appear for the petitioner in this matter, your lords. Under section 24, I have approached this court with a prayer to transfer the OS from Chikmagaluru to that of any court in Mysore, your lord.
Where is that your opponent?
They are on record, your lords, but they have not been appearing, your lords. Tumba dinadinda avaru bartilla.
Password. Yes.
Serial number 11, adjourned. Serial number 12, Sharanadeep for petitioner, Pragya Shetty K.
Appearing for respondent, my lord. On last occasion, this honorable court directed them to produce a file affidavit with respect to she is not working, resigned and.
Appealing for petitioner, my lordship. Kindly praying for 1 week. I'm getting the instructions from the client itself. So,
Yes, at the request, counsel for the petitioner, leave this matter next week. Yes.
much obliged. my lordship.
Serial number 13, Hemant Kumar GM for petitioner, Rattihalli Geeta.
We're filing objection.
Yes, madam.
I am filing my objection
Objection.
and also medical reports and reportable judgment from this
Have you served the copy?
serving you.
File it in that office. Yes,
My
The
lord, I'm
request of-
praying for adjournment, my lord,
yes.
for 1
At
week.
the
and
request of parties, leave this matter next week.
Lordship, kindly have it on 16th, your lordship,
Which 16th?
and next month 16th.
My lord,
September is holiday, madam.
And Any working day.
In
of,
this
after
month
16th,
only you
your
can
lordship.
give.
17th, your lordship,
Yes, 18th.
much obliged.
Yes,
in
interim order
this month
granted.
only you can,
Huh?
in time order extend agreement, my lord. This month only you can give it.
Sit with her.
This month you are not ready today. You are ready now.
No, senior is not this.
Then you are not ready, then she wants that next week as she has problem. Yes, 18th. Interim order granted earlier is extended till next date of hearing.
Serial number 14, adjourned. Serial number 15, K. Srihari for petitioner, Rangaramu V.
The petitioner, my lord.
Yes,
It's a transfer petition, my lord. Seeking transfer from Bangalore to Mangalore, my lord. And the petitioner is residing in Mangalore, my lord, in her parental house, my lord. And the respondent husband has filed the MC number 2713 of 24 before the principal judge, family court, Bangalore. The distance between the places.
that he has filed for divorce.
Yes, my lord.
Has she filed any case?
No, my lord. There is not.
Any issue due to marriage? ಮಗು ಏನಾರು ಇದೆಯಾ?
Yes, 4 years child, my lord, girl child.
4 years child. She has not filed any case.
No, my lord. She has not filed any case.
What is that husband is doing? Is working here.
Private work, man.
He is
Yes.
working in private company.
What is that? She is working
She is not working. She is with
near higher primary school.
Yes,
She is residing with the parents.
parents.
Father is not there, mother is there. Mother and sister are there in Mangalore, but they are originally resident of
Original resident of
Yes.
Originally, they are from North Karnataka. Purposely, they want to residing at Mangalore, my lord. Instead of
Who?
that,
No, they are residing in Mangalore.
yes,
please, man.
What is the distance between Bangalore to Mangalore?
more than 350 kilometers.
Huh?
More
350.
350 kilometers.
Then, mister, it is inconvenience for her.
Can come, man. I am ready to pay the expenses.
No, they are not for expenses.
Where the
Inconvenience because there is no male members, that 4 years child is there. It's difficult for her to travel.
My objection may be kindly considered, man. I have filed the objection.
What is your contention?
The
I didn't get
contention
any
is
copies
that
of
they are,
objection.
having sufficient means to for there,
Hmm.
need not worry about anything.
Hmm.
She don't want to come to join with the husband. The husband has to join the wife. That is the intention of the
All
response.
that is the merit, it will decided by the court. Now that inconvenience is concerned, they are not on the ground of, financial difficulties. Their case is that inconvenience because distance and that.
Distance is more than 350 kilometers, my lord.
Yes, what is the stage now?
No,
Then issue notice.
notice is
Notice.
notice stage. Yeah,
Notice
they have to
stage.
appear before the court in Bangalore.
Yes, now I can say that dispose of within 6 months
Please,
Please.
in Mangalore.
Mangalore.
Yes.
Principal family court, Mangalore.
So and so learned counsel appearing for the petitioner wife has contended that after the matrimonial dispute, she is residing with her mother with her 4 years old daughter,
Yes.
except 4 years, there is no male members to accompany her to come to Bangalore for prosecuting the case filed by the husband in family court Bangalore for divorce. From Mangalore to Bangalore, it's about 350 kilometers. Hence, he sought for allowing that CP. So and so learned counsel appearing for the husband has contended that the respondent is working in private company. He will not get any leave to go to Mangalore for prosecuting the case.
also he is paying maintenance for the child also.
He further contended that
Has been paying the maintenance for the child.
the respondent is paying the maintenance to the child. There is no financial difficulty for the petitioner to come to Bangalore for prosecuting the case. Hence, he sought for dismissal of the civil petition. Heard the learned counsel for the parties. Peruse civil petition papers. It is not in dispute. Petitioner is the legally wedded wife of respondent. Their marriage was solemnized on 28/4/2019. Due to wedlock, the female child was born. Now she is aged about 4 years. After the matrimonial dispute, petitioner residing with her mother. Her father is no more.
Father is,
He is there. He said no more.
oh,
Father
sorry,
is
sir.
not there.
ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಲ್ರಿ?
Sorry.
Father is not there.
Yes. Father is no more. There is no male members to accompany her to come to Bangalore for prosecuting the case.
Her brother, sister husband is working at bank, my lord.
Husband ಅವ್ರನ್ನೆಲ್ಲ trust ಮಾಡ್ಕೊಂಡು ಬರಕ್ ಆಗೋದಿಲ್ಲ. Yes. From Mangalore to Bangalore, it's about 350 kilometers. It is inconvenience for her to come to Bangalore along with that 4 years old daughter to prosecute the case. Considering that inconvenience made out by the petitioner and considering the judgment of this court, the civil petition is required to be allowed. Accordingly, CP is allowed. MC number 2713 of 2024, pending on the file of third additional principal judge, Family Court, Bangalore, is withdrawn.
Sixth additional. Sixth.
ಎಲ್ಲಿ?
Bangalore.
Fourth ಅಂತ ಬರ್ದಿದ್ದೀರಾ ಮತ್ತೆ?
Sixth additional. Sixth additional.
Notice is there, along with the notice there.
ಯಾವ್ದ್ರಲ್ಲಿ?
Page number 19, my lord. Annexure.
ಆಯ್ತ್ರಿ, ನಿಮ್ ಪ್ರೇಯರ್ ನೋಡ್ರಿ.
Prayer may be
5th ಗೂ
wrong.
6th ಗೂ ಹೆಂಗ್ ಬರೆಯೋದು ಗೊತ್ತಾ ನಿಮಗೆ?
Prayer may be wrong, my lord.
ಯಾವ್ದು 5th 6th?
Sixth.
6th. On the file of 6th additional judge, Family Court, Bangalore, is withdrawn. Same is transferred to Principal Family Court at Mangalore. It is also the Family Court, Mangalore, is directed to dispose of that MC petition as expeditiously as possible, not later than 6 months from date of receipt of that papers. Receipt of the file.
Serial number 16, Vijay Shetty B for petitioner.
I appear for the respondent in all the three cases.
Yes.
Madam, this is a case filed by the wife. Madam,
My lord, it was in Mysore, 3 petitions, my lord.
Yes.
The first one petition, my lord, that is filed by the petitioner herein, petitioner is the wife, my lord. It is for divorce. And the second petition, my lord, that is filed by the child, 8 years, my lord, the female child, for the maintenance, my lord. And the third petition, my lord, that is filed by the husband. Again, this respondent for GNWC
First
petition.
petition. You
The
are seeking-
204, my lord, 204.
No, 288.
288 is the GNWC petition filed by the respondent, my lord.
GNWC na?
Yes,
ಎಲ್ ಫೈಲ್ ಮಾಡಿರೋದು?
Mysore,
ಮೈಸೂರ್.
Mysore.
23 of 24.
Yes.
Now child is with you,
Child is with me, my lord.
residing in Hubli.
Now Hubli.
Yes.
But the
Second matter,
second matter, that is the
204.
204 is filed by the child, my lord, maintenance. In Mysore only. For maintenance.
Mysore.
Oh,
Now that, why you have filed it in Mysore? Who has filed this?
this, actually, this first petition is 204, my lord.
The first petition,
First petition is
CP 288 of 2024.
that is latest, my lord. That is the third,
Latest to
third
oldest
petition.
ಬೇಡ, ಕೇಳಿದಕ್ಕೆ ಹೇಳಿ ಅಷ್ಟೇ.
please.
CP 288 of 2024, GNWC transfer ಕೇಳಿದಿರಾ?
Oh,
GNWC is filed by that husband
filed by the husband,
in Mysore.
Mysore, my lord.
Second case ಅಲ್ಲಿ 204 of 2024.
That is filed by the child, my lord, in Mysore for maintenance.
Now which is the case you want to transfer?
That is the criminal miscellaneous case, which is
Criminal
filed by her
Criminal miscellaneous filed by that
child
in Mysore.
in Mysore, my lord.
Why you have filed it in Mysore?
Because I was there on Mysore.
At that time?
At that time I was there in the Mysore.
Now you want to transfer because
Yes.
you have shifted to
Yes,
Hubli.
yes, yes.
Criminal miscellaneous
Criminal miscellaneous 1051, my lord,
1051 of
of 2022.
22. Wife, child maintenance. Yes, what is that more? Third one?
Third one is, my lord, that is filed by the wife for divorce. That is in MC number 532 of 2021 before Family Court at Mysore.
MC number
532 of 21.
21.
Yes.
When you have shifted to Hubli?
That is, my lord, 3 months, it is 3-4 months agide. Your
Why
lordship,
you came to Hubli?
yes, my lord, the annexure, my lord, in the third matter, that is 288, your lordship may kindly see. Annexure H, my lord.
Page.
Page annexure G, my lord, at page number, relevant pair number 76.
Yes.
This is the, my lord, this is the child's petition, my lord. Para number 13, my lord, I'll read the order. The petitioners prayed for interim maintenance of rupees 30,000 per month. The facts and circumstances of the case show that the interim maintenance claimed by the petitioner is excessive. The respondent and mother of the petitioner, being highly qualified couple belonging to well-settled families, required to contribute to the maintenance of the petitioner. Considering financial and social status of the respondent and mother of the petitioner, this court opines that the petitioner requires minimum of 15,000 per month for her expenses towards food, shelter, cloth, medicine, education, etc. The respondent, being the father, requires to contribute to the extent of 50% of the expense of the petitioner. Under these circumstances, this court opines that it is just and necessary to direct the respondent to pay rupees 7,500 per month to the petitioner as interim maintenance for her expenses towards food, shelter, cloth, medicine, education, etc. For these reasons, the above point, the answer partly affirmative. I pass the following. IA number 2 filed under section 125(1) of CRPC is allowed partly. The respondent is directed to pay rupees 7,500 per month to the petitioner as interim maintenance for the expenses towards food, shelter, cloth, medicine, etc. My lord, this is the part, the 50% amount has to be paid by this petitioner. My lord, petitioner was not having any job. My lord, she is the native of this Hubballi. And my lord, next document is annexure H.
She was residing in Mysore with.
ಇಲ್ಲ ಇದ್ರು 2020 ಅಲ್ಲಿ this MC petition filed by this petitioner. 2020, my lord, their visitation right has been given to the respondent.
Till she comes to Hubli. She was
in Mysore only.
With that Mysore with whom?
With the father, my lord.
Father.
There is a house in that the first floor has been given for rent, and only for the sake of this after marriage, they are residing there.
No, your father is in Mysore.
Presently, both of them have shifted.
Earlier he was.
Earlier they were there. My lord,
what was he doing?
my lord, he was retired, my lord. He was retired. Now, my lord, 2020, when the petition has been filed, my lord, that time they were there. That time, my lord, 2022, visitation right has been given to the respondent, my lord. Visitation right, my lord, the petitioner has to drop the child in the house of the respondent, and he has to give it back. My lord, this was it has run for almost 2.5 years, my lord. My lord, since she is not having job, and she has also to earn as per the order of the honorable court, and she doesn't have any job, and it is her native place, and the properties and everything is there only. She has shifted there, and this fact has been informed to the honorable court also, saying that this is the thing, I got the job. My lord, it has been communicated to the respondent also. My lord, now the situation has been changed because she has to earn for her livelihood, and there is no maintenance for her.
What is she doing in Hubli?
Hubli, my lord, the annexure H, my lord, that the document, she is working as now, she got the job at computer lecturer cum lab assistant at DG Shetty Education Society at Hubli.
Where is that annexure?
Annexure H, my lord.
H.
H. Annexure J, my lord, that is shifting of the joining of the child to the school there, my lord.
School in Hubli.
ಹೌದು. 2024-25, it is was standard fourth standard.
That annexure H, this is
H, my lord, is
appointment
the
letter.
appointment letter, my lord.
Now he has
Got the appointment in Hubballi.
You were appointed as what?
Appointed as computer lecturer cum lab assistant.
What is her qualification?
Qualification, my lord, she is highly qualified ಅಂತ ಇದೆ, but
Highly qualified ಅಂತಂದ್ರೆ ಏನು? It's different. Yes.
ಎಲ್ಲ certain.
Now that child is also.
Child is also got admitted in Hubballi, my lord. Child 8 ವರ್ಷ, 8.5. Annexure J, my lord, this
Yes.
Sakare English medium school, it is.
Yes,
child
madam.
admission.
May I submit, Miller?
Yes.
The wife filed a case for divorce.
Yes.
At the time of filing of the divorce, she was in Mysore.
Yes.
She wants her own case to be transferred. Miller,
Yes.
there is no case decided on this. Whether a petitioner who had herself filed, whether she can seek for transfer. That's a matter to be decided by your lordship. So far, the husband had filed.
I think it is maintainable.
Yes, Miller?
No, I think she can also file her case to transfer on subsequent events.
I am asking your lordship to decide that, because a person who had filed a case, here is a case, her evidence is over. Everything is over. That only the husband is to be cross-examined. That is the stage at which the case is now she wants to transfer. If
No,
this
now
is allowed, I'll submit my right. This is allowed. Today she is in Hubli. Tomorrow she will go to Delhi. Then say I am transferred. I'm taking the job transfer. Whether in a case where everything is over, the examination of the wife
No,
is over.
wait, madam. No, that wife's evidence is over.
Yes, my lord. And everything is only my evidence is over. Only
I
thing remaining is
Wait, madam. Wait. See, in the MC case filed by that wife for divorce, her
Yes.
evidence is over.
Yes, my lord.
What about that in another case which is filed by you?
My lord,
GNWC?
I'll come to that later. I'll come to, because that is covered by Supreme Court judgment Ruchi Matthew. Supreme
No,
Court
now
has
that-
said, my lord,
Wait,
where
now that Mr. Shetty,
Please.
in that matrimonial case,
Yes.
your evidence is over.
Cross-examination over, there are two IAs pending in first case. And child's case.
IA and all that
Yes,
presence
yes,
of the
yes,
party
yes,
is not
yes,
necessary.
yes. In MC,
Whenever that party's presence necessary, we have to
Yes.
see that inconvenience, she can't travel and all.
yes.
Otherwise, advocate is there, they will take care of. in
Cross-examination PW1 was over in that case.
Hmm.
Second case, my lord, it is evidence has not come in. Third case, my lord,
One
we'll
by
go
one.
yes,
one by
yes.
one, my
MC.
lord.
yes, yes,
MC is concerned,
yes.
Yes.
now that your party is over, only that petition,
Chief ಆಗಿದೆ ಇದು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ
ಯಾರ್ದು?
ಇವರು
Wife ದು.
ನಮ್ದು
ನಿಮ್ದು ಎವಿಡೆನ್ಸ್ ಆಗಿದೆಯಲ್ಲ?
ಹೌದು
Then your
Over.
presence is not necessary now.
ಅದೇ ಇನ್ನು ಇದು ಎವಿಡೆನ್ಸ್ ಐ ಇದೆ ಇನ್ ವಿಟ್ನೆಸ್ ಬರ್ಬೇಕಾ ಅನ್ನೋದ್ರ ಬಗ್ಗೆನೇ ಇನ್ನು
ಯಾರು ವಿಟ್ನೆಸ್ ಬರ್ಬೇಕ?
ಅಲ್ಲ ವಿಟ್ನೆಸ್ ಎವಿಡೆನ್ಸ್
I
ಇರ್ಬೋದು
again
ಅನ್ನೋ
witness.
ಗೊತ್ತಿಲ್ಲ
See, your
But-
convenience for that parties has to be seen under section 24.
yes.
In MC petition is concerned, if it is transferred, it is inconvenience for the husband because he has to
Yes.
give an evidence, he has to do this thing.
In
Then-
first case it is over.
In MC petition is concerned,
Yes,
I think there is no inconvenience at all.
Yes.
Now that, which is that MC, that is serial number 3,
second 204 my lord
205 ಇರ್ಬೇಕು.
ಅಲ್ಲ
205
is wife's petition my lord.
Huh?
205 is wife's petition.
205 is wife petition.
Also
That is for matrimony, the divorce.
divorce
In that case only, your evidence is over.
over.
Now that there is no inconvenience for you and that 205.
Yes.
204 is that criminal miscellaneous filed by that.
There are also order is over. Interim
Illa.
order is passed and they
Alla,
have
your
to pay
Lordship,
maintenance.
kindly see
that's all.
page number 29 in the order sheet, that page number 29.
Now that criminal miscellaneous, what is the stage
10,
now?
1050, ಅದು cross ಗಿದೆ some.
There also her evidence is over.
Wait, madam, I am, yes.
Your
What is
Lordship,
the-
kindly see page number
10 yes.
29, further chief ಅಂತ ಇದೆ some.
ಕೊಡ್ರಿ, ಎರಡನೇ ಮ್ಯಾಟರ್ ಕೊಡ್ರಿ. ಯಾರ್ದು ಚೀಫ್ ಫರ್ದರ್?
ನಾವು ಮಾಡ್ಬೇಕು.
ನಿಮ್ದು ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ಚೀಫ್ ಎಕ್ಸಾಮ್ ಅಫಿಡೇವಿಟ್ ಹಾಕಿದ್ದಾರೆ, ಫರ್ದರ್ ಮಾರ್ಕಿಂಗ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಮಾರ್ಕಿಂಗ್ ಡೆಫರ್ ಆಗಿದೆ. Your Lordship, kindly see at page number 29 in the second petition.
Second,
204.
Yes, madam, in second petition, what is the stage?
My lord, the question is, she is asking for the maintenance for the child under section 125. My lord, the case regarding the child concerned, my lord, in Ruchi Matthew's case in Supreme Court, this case and the next case, guardianship case, court has said wherever the child is ordinarily residing, only that court has the jurisdiction and no other court. So, my lord, that is what has been decided, my lord, 2011 6
No,
SC.
that is in GNWC.
Yes, my lord,
for-
if the GNWC, has to be decided. GNWC only they can ask for maintenance.
No,
It is not
GNWC
the-
is concerned where the child is residing, there it
Yes.
has to be filed.
Yes, and I have filed in Mysore, and because to prevent me, there was an order for visitation.
No, now
right?
that Mr. Shetty,
Please.
you see the judgment. What is that? See, cause of action to file in a GNWC where the child is there.
Please.
Subsequently, it is shifted.
Please.
Can be seek for a transfer. Any judgment on that point?
I'll ascertain that, my lord. That is one.
Find out. One. Second is that now that your MC petition, now there is no, now that only main thing is that in respect of GNWC,
GNWC.
you find out the judgment and the.
Yes, my lord, one submission. My lord, here
What?
the second case, that child case, my lord, that is posted for the cross-examination of PW1. For that, almost 4 to 5 hearings over. But third case, because shifting of one case may not be, because when the cross-examination stage is one case, in the GNWC, it is in the stage of notice services, I have filed the wakalat.
Come to one by one.
Please.
See, no purpose will serve if you transfer MC petition to that Mysore. Mysore to Hubli,
Yeah.
because your evidence is over.
ಆಯ್ತು.
Now it is the work of the lawyer.
ಆಯ್ತು.
See, if there is two cases, if has to be clubbed together, otherwise contrary judgment is coming, that
Oh.
can be considered.
Oh.
But here, diverse maintenance, it's in a different.
ಅಲ್ಲ
It will
ಹೌದು
not-
ಡಿಫರೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ ಬಟ್ ನಡೆಸಬೇಕಾದ್ರೆ ಈಗ ಇವರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸ್ವಾಮಿ ದೆನ್
No.
ಶಿ ಹ್ಯಾಸ್ ಟು ಅಗೇನ್ ಕಮ್ ಟು Mysuru in this case
No,
and
now
MC
that-
case
now-
also.
See, criminal
traveling-
miscellaneous is concerned, we'll see now only thing is that GNWC. GNWC, when they have filed, child was in Mysore,
Yes,
now it has come. Now what is the law on that point? You have to.
yes,
address.
yes. One submission in regarding this matter. In the child's case, it is for the cross examination. For that, she has to come, and this is the difficulties. And for GNWC matter, as per this one, GNWC matter, it is at the stage of the objections main.
Still, if you convince that, that
Yes, yes.
case will be transferred.
Yes, yes, yes,
That case will be transferred. Wait, first we have to convince.
yes.
See whether GNWC can be transferred.
Marad, it is all subsequent development because Marad, as on, yes, yes, I'll go,
Put the judgment and convince. That is what that she
Yes.
is arguing. Second case is that she said, even MC case also find out whether your own case you can seek for a transfer.
Definitely, Marad, because Marad, this
I
change
agree,
of circumstance,
definitely.
I'll submit by virtue of this, please.
It is court, you can't say that.
I'll-
Yes. When do you want?
In the fifth, sixth, again.
Yes.
Only one. Only
Yes,
one
madam.
submission. What has happened, my lord? There is no transfer order by your lordship. But the trial court says they closed the case. They've written already transferred. Man, I was shocked when I go there. I do not know how the court could write already transferred.
No, that is
Then
for
your
the
lordship
lawyers
must-
to convince the court. I can't
No,
say them
not
that.
the lawyers, my lord. Court has written already transferred, even though there is no transfer. God is it shows that it's transferred.
We have produced the order
And
sheet
I
in the
brought
court.
it in
Madam.
notice of the
We
court.
have produced the
And-
order sheet of this honorable court. Court can very well read it and
No,
read it
no,
also.
Yes.
my lord, we have lodged a complaint already, and we go there. Visitation right is there. Court
Can
says
transfer ಅಂತ
already
ಬರ್ದಿದ್ದಾರೆ.
transferred.
ಇಲ್ಲ ಇಲ್ಲಪ್ಪ ಇಲ್ಲಿ
Something-
ಸ್ವಾಮಿ ತಾವು
something
ಮಾಡಿರೋ
wrong
ಆರ್ಡರ್
in
ಆಸ್ ಇಟ್
the-
ಇಸ್ ತಗೊಂಡೋಗಿ ಕೊಟ್ಟಿದ್ದೀವಿ.
Your lordship asked registrar to verify. I am only
No.
requesting your lordship.
Now, what is that you want to make? The court has transferred the case.
Yes, the court, the trial court says already transferred, you go to Dharwad.
Now that, where is that? You produce that order sheet.
Well, I have already lodged a complaint, my lord, in writing, I have given already in writing.
Where is that?
Well, I have the copy, my lord, written copy.
Where is your instructing counsel?
Well, my instructing counsel is here only, but she.
You, that, if that is the case, you produce the
Yes.
order sheet and ask
I'll
her
do
to
it,
be.
I'll do it, well. I'll do it, well.
furnish. Next date of hearing, you furnish
Yes,
that.
yes, sir, well, I'll do it.
If it is, no, if that is anything contrary to that order of this
Yes.
court, we'll see that what we have to
Yeah,
be. Yes,
grateful to your lordship.
yes.
Please.
Is this matter on 10th? Yes.
Serial number 17, Shantaraj K for appellant. O Mahesh.
Appellate.
Yes, Mr.
Driver is a tractor and trailer driver, my lord. And accident is of the year 2013. The MSCT is a commissioner has taken income at rupees 6,000 per month.
Yes.
And the disability has been stated by Dr. PW2. Permanent disability of 55% and 18% to whole body. Since he was a driver, 55% permanent disability ought to have been taken. And MSCT has taken the disability at 12%. There are 15 of the judgment.
What are the injuries?
Injuries, fracture of petitioner. Doctor evidence. Fracture of right femur with Implant in situ.
Yes.
Right leg and right ankle, right knee joint, right hip joint, right foot and right elbow. TCR ಇದೆಯಾ ಇದು? TCR ಇದೆ. Doctor evidence, last guy.
Injury, fracture, complicated disabilities assessment ಅಂತಾರೆ. Shifting, restricted pain movement, weakness, right leg, so on. So total soft tissue injuries, fractures, I have treated the patient. Individual joint problem, physical disabilities, fracture of lateral candula, right tibia, causing blood right knee, chest, so on. So
ಫೋಟೋನ ತಕೊಂತ ನೋಡಪ್ಪ.
yes. ಫೋಟೋ ತಕೊಳ್ಳೋದ? ಅದು ಫೋಟೋ ತಕೊಂತಾರೆ. Yes.
Interest 9% ಕೊಟ್ಟಿದ್ದಾರೆ from the date of petition.
ಅದು 12% ಅಲ್ವಾ?
12% from the date of 1 month from the date of accident.
2013 8,000
8,000.
But claimed is only 6,000. It can't be more than that.
No, but act says minimum is 8,000.
No, my lord, you have a kind.
Minimum 8,000.
No, that is what the tax says.
No, my lord, maximum has to be, my lord, if it exceeds 8,000, my lord, 8,000. Now what he has claimed is 6,000. Yoshma, kindly look into, he is pleading.
Yes.
He can't now breathe hot and cold. He has claimed 6,000, 6,000 has been taken.
Where is that pleading? Workman compensation.
Para 4, my lord, of the judgment.
No, 6,000 ಸಂಬಳ ಮತ್ತು ದಿನಕ್ಕೆ 50 ರೂಪಾಯಿ ದಿನ ಭತ್ಯೆ ಕೊಡುತ್ತಿದ್ದರು. ಸಂಬಳ 6,000 ಜೊತೆಗೆ this is also there.
Like
that is evidence.
Not examine the, my lord, the employer.
Therefore, now we have to go for a minimum wages. If he is not examined, yes.
Yes, my lord, minimum wages.
Yes.
ಆಮೇಲೆ ಇಂಪ್ಲಾಂಟ್ಸ್ ರಿಮೂವಲ್ ಗೆ 40,000 ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್, ಅದೇನು ಕೊಟ್ಟಿಲ್ಲ.
And typed page 11, my lord, moreover, the petitioner had not produced any material before this court to say that there was a fracture of femur. The recital in the certificate only refers to fracture of tibia, right tibia and right knee.
Yes.
And para 15, not PW2, doctor says 18% whole body disability.
Yes.
Right, the disability is different. What is the loss of earning capacity, my lord, is different. He has to spell out what is the loss of earning capacity.
Yes.
And he said to be a driver, my lord. And
Yes.
his driving license has not been surrendered or cancelled.
Yes.
he continues to be, my lord, the driver. Exhibit P5 may kindly be looked into.
Yes,
And here not examined, my lord, the employer.
yes,
You want to prove, my lord, that he was paid 6,000 rupees per month.
yes. ಹೇಳಿ exhibit ಯಾವ್ದು?
Exhibit ಯಾವ್ದು sir, Maheshwara?
Exhibit P5 with the driving license. Evidence of PW2, my lord. You have not spoken to how this injury,
Yes,
to what percentage his earning capacity is reduced. And the
Yes.
driving license, my lord, is up to 29.
yes,
So there is no question of, my lord, only for this thing has to be given, but even what you have claimed is 6,000. If
Yes.
data is also included, my lord, it will be around 7,000. That's all.
yes,
It can't be 8,000. Employer is not examined. And there is no declaration, my lord, that the accident was due to the negligence of the other side, other vehicle.
No, all that is not there. Now that that has been accepted, you have not challenged. And regarding employer-employee relationship, everything is over. Only thing is that enhancement. We'll see. I will see that records and pass it on.
Bill.
Yes, third. Yes. What is that?
Expert.
Yes,
55% ಹೇಳಿದ್ದಾರೆ.
yes. Which is that judgment?
Somebody has told me.
Then you produce that, we'll have it next week. Yes. What is that substantial question of law? Hard. Possible right in taking 12% against the evidence of the doctor. Whether the commission right in awarding compensation 40,000. Council 12%. Whether the substantial question of law. How the substantial question of law arises for consideration. One though. 55.
Future prospects ತಗೋಬೇಕು ಅಂತ substantial question of law frame ಮಾಡಿದ್ದೀನಿ.
Yes.
There is no discrimination under Motor Vehicles Act. Future prospect has to be added.
Yes,
But
which is
why
that?
not this case?
Yes, Learned Commissioner want to try to take a disability 12% since the appellant was driver professions. Affects court in 1 to 3. Hard. Admit the substantial question of law arises for consideration 1 to 3. Yes.
We'll call next week, my darling.
Yes. Yes.
Hard and reserved, my lord?
Now we have admitted that.
Hey.
Yes.
Award ಬೇಕು ಅಂತ ಇರೋದು
Bill number 18.
Yes.
Suresh M. Lathur for appellant. Connected matter B. Pradeep.
And for appellant in this case.
Yes.
And we call for TCR, my lord, not stated matter.
Pradeep? They are also challenging on what ground?
Liability.
Yes, heard, admit.
Serial number 19, B. Palakshaya for appellant, S.V. Egde Malkon.
For the respondent, my lord.
Hmm.
My lord, this is a vehicle damage in respect of KSRTC. 20,000 has been given.
Now Palakshaya is, now that matter is pending before the division bench.
That I don't know, my lord.
Now that in respect of that damages is concerned by the KSRTC, I think somebody has told single judge has referred the matter to division bench.
My
Is
lord,
it, this
this
case
is
is
one-
also applicable? It is
This is
coming
what
under.
20,000 has been awarded.
Hmm.
So I don't think, my lord, any.
Where is Palakshaya? What is that they have claimed, Mr. Hegde?
My lord, this KSRTC appeal saying that, my lord, this vehicle was damaged and the grant of compensation is illegal. But my lord, the compensation granted is in respect of motorbike, my lord. So 20,000, my lord, he has produced a bill for 23,134. Mechanic has not been examined. But taking into consideration all these aspects, 20,000 has been awarded.
Their claim itself is 23,000.
The total, my lord, 23,134 is the in respect of repair charges. So the 20,000 has been awarded.
I thought, what is their ground in this appeal?
Ground says, my lord, this compensation awarded is excessive.
Compensation awarded?
Is excessive, my lord.
No, how can they say excessive?
Because the liability has been passed on the KSRTC, my lord.
20,000 along with the 9% is bad in law. Learned judge awarding.
And regarding contributory negligence,
Counsel
also,
failed to notice that driver has not rash and negligent driving was negotiation is course of route so and so finding a tribunal as bad in law and since spoke extra not property applied in case and there is
contributory negligence also.
learned judge has not order of the motorcycle without holding it.
We are only formal
No,
parties.
that, when you are paying that compensation, they are only paying that policy amount or entire amount will be bear by that case.
We are the formal parties. We are the insurer of the motorcycle. We are the insurer of motorcycle. And
Yes.
they claim against the KSRTC bus. KSRTC bus tax against the motorcycle.
No, but why they have filed it for 20,000?
20,000, I think, and then matter death claim. Well, Lord, that is more, I believe. So,
No, is there any appeal by that climate?
that I do not know, madam.
Then why the KSRTC has filed an appeal for this 20,000?
Because in the connected matter, they may be filed that regarding contributory negligence also they may be seeking.
Well, connected matter. There are other matter also there.
I do not know, my lord. That aspect I do not know.
Where is that Palakshaya? Pass over. Let him come. Otherwise, we'll dismiss it. What is this here? For
Yes,
20,000?
we are only formal party because we are insurer of the motorcycle.
Yes, let Palakshaya, you just inform him. We'll take at 2:30.
Yes, madam.
Yes.
Serial number 20, B. Pramod for appellant, E.I. Sanmati, Ravi Shankar.
No, it's a case of accident, my lords. 2016 is the date of accident, 28/5/2016. Lords, he's aged over 32 years. He has sustained various injuries, fracture, and he had surgery was done and POP was applied for 8 weeks, my lords. Lords will get the details of the injury, my lords, at page number 23 and 24, my lords. 23, my lords, para 24.
Yes.
Abrasions, fracture, my lords. And if my lord sees 24, my lords, fracture of upper
24. This MVC is 39 of 2017, huh?
Yes, my lords, 39 of 2000.
Yes.
ಹೌದು ಅದಾದ್ಮೇಲೆ POP ನು ಹಾಕಿದ್ದಾರೆ ಪೇಜ್ ನಂಬರ್ 28 ತಾವು ನೋಡಿದ್ರೆ
What is that evidence of doctor?
Doctor
Eglova injuries, left thigh swells, left leg, foot abrasion.
22% ಅಂತ ಹೇಳಿದ್ದಾರೆ 7% for the entire body it is taken.
Where is that discussion?
Page 26, my lords.
Yes.
Page 26, if my lords.
22% left lower limb,
ಹೌದು ಅದಕ್ಕೆ 1/3 ತಗೊಂಡಿದ್ದಾರೆ 7.
ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ ಅದು.
ಅದು ಐ ಆಮ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ my lord. Income if my lord sees it is taken as 7,000. Accident is of the year 2016 my lord.
ನೀವ್ ಎಷ್ಟು ಕ್ಲೈಮ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲಿ ಕ್ಲೇಮ್ ಮಾಡಿದ್ರೆ 22,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಬಟ್ he has not produced
There
any.
is no income proof.
2016 my lord, it should be 11,000 my lord.
2016 ಎಷ್ಟಿದೆ?
11,000
9,500.
plus 16 sir.
2016 9,500 mister.
Please me.
2017 11,000.
Please. It is 16 sir.
Yes. Now how many days you are in that hospital?
No, 6 days my lord. And POP was applied for 8 weeks my lords to his foot. My lords will get that page number 28 para 34. 8 ವಾರ POP ಹಾಕಿದ್ದಾರೆ.
Yes.
ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಬರೀ 2 ತಿಂಗಳು ತಗೊಂಡಿದ್ದಾರೆ.
Yes.
POP ಆಗಿ 8
Towards
ವಾರ.
convenience, nourishment, towards future earning capacity, future medical expenses, loss of income during the later period.
Laid up period, my lords, it has to be at least 4 months instead of 2 months.
Yes. Yes, madam, that's all.
My lords, pain and suffering may be increased by another 15,000.
Yes.
Disability is just and proper, my lords, as per the tribunal. And income may also be taken as per the Lok Adalat chart, that is 9,500, my lords.
Yes.
And as the learned counsel said, the laid up period may be slightly increased.
Yes. Loss of amenities. Interest is 9%. Yes, ತಗೊಳ್ಳಿ.
ಆಮೇಲೆ ಲಯಬಿಲಿಟಿ ಬಂದು 2 ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಇದೆ 50-50 ಆಗ್ಬೇಕು.
ಇನ್ನೊಂದು ಯಾರು ಇದ್ದಾರೆ?
R2 and R4.
ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟಿದೆ?
20 ಸರ್.
Yes, ಅದು ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ.
ಅಲ್ಲಾಗಿದೆ.
So and so learned counsel appearing for the claimant has contended that at the time of the accident he was earning 7,000 per month.
ಅಲ್ಲ 22 ಅಂತ ಹೇಳ್ತಾರೆ.
22,000 per month. Tribunal has assessed notional income of the claimant as 7,000 per month is on lower side. Secondly, he has contended that due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 6 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses are in lower side. Hence, he sought for enhancement of compensation. Per contra, so and so learned counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 22,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 7,000 per month. Secondly, she has contended that considering that evidence of doctor and injury suffered by the claimant and considering that medical records, compensation awarded by the tribunal, pain and suffering, loss of amenities, other incidental expenses, just and reasonable. The interest awarded by the tribunal, 9% is on higher side. Hence, she sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 28/5/2016 due to rash and negligent driving of driver of lorry bearing registration number KA 16 A893. Even though claimant has claimed that he was earning 22,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed on the basis of chart prepared by Karnataka Legal Service Authority for the accident occurred in 2016. Notional income has to be considered as 9,500. Tribunal has rightly assessed whole body disability is 7%. The multiplier applicable to that age group is 16. Accordingly, loss of future earning has been reassessed as follows.
9,500 into 12 into 16 into 7%, 1,27,680.
Due to that accident, claimant has suffered the above said injury, was inpatient for a period of 6 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 25,000 to 50,000. Loss of income during the later period has to be granted for 3 months. Loss of immunities has to be enhanced from 20,000 to 40,000. Enhanced compensation amount carries 6% interest. Both the insurance company has to deposit 50% each.
Yes, ma'am.
Serial number 21, D. Vijayakumar for appellant, Gururaj R. Serial number 21.
My lord, I am ready, my lord. Kindly call at 2:30, my lord. I am ready.
Your Lordship, another day, if not today.
You are appearing for?
Respondent, Your Lordship, the claimant.
Yes, at the request of counsel for the respondent. Please this matter next week. Inconvenience of Madhyana, yes.
Serial number 22, Gopal Krishna. N.
Pass
for
over, my lord.
appellant.
Kindly pass over, my lord.
Pass over. Yes.
Serial number 23, Marigauda for
2:30.
appellant, Sumangala S.
Yes.
Quantum sum.
Yes.
Global compensation has been awarded, my lord.
Well, a doctor has not been examined. Fracture of right dislocation, 75,000 has been awarded. ಅದರಲ್ಲಿ ಇವರು 20% ನಮಗೆ ಅಲ್ಲ ನಮಗೆ 20% ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ. ಮಾಡಿ 60,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. Lordship may kindly take in page 12, madam, issue number 2.
Yes.
Exhibit P7 is the outpatient slip. Exhibit P8 are the 20 medical bills of an amount of 18,470. P9 and 7 are prescription. P10 is the patient information report. Exhibit P11 is the MRI scam report. 12 is the patient information form. 13 is the progress record. The petitioner has not examined either the doctor who had treated him or the disability certificate to decide the magnitude of disability. Hence, the petitioner is entitled for 75,000 ಮಾಡಿ ಅದರಲ್ಲಿ 20 ಮಾಡಿ ಅಷ್ಟೇ ಸರ್. ಒಂದು ಮಂತ್ ಹೊಸಪತ್ತ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರು ಸರ್.
ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಸ್ಪಿಟಲ್
ಇದಿದೆ ಸರ್ ನಂಬರ್. ಹೊಸಪತ್ತ ಹಾಸ್ಪಿಟಲ್ ಇಲ್ಲಿದೆ ಸರ್, ಕೊಡಿ ಸರ್. ಇಲ್ಲ ಇದೆ
ಮೆಡಿಕಲ್ ಬಿಲ್ ಎಷ್ಟಿದೆ?
18,000 ಚಿಲ್ಡ್ರೆ. ಯಾವ್ದು ಸರ್ ಎಕ್ಸಿಬಿಟ್ಸ್ ಅಲ್ಲ, ಈ ಎಕ್ಸಿಬಿಟ್ಸ್ ಎಲ್ಲಿಂದ ಬರ್ತದೆ ಅಂದ್ರೆ P7 ಸ್ವಾಮಿ. Exhibit P7 to P16.
Where is that to show that you are admitted in the hospital for 1 month, mister?
ಅಲ್ಲ ಅದು ಇದರಲ್ಲಿ ಬರ್ತದೆ, 1 ವಾರದಲ್ಲಿ ಆಗಿದೆ. ಔಟ್ ಪೇಷಂಟ್ ನಲ್ಲಿ 1.7 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಔಟ್ ಪೇಷಂಟ್ ಡಿಫರೆಂಟ್. You said that you are an inpatient for period of 1 month.
ಅಲ್ಲ ಅದು ಅಷ್ಟೇ, ಔಟ್ ಪೇಷಂಟ್ ಅದರಲ್ಲಿ ಒಂದರಲ್ಲಿ ಅಷ್ಟೊಂದು.
ಆಯ್ತು ಮೇಡಮ್, ಎಷ್ಟು ಅನೌನ್ಸ್ ಮಾಡ್ಬೋದು?
ಗ್ಲೋಬಲ್ ಕಂಪನಿ ಏನು ಇದು ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೂಡ ಇದು
ಅದೇ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಮತ್ತೆ
You say how much?
only dislocation of the
ರೈಟ್ ಶೋಲ್ಡರ್
and tenderness and the swellings and
ಅದರಲ್ಲೂ 20% ತೆಗೆದುಬಿಟ್ಟಿದ್ರಲ್ಲ. ಆಯ್ತು, ಅದನ್ನ 75 ನ ವಿಲ್ ಮೇಕ್ ಇಟ್ 1 lakh. Let that liability of 2080 will be there. 1 lakh with interest.
ಅಲ್ಲ 20% ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ
ಅದಂಗೆ ಇದೆ. 1 lakh ಅಂತ ಅಂದ್ರೆ ನೀವು 80,000 ಕೊಡ್ಬೇಕು ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್. ಬಾಕಿದ್ದು ಹಂಗೆ. That I will not touch. Only that compensation. Yes. So and so learned counsel appearing for the claimant has contended that he has suffered grievous injury he has spent 18,457 for medical expenses. And he has taken a treatment as an outpatient for nearly 1 month. The global compensation awarded by the tribunal, 75,000, is on lower side. Hence, he sought for enhancement of compensation. For contra, so and so learned counsel appearing for the corporation has contended that the injuries suffered by the claimants are minor in nature. He has not examined the doctor. Considering that medical bill, the tribunal has granted a just and reasonable compensation. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award and original records. It is not in dispute. Petitioner has suffered an injury in a road traffic accident occurred on 1/6/2016. Due to that accident, he has suffered the following injury. He has produced medical bill of rupees 18,457 and he has taken treatment as an outpatient for nearly 1 month. Considering that medical records produced by the claimant, I am of the opinion that the compensation awarded by the tribunal, 75,000, has to be enhanced to 1 lakh. The insurance company's liability is restricted to KSRTC 80%. Yes. The case corporation is directed to deposit 80% of the compensation amount with 9% interest within 6 weeks from date of rest of topics.
Serial number 24, Shantaraj K for appellant, Nagarajaya K.
And for the respondent, first respondent, my lord.
Aged about 21 years.
Ready?
Ready.
Yes.
21 years. And doctor has assessed the permanent disability to an extent of 32% to the limb and 16% to whole body. Para 16 of the judgment.
Yes.
Tribunal has taken 10%.
Yes.
Para 16. Petitioner also examined the doctor as believed to, and in his affidavit he reiterated the nature of the injuries suffered and the treatment taken him in the hospital as inpatient. Petitioner in his evidence says the petitioner has a sustained fracture of distal radius and ulna, both bones, right forearm, and he was treated conservatively. The present X-ray shows united fracture of radius and non-union fracture of ulna styloid. He has assessed the total disability in respect of right upper limb at 32% and to whole body at 16%. He was subjected to cross-examination. In the cross-examination, he admits that the radius fracture is united, ulna is not united. And the tribunal has taken 10%.
Yes.
Income has taken at 7,500 per month.
What is the date of the accident?
15.
15.
Yes.
Not only quantum. He is
Yes.
not a
And,
member. He is a MBA student.
Hmm?
MBA student is not a earning member.
Yes.
Only radius fracture. Tribunal already given 2,60,500. 9% higher side interest. Only three days treatment you take.
Yes.
Para 70.
Yes.
Last paradalli
10%.
10% has
What are the injuries?
injuries,
Radius
fracture
fracture.
of radius and ulna fracture, both bones.
Yes.
Both bones.
Only 3 days taken treatment, my lord.
Yes.
ESI hospital.
I theory in an argument agli. Don't interfere. When I
Yes.
completed, you can argue.
Then nourishment. Immunities. 9%. Yes, mister. That's all.
Doctor evidence is there.
Yes. Pudi. Records idea.
Idea, record.
ಇಲ್ಲ
Doctor evidence.
Yes, Mr.
ನನ್ನ ಕೈಲಿ 2 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ ಸರ್ 794 days delay in appeal. Only 3 days treatment in conservative treatment. Only
Yes,
less medical bills,
Eleven.
3,500 medical bills. The doctor says disability is a radius fracture is higher side.
Yes.
32% limb and 12% whole body. Criminal taken is 10% is correct.
Yes.
But tribunal taken income is 7,500 according to is not earning member, he is a student, MBA student. But tribunal already given 2,60,500.
Yes.
9% higher side interest.
Yes. Yes, that's all.
Yes, sir.
Third. So and so learned counsel appearing
The
for.
income, my lord.
Yes, we will consider. Yes. So and so learned counsel appearing for. The claimant has contended that. Due to the extent, claimant has suffered the following injury. He has examined the doctor as PW2. In his evidence, he has deposed that claimant has suffered disability in respect of upper limb 32% and whole body 16%. The tribunal has assessed whole body disabilities 10% is on lower side. He further contended that at the time of the accident, the claimant was earning 10,500 per month as a part-time medical representative. Tribunal has assessed notional income of the claimant as 7,500 is on lower side. Lastly, he has contended that due to the accident, claimant was suffered a grievous injury. He was inpatient for a period of 3 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, so and so learned counsel appearing for the insurance company has contended that even though doctor has assessed whole body disability 16%, considering that limb disability assessed by the doctor 32%, and considering that age and avocation of the claimant, tribunal has rightly assessed whole body disabilities 10%. Secondly, he has contended that even though claimant has claimed that he was earning 10,500 per month, since he was a student, he is a non-earning member. Therefore, tribunal has rightly assessed notional income as 7,500. Lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant and considering that medical records, overall compensation awarded by the tribunal is just and reasonable. The interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 14/9/2015 due to rash and negligent driving of rider of motorcycle bearing registration number TN57 AK 1537. Due to that accident, claimant has suffered the following injury. The claimant has examined doctor as PW2. In his evidence, he has deposed that claimant has suffered right upper limb at 32% and whole body 16%. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 14%. Even though claimant has claimed that he was earning 10,500 per month as a part-time medical representative, he has not produced any document to establish the same. Even as per that local chart prepared by Legal Service Authority for notional income 2015, 9,000 has been fixed. Accordingly, monthly income of the claimant has to be assessed as 9,000 per month. The multiplier applicable to that age group 18. Accordingly, loss of earning due to disability has been reassessed as follows.
9,000 into 12 into 18 into 14%, 2,72,160.
Due to the accident, claimant has suffered the above said injury. He was inpatient for a period of 3 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering has to be enhanced from 10,000 to 50,000. Loss of amenities has to be enhanced from 20,000 to 40,000. And food and nourishment has to be enhanced from 5,000 to 8,000. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in.
794 days delay. 794 days.
As per order dated 15/2/2024, the claimant is not entitled for the interest for a period of 794 days for enhanced compensation. Later period same. Adjust it.
Serial number 25, Gopal Krishna N for appellant, connected matter, HS Lingaraj.
ಇದರಲ್ಲಿ ಮ್ಯಾಟರ್ ನಮ್ದೊಂದು ಅವ್ರ ನಮ್ಮ ಅಪೀಲಲ್ಲಿ ಎಷ್ಟು ಟೇಕ್ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಫಾರ್ ಆರ್
ಕೊಡಿ. ಯಾರಿಗೆ R1 ಗ
R1 to R3
yes
claimants out.
Gopal Krishna N is undertake to appear for respondent number 1 to 3. Office is directed to show his name. Will condone the delay. There is a delay of 169 days in filing an appeal. IA 1 of 2019 is filed for condonation of delay. Peruse that affidavit. For the reason stated in that accompanying affidavit, delay of 169 days in filing an appeal is condoned. IA 1 of 2019 is allowed.
LCR ಬೇಕಾದ
Office is directed to secure original record from the tribunal.
Serial number 26, Manjunath ND for appellant, connected matter, BC Sitaram Rao.
Ready, madam.
Ready?
Ready, madam.
Yes.
Madam, this injury case, madam, only quantum, my lord.
Yes. First you come to that
MEC 1063/2016.
1805.
Yes, madam.
1805 arising out of which MEC?
Madam, 1063.
1063.
Past 16, madam.
Where is the, which is the?
Madam, date of, madam.
Para.
Para, my lord.
163 ಯಾವ್ದ್ರಲ್ಲಿ ಶುರು ಆಗುತ್ತೆ? 1063.
No, sir, my lord.
1063 para 26.
26, my lord.
Yes.
My lord, date of accident, my lord. 33/2016, my lord.
Yes.
Age, my lord, 24 years, my lord.
24 years.
Yes, my lord. Occupation, my lord, working as jaggery maker, my lord. Income, my lord, 15,000. Tribunal taken as 7,000 only.
Yes.
Disability, my lord, 23.5% to whole body. Tribunal taken as only 23%, my lord.
23%.
Yes, my lord. Thank my lord.
ತಗೊಂಡಿದಾರಲ್ಲ?
Yes, yes, my lord. My lord, inpatient, my lord, 13 days, my lord. 13 ದಿನ.
13 days.
My lord, injury, my lord, para number 32, my lord. Open communicated of shaft of radius ulm of right 4 arm. Communicated fracture of head of radius right elbow. Open injury to right knee with chip fracture patella.
Open case fracture of so and so. Yes. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
My lord, pain suffering, my lord, 90,000. My lord.
Loss of amenities.
Yes, my lord, 30,000.
Future income towards date of nourishment, income rest, medical Future medical expense. ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. Income has to be enhanced.
ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ 32.44,000 ಮೇಲೆ only 25,000 ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ discussion?
ಪ್ಯಾರಾ ನಂಬರ್ 37 ಮೇಲೆ
37.
37 ಮೇಲೆ ಪ್ಯಾರಾ ನಂಬರ್.
Read. CWD doctor has stated that petitioner needs some more surgery for removal of the implant. Cost of said surgery is 35 to 40%.
Yes, madam.
Support of person CWD has not produced any estimations letter, other proper documents. ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಇಂಪ್ಲಾಂಟ್ ರಿಮೂವ್ ಮಾಡಕ್ಕೆ 5,000ದಿಂದ 50,000 ಆಗುತ್ತೆ. ಬಟ್ ಎಲ್ಲಿ ಏನು ಎಷ್ಟಾಗುತ್ತೆ ಅನ್ನೋದು ಏನು ಹೇಳಿಲ್ಲಲ್ಲ ಡಾಕ್ಟರ್. ಹಂಗಾಗಿ ಕೋರ್ಟ್ನರ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
25,000.
25,000. ಆಲ್ಮೋಸ್ಟ್ ದೇ ಹ್ಯಾವ್ ಗಿವನ್ ದಟ್ ಸಫಿಶಿಯಂಟ್ ದಿಸ್ ಥಿಂಗ್. Yes, that's all.
Yes,
What
ma'am.
about second matter?
Second matter ಮೇಲೆ 1682/20 MEC number 164/2016
1064.
Yes, madam.
Yes.
Date of accident, madam, 33/2016.
33?
2016, madam. Age, madam, 38 years.
30?
38 years, madam.
Yes.
Occupation, agriculture and dairying work. Income 50,000, same 7,000 ತಗೊಂಡಿದ್ದಾರೆ, madam.
ಅದು ಸೇಮ್ ಇದೆ.
16 9,500 ತಗೋಬೇಕು.
Yes.
Same, madam. Disability 50%, same ತಗೊಂಡಿದ್ದಾರೆ, madam. Full body.
ಅದು ತಗೊಂಡಿದ್ದಾರೆ.
ಅದೇ. Income
ಸಫರಿಂಗ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದ್ರಲ್ಲೂ ಹಂಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇನ್ಕಮ್ ಲೇಡರ್ ಪೀರಿಯಡ್ ಜಾಸ್ತಿ ಆಗಬೇಕು.
ಇನ್ಕಮ್ ಲೇಡರ್ ಪೀರಿಯಡ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
30,000 ಮೇಲೆ.
ಅದು ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಇನ್ಕಮ್ ಜಾಸ್ತಿ ಆದ ತಕ್ಷಣ. ಎಸ್ ತಾಳಿ. ಎಸ್ MFA 1805 of 2020 arising out of MEC 1063 of 2016. So and so learned counsel appearing for the claimant has contended that at the time of the accident he was earning 15,000 per month. Tribunal has assessed notional income of the claimant as 7,000 per month is on lower side. Secondly, he has contended that due to the accident, claimant has suffered grievous injury. He was inpatient for a period of 13 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, so and so learned counsel appearing for insurance company has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 7,000 per month. Secondly, he has contended that considering that evidence of doctor injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses, just and reasonable. The interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 30/3/2016 due to rash and negligent driving of driver of lorry bearing registration number KA 554195. Due to that accident, claimant has suffered the following injury. Page 23 alli the extract. Considering that injury suffered by the claimant and evidence of doctor, tribunal has rightly assessed whole body disabilities. ಎಷ್ಟಿದೆ ಅದರಲ್ಲಿ? 23%.
23.5%.
No, tribunal has assessed whole body disabilities 23%. ಎಲ್ರಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಎಲ್ಲಿದೆ ರೀ? Yes, 23%. has rightly assessed whole body disability is 23%. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the extent occurred in 2016, notional income has to be considered as 9,500. The multiplier applicable to that age group
18
is 18. Accordingly, loss of future earning has been reassessed as follows.
9,500 into 12 into 18 into 23%, 4,71,960.
Due to that extent, claimant has suffered the following injury. He was inpatient for a period of 13 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 30,000 to 40,000. Loss of income during the later period for 3 months. Compensation awarded by the tribunal in the other head are just and reasonable. Enhanced compensation amount carries 6% interest. This is your first matter. Yes, in view of accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit entire compensation amount with interest within 6 weeks from date of receipt of the copy of this order. In view of order dated 25/1/2023, the claimant is not entitled for the interest for a period of 278 days for enhanced compensation amount.
If later period is considered at 3 months, 1,500,000 ಇನ್ನು ಕಮ್ಮಿ ಆಗುತ್ತೆ.
ಈಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
30,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
30,000 ಅಂತಂದ್ರೆ ಈಗ ಎಷ್ಟು ತಿಂಗಳು ಲೆಕ್ಕ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು?
4.25 ತಿಂಗಳು.
4.25 ತಿಂಗಳು. 4 months ಆದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ?
ಜಾಸ್ತಿ.
4 months ಮಾಡ್ಬಿಡಿ. Enhanced later period is granted for period of 4 months. 3 months ಅಂತ ಹಾಕಿದ್ನಲ್ಲ 4 months ಮಾಡಿ. Enhanced compensation amount carries 6% interest. Second matter ali, what is that income is same?
Same, madam. Disability 15%, madam. 1.5.
In respect of contention, it is MEC 1064 of 2016. Insurance company matte claimants contention same. Only finding I will give. Adanna first matter hakidilla same contention hakandi. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 30/3/2016. Due to that accidental injury, claimant has suffered the following injuries. Page 29 ali. Considering that evidence of the doctor and injury suffered by the claimant, tribunal has rightly assessed whole body disabilities 15%. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines. For the accident occurred in 2016, notional income has to be considered as 9,500. The multiplier applicable to that age group is 15. Accordingly, loss of future earning has been reassessed as follows.
9,500 into 12 into 15 into 15%, 2,56,500.
Due to that accident, claimant has suffered the following injury. He was inpatient. Idರಲ್ಲಿ ಎಷ್ಟು ದಿನ ಇದ್ರಿ?
12 days, madam.
He was inpatient for a period of 12 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 30,000 to 40,000. Loss of income during the later period has to be granted for 4 months. Other head, compensation awarded by the tribunal is just and reasonable. Accordingly, the enhanced compensation amount carries 6% interest. Yes, there is a delay of ಅದಕ್ಕೆ ಒಂದು ಬೇರೆ ಆರ್ಡರ್ ಮಾಡ್ಕೊಳ್ಳಿ. IA 1 of 2019 is filed for condonation of delay of 369 days in filing an appeal. Peruse that affidavit. For the reason stated in that accompanying affidavit, delay of 369 days filing an appeal is condoned. IA 1 of 2019 is allowed, subject to condition. In case appellant succeeded in the appeal, he will not entitle for the interest for enhanced compensation amount. Orderly, he is not entitled for the interest for a period of 369 days for enhanced compensation.
Serial number 27, B. Pradeep for appellant, DP Mahesh.
For the respondent.
Pradeep, password.
Password.
Is there.
Password.
ಕೆಳಗಡೆ ಬರ್ತದೆ.
Serial number 28, Rangegowda NR for appellant, connected matter, BC Sitaram Rao.
In the connected matter, I need to take steps, Manoj. I'll take steps. In fact, Manoj, respondent number 1 is the claimant. Mr. Rangegowda ಅವ್ರಿಗೆ
One matter Rangegowda idare. Yav matter ಅಲ್ಲಿ?
in the connected 28.4
ಅಲ್ಲ? Which is
respondent
that?
number 1 is the claimant.
1. A process for 1 ಅಲ್ಲ? Yes. 28.4 ಅಲ್ಲಿ Rangegowda NR is directed to take notice for respondent number 1. 28.5 ಅಲ್ಲಿ ಅವ್ರು
Yes, I'll take steps, Manoj, ಅದ್ರಲ್ಲಿ R3.
28.5 ಅಲ್ಲಿ ಹಾಕಿದಾರ ಅವರು.
ಅಲ್ಲ, I'll take steps 28
For R3.
R3.
28.5 ಅಲ್ಲಿ weeks time is granted to take steps in respect of respondent number 3.
Serial number 29, Rajaram S for appellant, K. Nagarajaya.
Appellant, my lord.
Second respondent.
Doctor has been examined, my lord. Exhibit P19. Spinal injury, my lord. Lesser amount has been awarded.
ಕೊಟ್ಟಿದ್ದಾರೆ.
Totally, my lord, they have
1,09,689.
ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಆಗಿದೆ sir. PW2.
My lord, only produce the disability certificate. He assessed the disability 16%, but not limb.
ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಆಗಿದೆ sir. PW2 exam ಆಗಿದೆ sir.
Exam ಆಗಿಲ್ಲ, doctor.
ಆಗಿದೆ.
Only produce exhibit.
Evidence ಆಗಿದೆ sir.
ನೋಡೋಣ. ಇದಾರೆ. ಪ್ರದೀಪ್ ಕುಮಾರ್ has been examined. Now what is his evidence, mister? Has the tribunal discussed?
ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಸ್ವಲ್ಪ ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Is a MESCOM engineer.
ಯಾಕ್ರಿ ಅದೇನು ಡಿಸ್ಕಸ್ ಮಾಡಿಲ್ಲ ಅಲ್ಲ ಡಿಸಬಿಲಿಟಿ ಮಿಸ್ಟರ್ ನಾಗ?
ಅವ್ರ no loss of income, is working in the
continued in that work. Is it, mister?
ಅದ್ರ ಬಗ್ಗೆ ಏನು ತಿಳಿಲಿಲ್ಲ ಸ್ವಾಮಿ. ಅದ್ರ ಬಗ್ಗೆ ಏನು ತಿಳಿಲಿಲ್ಲ.
What is this?
Only 2 days taken treatment. Is only no fracture at all.
What is he?
He's a lineman, KPTCL.
Lineman.
ಹೌದು
Then you have continued in this work.
Yes.
Therefore that loss of
Only
future
2 days taken treatment,
pain and suffering, medical expenses. ಏನ್ ಇಂಜುರಿ ಏನೋ?
ಸ್ಪೈನಲ್ ಇಂಜುರಿ ಸ್ವಾಮಿ.
ಮೈನರ್ ಇಂಜುರಿನಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಇಂಜುರಿ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಆಗಿದೆ.
ಗ್ರಾಫ್ಟಿಂಗ್ ಎಲ್ಲ ಆಗಿದೆ.
ಟ್ರಾವೆಲಿಂಗ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್, ಡಿಸ್ಕಂಫರ್ಟ್, ಲಾಸ್ ಆಫ್
ಎಕ್ಸಿಬಿಟ್ 19 ಅಲ್ಲಿ ಎಲ್ಲ ಕ್ಲೀನ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತು.
ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಆಲ್ಸೋ 50,000 ರೂಪಾಯಿ ಜಾಸ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ?
16% ಅಂತ ಹೇಳಿ.
16% ಸ್ವಾಮಿ.
ಬಟ್
ಪೈನ್ ಇಂಜುರಿ,
ನೋ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್.
ಇನ್ಕಮ್ ಇಲ್ಲ, ಡಿಸಬಿಲಿಟೀಸಿಗಾರ ಕೊಡ್ಬೇಕಲ್ಲ, ಲಾಸ್ ಆಫ್ ಎಮ್ಯುನಿಟೀಸಿಗೆ.
ಹೌದು ಸ್ವಾಮಿ.
Immunities ಕೊಡ್ಬೇಕು.
ಬಹಳ ಕಡಿಮೆ ಆಯ್ತು ಸ್ವಾಮಿ.
ಆಯ್ತು, 1,09,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
ವಿಲ್ ಮೇಕ್ ಇಟ್ ಆಸ್ 1,50,000.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ಎಸ್, ಅಲ್ಲಿಗೆ 40,000 ಜಾಸ್ತಿ ಆದಂಗ ವಿತ್ ಇಂಟ್ರೆಸ್ಟ್.
ಇಂಟ್ರೆಸ್ಟ್ 7% ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು, ಅದು 50ಕ್ಕೆ ಯಾಕೆ ಇನ್ನ ಕಡಿಮೆ ಮಾಡ್ತಾರೆ? ಇಂಟ್ರೆಸ್ಟ್ ಹಂಗೆ ಇರಲಿ. So and so learned counsel appearing for the claimant has contended that due to that extent claimant has suffered 16% disability and he has spent 4,689 rupees for medical expenses and he was inpatient for a period of 2 days. The overall compensation awarded by the tribunal 1,09,689 which 7% interest is on lower side. Hence, he sought for enhancement of compensation. For contra, so and so learned counsel appearing for insurance company has contended that injuries suffered by the claimants are minor in nature. Due to disability, he has not suffered any loss. He has continued in his work. Considering that medical records and injuries suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, sought for dismissal of the appeal. Heard the learned counsel for the parties, Perot's judgment and award. It is not in dispute. Claimant has suffered an injury in road traffic accident occurred on 20th/4/2017 due to rash and negligent driving of driver of car bearing registration number KA02Z3855. Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 2 days. He has suffered 16% disability. And he has spent 4,689 rupees for medical expenses. Considering that injury suffered by the claimant and medical records, I am of the opinion that the compensation awarded by the tribunal 1,09,689 has to be enhanced to 1,50,000 with 7% interest.
Much obliged.
Accordingly, the appeal is allowed in part. Judgment and award passed by tribunal is modified as follows.
Much obliged.
Office objection, first time matter, serial number 30, Vasanta Lakshmi HV for
And for
petitioner.
the petitioner, my lord.
Yes,
My
madam.
lord, in this serial number 1, it may be
What is that
passed
office objection?
because that is the case Sadashiv Rao made as a party. My lord, during the pendency of the
Who is
proceedings,
Sadashiv Rao?
he has purchased the property during the pendency of the proceedings.
Yes.
As per annexure L, my lord.
What is that second?
Second, I will rectify, my lord. A week's time may be granted. I will rectify the same.
Yes. Submission of learned counsel for the petitioner is accepted. Office objection serial number 1 is overruled. She prays weeks time to comply office objection serial number 2.
Obliged.
Prays time to comply other office objection. Yes.
Serial number 31, Vasanta Lakshmi HV
For the petitioner, a week's time may be granted.
Appeal
Yes.
for the third respondent.
Yes,
A
she
week's
wants
time
to-
is granted.
yes.
Let's direct the office to correct my name in the cost item. It's KSS. SS to be removed.
Yes, office is directed to show the name of K.S. Shivkumar as correctly in the cost list.
KS Shivshankar. K Shivshankar.
Yes.
Obliged, me.
At the request of petitioner, please this matter next week.
for orders, serial number 32, Pallava R for petitioner.
Malad, I am for the petitioner, Malad.
Hmm.
Kindly 1 week time may be granted, Malad.
At the request, week's time is granted to do the needful.
Grateful.
Serial number 33, O Mahesh for appellant, connected matter, Pawan Chandra Shetty H.
And for the appellant to be connected.
IP for the sixth.
Where is Mahesh?
Steps ಬಂದಿಲ್ಲ.
ಏನಕ್ಕೆ ಬಂದಿದೆ? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ acknowledgement having served a copy of the appeal memo and necessary documents. ಯಾರಿಗೆ ಕೊಡ್ಬೇಕು?
ನನಗೆ.
ಈಗ ಕೊಟ್ಟಿಲ್ವಾ? Yes, where is Mahesh?
Serial
Collect
number
ಮಾಡ್ಕೊಳ್ಳಿ.
33,
ತೊಂದ್ರೆ ಇಲ್ಲ, ನನ್ ಮೇಲೆ ಏನ್ ದಯವಿಟ್ಟು ಇಲ್ಲ, ಅವ್ರು ಮಾಡಿದ್ರೆ ಅಂತ.
Yes. What is that in your this thing? Common TCR received in MFA. In your case, process is completed. On what ground they are challenging, Mr. This?
My lord, the driver should be a necessary party.
That is not that. Yes, any other on what ground? ಅದು ಎಲ್ಲ ಕಾಮನ್ ಇರುತ್ತೆ ಮಹೇಶ್ ಅವ್ರ ಅಪೀಲ್ ಅಲ್ಲಿ. ಡ್ರೈವರ್ 134 ಸೆಕ್ಷನ್ ಅವೆಲ್ಲ ಇರುತ್ತೆ. ಬಟ್ ಅದರ್ ಮೈನ್ ಗ್ರೌಂಡ್ಸ್ ಯು ಹ್ಯಾವ್ ಟು ಸೇ. ಎಸ್. ನಿಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ನನ್ನ ಹತ್ರ ಏನಿಲ್ಲ, ಬಟ್ ನನ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಹಂಗಾಗಿ ನನ್ನ ಮೇಲೆ ದಯವಿಟ್ಟು.
ಮೋಸ್ಟ್ಲಿ ನೆಗ್ಲಿಜೆನ್ಸ್. ಎಸ್.
50% to the respondent number 1 and 2 and 50%.
ಅವ್ರು 100% ಕ್ಲೈಮ್ ಮಾಡಿರ್ತಾರ ಅಷ್ಟೇ
Yes, ma'am.
ನಿಮ್ ಮೇಲೆ. ದೆನ್ ಯು ರಿಕ್ವೈರ್ಡ್ ಫಾರ್ ಕಾಪಿ.
ಹೌದು, ಕೊಟ್ಟಿಲ್ಲ. ಮಾಡತ್ತಿದ್ರೆ
Yes.
ಮಾಡ್ತೀನಿ ಆಮೇಲೆ.
ಯು ಕಲೆಕ್ಟ್ ಆರ್ ಐ ವಾಂಟ್ ಟು ಪಾಸ್ ಎನ್ ಆರ್ಡರ್.
ಅವ್ರು ಕಲೆಕ್ಟ್ ಅಲ್ಲಿ ಬರೋ.
ಎಸ್.
ನನ್ನ ಹತ್ರ ಇದೆಯಾ ನಮ್ಮ?
ಪಾಸ್ ಓವರ್.
ಅವ್ರ ಅಪೀಲ್ ನಂಬರ್.
ಎಸ್ ಮಿಸ್ಟರ್
ನಾನು ಇವ್ರ ಹತ್ರ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂತೀನಿ, ಡೇಟ್
Collect ಮಾಡ್ಕೊಂತೀರಿ,
ಇವ್ರ
yes.
ಹತ್ರ ಮಾಡ್ಕೊಂತೀನಿ.
ಎಸ್. Leave this matter next week.
Lordship, serial number 32, my lord, entry model kindly be extended.
32.
Yes, my lord.
Interim order, if any, is extended till next date of hearing.
Great.
Serial number 34, Shantaraj K for appellant, Ravi S.
Yes.
Prati.
Respond number 2 has not led either respond 2 or respond number 1 has not led any evidence.
Allala, iದೇನ್ process respondent number 2 is necessary.
ಅಲ್ಲ ಇದು ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ.
Who is he?
ಅವನ್ ಓನರು
ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿದಾರಾ?
ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟವ್ರು.
ಮತ್ತೆ ಒಂದು process ತಗೊಳ್ಳಿ. Yes, weeks time is granted to do the needful.
Serial number 35, O Mahesh for appellant, KT Udyog Prasad.
Furnishing PF issue notice to R2. Weeks time is granted to do the needful.
Serial number 36, Nayak NR for appellant.
The claimant appeal, my lord, United Kingdom, and take notice to Rushima.
Serial number 36,
For the appellant.
Memo for dispensation of notice to
1 and 3 and 4, man.
1 and 3 and 4.
Respond number 2, United.
United India Insurance.
United.
I will take notice, my lord. I will take notice.
Rushima.
Yes. Rushubendra. Yes, HC Rushubendra is directed to take notice for respondent number 2. Learned counsel for the appellant has filed a memo seeking dispensation of notice to 1, 3 and 4. Memo is taken on record. Notice to respondent number 1, 3 and 4 is dispensed at the risk of the appellant. You serve a copy to him? Yes.
Only Monday.
Next week, case of death, copy kodi first.
Serial number 37, Gopal Krishna N for appellant, HC Rishabhendraya.
Filing memo to dispense notice to R.
Yes, learned counsel for the appellant has filed a memo
Can be
seeking dispensation of notice to R1. Memo is taken on record. Notice
Can be
to
disposal
R1
of
is dispensed.
connected matter paint recovery ಆಗಿದೆ.
ಕೊಡಿ. ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ. Permit ಇಲ್ಲ.
So and so learned counsel appearing for the claimant has contended that the tribunal has passed on the liability on owner of the offending vehicle on the ground that offending vehicle was not having valid permit. He further submitted that in connected matter arising out of the same extent, this court in MFA 8630 of 2015 disposed of on 17 December 2019 has passed an order for pain recovery. The same is not been disputed by counsel appearing for insurance company. Accordingly, the appeal is allowed in part.
He is not entitled for interest of 1,305 days, my lord.
That I will come.
Delay in filing appeal.
Yes, yes. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified to that effect that insurance company is directed to deposit the entire compensation amount with interest, liberty to recover from owner of the offending vehicle. Yes, din delay?
1,305 days.
5 days.
1,305.
1,305.
1,305
sir.
IA ಯಾವ್ದು?
1 of 18.
IA 1 of ಅದು ಬೇರೆ ಆರ್ಡರ್ ಶೀಟ್. IA 1 of 2018 is filed for condonation and delay of 1,308
305.
305.
1,305 days.
Interest at 6%, my lord.
Peruse that affidavit
Interest at 6%.
for the reason stated in that.
Interest at 6%, my lord. In interest.
ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
6%. 6%.
ಕೊಡಿ ನಾನು ಹೇಳ್ತೀನಿ ತಕ್ಕಂತ.
Appending this allowed the judgment and award passed by the tribunal principal accident claim to Bangalore modified to the depot extents. Clear that?
Tribunal also 6%.
Huh?
Tribunal also 6%.
6%. Then yes. for the reason stated in the accompanying affidavit. Delay of 1,305 days in filing an appeal is condoned. Subject to condition. In case appellant is succeed, he is not entitled for the interest for a period of 1,305 days. Accordingly, IA 1 of 2018 is allowed. Idralli to that effect modified adadmele. In view of order dated so and so, the claimant is not entitled for the interest for a period of 1,305 days.
Appellant, N. Gopal Krishna.
Appellant proxy counsel for there are connected matter, maybe posted along with.
What about the process for R2? Necessary?
I will pay the
Yes.
process.
Week's time is granted to do the needful and call this matter along with that.
That I will.
For so and so, yes.
Serial number 39, K. Prasanna Shetty for appellant, D. Vijay Kumar.
I am ready, my lord. A simple matter, it can be disposed of.
Simple matter, my lord, sir. Two simple injuries. And my lord, ಅದರಲ್ಲಿ ಅವ್ರ ಏನ್ ಕಂಟೆನ್ಷನ್ ಅಂದ್ರೆ ಅವ್ರ ವೆಹಿಕಲ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ three wheeler auto rickshaw, passenger auto rickshaw, my lord. So trial court has awarded my lord 21,000, my lord.
Liability dispute idea?
No, my lord, no dispute. Tribunal has awarded
Only enhancement.
Yes, my lords.
Yes. On what are grounds you are raising that?
Grounds, my lords, only that
Enhancement of compensation. Enhancement of compensation, Master.
Yes.
Two simple injury, my lord.
Two simple injuries, my lord.
What are that? Doctor has been examined.
No, my lord, doctor has not been examined, my lord. The only contention is, my lord, sir, he's a driver of auto, my lord, sir. His auto has been damaged, totally damaged. Under that head, my lords, only 5,000 is given.
ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಡ್ಯಾಮೇಜ್ ಗೆ?
My lords, no documents has been produced, my lord.
ಮತ್ತೆ
So, my lords,
estimation ಇದೆಯಾ? Exam, you have examined that
examined, my lords.
person,
Yes, my
garage
lords.
person.
At page number 10, my lords. Page number 10.
ಯಾರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದೀರಾ?
Surveyor of general insurance, my lords.
ಎಷ್ಟು ಹೇಳಿದಾರ ಅವರು?
My lords, they have estimated 71,366 ಕೊಟ್ಟಿದ್ದಾರೆ.
Is a ವಾಹನಕ್ಕೆ ಒಟ್ಟು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂನೇ
Market, yes, my lord. My lords, so what I'm.
How that who has assessed that market value?
ಅಲ್ಲ, surveyor, insurance company surveyor ಮಾಡಿದ್ರೆ they have claimed amount from the insurance company.
ಆಯ್ತು.
Of their insurance company.
ಸರ್ವೇಯರ್ ರಿಪೇರಿಗೆ ಅಷ್ಟು ಹೇಳಿದ್ರು, ರಿಪೇರಿ ಮಾಡಿಸಿ ಗ್ಯಾರೇಜ್ ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಅಥವಾ ನೀವು ಗುಜರಿಗೆ ಹಾಕಿದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? 21,000 ಕೊಟ್ಟಿದ್ರ ಎಷ್ಟು ಮಿಸ್ಟರ್?
ಇನ್ನೊಂದು 15,000 ಕೊಡಿ ಸರ್.
Globally maybe.
You will make it as 50,000.
ಅಲ್ಲ ತುಂಬಾ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಎರಡು ಸಿಂಪಲ್ ಇಂಜುರಿ.
10-15 ಎಷ್ಟಾಯ್ತ್ರಿ? 35. ನಾನು ಹೇಳ್ತಿರೋದು 25 ಅಷ್ಟೇ.
10ರಿಂದ 15 ಅಷ್ಟೇ.
ಆಯ್ತು, 50,000 ರೂಪಾಯಿ ಎಷ್ಟು ಹೇಳಿ? So and so learned counsel appearing for the claimant has contended that due to that extent claimant has suffered grievous injury,
laceration back of ear.
Yes, he was
ತರ್ಚ್ಕೊಂಡಿದೆ ಅಷ್ಟೇ. ಇನ್ನೊಂದು tenderness.
Also his auto rickshaw was damaged. He has examined the general insurance surveyor. He has estimated the cost of repairs is 71,366. The overall compensation awarded by the tribunal 21,819 is on lower side. Hence he sought for enhancement of compensation. Per contra, Shri Vijay Kumar, learned counsel appearing for insurance company, has contended that injuries suffered by the claimants are minor in nature. Even though the surveyor has estimated damage cost to that auto rickshaw is 71,366. Petitioner has not examined any person from the garage and he has not produced any document to show that he has got repaired that auto rickshaw. Therefore, The overall compensation awarded by the tribunal is just and reasonable. Hence he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 10/5/2016 due to rash and negligent driving of driver of lorry bearing registration number MH12 LT 6675. Due to that accident, claimant has suffered the minor injuries. He has, considering that injury suffered by the claimant, medical records ಏನಿಲ್ಲ, and also exhibit P10 damage claimed application.
Wound certificate is produced.
Considering that wound certificate exhibit P4 and other records, I am of the opinion that the compensation awarded by the tribunal 21,819 has to be enhanced to 50,000 with 6% interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. 82 days delay. There is a delay of 82 days in filing an appeal. IA1 of 18 is filed for condonation of delay. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay is condoned. Filed in a memo for dispensation to notice to R1. Memo is taken on record. Notice to R1 is dispensed.
Serial number 40.
Appellate.
Appellant Ravi Shankar A.
Appellant. This case.
Where is Ravi Shankar?
ಇದರಲ್ಲಿ ಕ್ಲೈಮೆಂಟ್ injured was died on 24/9/2021 and I filed IA on 14/7/2022 bringing the LRs.
IA ಅಲಾಗಿದ್ಯಾ?
ಇಲ್ಲ.
Office objection.
ಏನು what is
ಅದರಲ್ಲಿ ಅಬೇಟ್ಮೆಂಟ್ ಗೆ ಮತ್ತೆ ಲಿಮಿಟೇಷನ್ ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
No, you can say in that one application.
Yes.
You have mentioned that prior
ಅಬೇಟ್ಮೆಂಟ್ ಬಗ್ಗೆ.
In the same application, you can mention abatement and condonation of delay and bringing a loss.
ನಾನು ಆ ತರ ಹೇಳಿಲ್ಲ ಇದು.
You just make an amendment. We'll have it next week.
Yes.
Now one application is enough.
ಅದೇ.
But all three prayers should be there.
Yes.
Yes, leave this matter next week.
Serial number 41. Kailash Shankar PS for appellant. Connected matter. SC Bensur, PC Shivanegowda.
Yes, Shivanegowda, ready?
Please. There are involvement of two vehicles. Involvement of two vehicles.
ಏನ್ dispute ಇಲ್ಲ.
Dispute ಏನಿಲ್ಲ. 70% 30%.
ಆಯ್ತು, ಅದು ಅವ್ರು ಬಿಟ್ಟಿರೋದು, ಅವ್ರು ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
They have not referred any appeal.
Yes. What is the second? Two claims ಇದೆಯಾ?
Two cases.
Yes.
ಮೊದಲನೇ MVC ಆರೋಪ. First case measured. In MVC 5239. 4498. In MVC 5239.
5239. Which is that page?
Page number 45 of the appeal memo.
45
and para number 58, my lord.
45
of appeal memo. 39 of judgment, man.
Yes.
First case. My lord, he was aged 64 years as on the date of action. And he has earning 25,000.
Yes to 50?
64 years.
64 years.
Professionally, he is a businessman and earning 25,000, man. Tribunal taken 7,500. And yes.
Date of accident?
My lord, date of accident is 29/4/2017, my lord.
11. Yes.
The fracture is and a fracture of femoral condyle left knee with swelling around left knee. We have examined doctor. That is that
doctor ಏನು ಹೇಳಿದ್ದಾರೆ?
Doctor assessed disabled at the lower limb but 34%, 11% at the whole body. But tribunal considered 9%.
34%, 11%, 9%. Yes.
And other rates he has taken conservative type of treatment, my lord. He is not impatient.
9% interest ಕೊಟ್ಟಿದಾರಾ?
9% ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಷ್ಟ್ ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರೆ ಒಂದೇ ದಿನ ಇಲ್ಲ.
ಇದು ಕನ್ಸರ್ವೇಟಿವ್ ಟೈಪ್ ಆಫ್ ಟ್ರೀಟ್ಮೆಂಟ್.
ಓಕೆ.
No operation, nothing.
ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 20, ಅಮ್ಯುನಿಟೀಸ್ 15.
3 ಎಡ್ಸ್ ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes. What is that other matter?
Other matter, my lord. That is a 3259 of 17, my lord. Case number 3259.
Para. Thirty to 59,
Please, my lord.
ಇದು ಇಂಜುರಿ ಕೇಸಾ?
ಇದು injury case.
Yes.
Para number 42, my lord. 43, my lord.
Yes.
Is
32 59. ಇದರಲ್ಲಿ
37 ವರ್ಷ ಏಜ್ ಅವರು.
32 years.
And he is also doing business and earning 45,000 per annum.
Yes.
In this regard, we have furnished exhibits P 12 to 15.
What is that?
My lord, that is registration certificate and 3 tax registration certificate and 2 income tax returns we have filed.
Which year?
15 and 16 and 16 and 17 months. Para number 45 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
Tribunal 15,000 ತಗೊಂಡಿದೆ. Para number 45 mainly
Since Malad is continuing the business, he has not produced the subsequent year income tax in order to show that there is a loss. Therefore, Malad, there is no loss. According to the tribunal, there is no loss. That's the reason they have not.
kindly peruse the ಇದು para number 45 my lord.
Mr. Counsel, now that 15,000 ತಗೊಂಡಿದ್ದಾರೆ,
ಅದೇ ಕೊಡ್ಬಾರ್ದು.
ಡಿಸಬಿಲಿಟಿ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಸುಮ್ಮನೆ ಇದ್ಬಿಡಿ ಅದನ್ನ.
ಅಲ್ಲ ಡಿಸಬಿಲಿಟಿ ಕೂಡ
What I have suggested.
kind submission ಡಿಸಬಿಲಿಟಿ ಕೂಡ ಲೋಯರ್ ಲಿಂಬ್ 57% ಕೊಟ್ಟಿದ್ದಾರೆ, 19% ಓಲ್ಡ್ ಬಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಕನ್ಸಿಡರ್ ಓನ್ಲಿ 14% ಮಾಡಿ.
ಅದು ಕೊಡಕ್ಕೆ ಬರಲ್ಲ ಸ್ವಾಮಿ. That's what.
ಸಿ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಡಾಕ್ಟರ್? ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ?
19% ಮೇಲೆ ಓಲ್ಡ್ ಬಾಡಿ, 57 ಲೋಯರ್ ಲಿಂಬ್ ಮೇಲೆ.
ಟೋಟಲ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ ಲಿಂಬು?
57.
57. 15 3 45 ಆಯ್ತು. ಒಂದು 5 ನೌ ಇಫ್ ಯು ವಾಂಟ್ ಟು ಗೋ ಆನ್ ಎಕ್ಸಾಮಿನ್, ದೆನ್ now you have to produce that income tax return for the year 17 and 18.
That is Margaret P15 my lord. Kindly peruse the para 45 my lord.
No, that 17 and 18.
That's what the observation.
17, 16 and 17 we have furnished.
ಆಯ್ತು. ಆಕ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ಏನ್ ಲಾಸ್?
Accident ಆದ್ಮೇಲೆ we are not furnished.
ಅದರಲ್ಲಿ ನಿಮಗೆ ಇನ್ಕಮ್ ಜಾಸ್ತಿ ಆಗಿದ್ರೆ ಇವೆಲ್ಲವೂ ಹೋಗ್ತಾವ.
ಹೌದು, that's correct.
You keep it that this thing. How many days you are in that hospital?
20 days my lord. 20 days.
20 days. ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
Pain and suffering ಅಲ್ಲಿ
20,000 it is granted.
Pain and suffering
60,000 ಕೊಟ್ಟಿದ್ದಾರೆ, but he has suffered multiple fractures my lord.
Amenities towards nourishment.
Future loss of income ಕೊಡಕ್ ಬರಲ್ಲ. Considering that Malad, the compensation granted reduced.
As per wound certificate, he has sustained 5 simple injuries, 3 grievous injuries.
ಅದಕ್ಕೆ 60,000 ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ, 40 plus 3 60. ಆಮೇಲೆ ಅಮ್ಯುನಿಟೀಸ್ ಒಂಚೂರು ಯಾವ್ದೋ ಒಂದ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡ್ಕೊಡೋಣ ಬಿಡಿ, ಆಯ್ತು. ದಟ್ಸ್ ಆಲ್.
ಅದ ಇನ್ಕಮ್ 25,000 ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಬಹುದು.
Now that
IT returns ಮೇಲೆ
that don't enter into that. Otherwise we will ask you to file an affidavit producing that income tax returns for 17 and 18. Or you have to file an affidavit that you have not filed any return after that. Then we know that how to get records whether you have filed it or
Yes, filed the return. It is income is increased. That's the reason is not entered, but number appeal akila. Therefore, I am not.
ಅದು 1/3 ತಗೊಂಡ್ರೆ ಕೂಡ 19% ಬರುತ್ತೆ.
No, if you want to touch that disabilities aspects and income, again all these things will be reopened. You keep it that I will not even consider your argument on that point. Yes. Will enhance some extent in that other. First matter, MVC 5239 of 2017. Learned counsel for the claimant has contended that due to that extent, claimant has suffered grievous injury. He has examined the doctor. Doctor has assessed whole body disabilities 34%. Allah, doctor has assessed
34%, 11% first.
34% to which limb?
Lower limb.
Has assessed
Left lower limb.
34% disability to lower limb and
Left lower limb.
11% to that whole body. Tribunal has assessed
9%.
whole body disability is 9% is on lower side. Second, he has contended that at the time of the accident, claimant was earning 25,000 per month. Tribunal has assessed notional income of the claimant as 7,500 per month is on lower side. Lastly, he has contended that due to that accident, claimant has suffered grievous injury. He was suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, loss of immunities is on lower side. Hence, he sought for enhancement of compensation. For contra, Shri Shivanegowda and Pestor, learned counsel appearing for the insurance companies, contended that even though doctor has assessed whole body disabilities 11%, considering that age and avocation of the claimant, the whole body disabilities assessed by the tribunal 9% is just and reasonable. Secondly, they have contended that even though claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the claimant as 7,500. Lastly, they have contended that considering that injury suffered by the claimant and his age and avocation, overall compensation awarded by the tribunal is just and reasonable. Interest awarded by the tribunal 9% is on higher side. Hence, they sought for dismissal of the appeal. Yes. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 29/4/2017 due to rash and negligent driving of driver of lorry bearing registration number AP 25 Y8364. Due to the accident, claimant has suffered the following injury. He has examined the doctor as PW6.
516.
PW ಯಾರು ಇದ್ರಲ್ಲಿ?
6 madam.
PW6. In his evidence, he has deposed that the claimant has suffered 34% disability to left lower limb, 11% to whole body. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the whole body disabilities has to be assessed 11%. Even though claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, his notional income has to be considered as 11,000. The multiplier applicable to that age group is 64, 9, 7.
7 madam.
7. Accordingly,
64 age.
loss of future earning has been reassessed as follows.
11,000 into 12 into 7 into 11%, 1,01,640.
Due to that accident, claimant has suffered the above said injury. He was inpatient for a period of, no, he was not inpatient. Yes,
No, yes.
suffered
Conservative.
the above said injury. He has suffered lot of pain during the treatment. Considering that, and he has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 20,000 to 30,000. Loss of immunities from 15,000 to 30,000. The enhanced compensation amount carries 6% interest. Yes.
And
Second matter.
70%.
Adide. That is what is there in that tribunal order. Or you're not
Tribunal
listening.
order is
In the MEC,
In this case, he has sustained multiple fractures.
where? 3259.
Please, madam. My lord, parent number 49, my lord.
ಎಷ್ಟು ಡಾಕ್ಟರ್ ಡಿಸಬಿಲಿಟೀಸ್ ಹೇಳಿದ್ದಾರೆ?
ಅದೇ
Doctor
continuing
disability
business
57
man
and,
is not entitled to get any compensation.
ಅಲ್ಲ ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಅಂಡ್ ಅದರ್
ಅದು
ಹೆಡ್ಸ್
60,000.
60,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲೂ. ಈ ಹೆಡ್ಡಲ್ಲೇ ಕೊಟ್ಟಿದ್ದಾರೆ ದಟ್ ನಮ್ಮವ್ರ ಅಪೀಲ್ ಹಾಕಿದ್ರೆ is not
Yes,
entitled to get.
so and so learned counsel appearing for. The claimant has contended that due to that extent, claimant has suffered 7 injuries. He was inpatient for a period of 20 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, Shri Shivanegowda and Bestor, learned counsel appearing for, insurance company has contended that even though the claimant has suffered on 7 injuries, ಯಾವ್ದು ಮೇಜರ್ ಇಂಜುರೀಸ್ ಎಷ್ಟಿದೆ?
5 to 8, my lord. More injuries as per wound certificate.
ಮೇಜರ್ ಇಂಜುರೀಸ್ ಎಷ್ಟು?
More.
There are only 2 major injuries. Other injuries are minor injuries. And
6 to 8.
due to that accidental injury, he has not suffered any loss of income. Therefore, the overall compensation awarded by the tribunal is just and reasonable. Sought for dismissal of the appeal. Heard the learned counsel for the parties. Perose, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 29/4/2017 due to rash and negligent driving of driver of lorry bearing registration number KA 429627 and lorry bearing registration number AP 25Y8364. ಆ ಮೊದಲನೇ ಕೇಸಲ್ಲಿ 2 ನಂಬರ್ ಹಾಕಬೇಕು. ಒಂದೇ ಲಾರಿ ಹೇಳಿದ್ದೆ. Liabilities is on both. Due to that extent, the claimant has suffered the following injury. Page 40 ಇದೆ 8 injuries. Considering that injury suffered by the claimant, considering his age and avocation and disabilities suffered by the claimant, I am inclined to enhance the compensation for loss of amenities from 30,000 to 50,000. Towards attendance nourishment has to be enhanced from 10,000 to 30,000. ಇನ್ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ರೀ?
ಇಲ್ಲ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಕೊಟ್ಟಿರೋದ್ರೆ ಕಡಿಮೆ ಆಗ್ಬೇಕಿದೆ ಆಕ್ಚುಲಿ.
ಅಟೆಂಡೆನ್ಸ್ ಅದರಲ್ಲಿ 20,000-30,000 ಜಾಸ್ತಿ ಆಯ್ತು. Yes. The enhanced compensation amount carries in other head, compensation awarded by the tribunal is just and reasonable. Accordingly, the appeal is allowed in part. The enhanced compensation amount carries 6%.
Liability.
Liability as per the tribunal law.
Yes, yes. 41, Shivanegowda is directed to take notice for respondent number 2.
ಎರಡರಲ್ಲಿ dispensation ಇದೆ. First
Notice
case ಅಲ್ಲಿ R3.
Yes, memo filed for dispensation of notice to R3. Memo is taken on record, notice to R3 is dispensed.
In second case ಅಲ್ಲಿ R1 and R3.
R1 and R3 is dispensed, second matter.
Serial number 42, Sharadambai for appellant.
Appellant, my lord. Sorry, my lords, in this case, I could not pay the process. I am seeking dispensation for notice to respondent number 1, United India Insurance Company, second respondent.
United India.
ಇವ್ರು ಇದ್ದಾರೆ.
ಶಿವನಗೌಡರು ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇದ್ದೀರಾ? Yes. Shivanegowda is directed to take notice for respondent number 2. Learned counsel for the appellant has filed a memo for dispensation of notice to R1. Notice to R1 is dispensed. Directed to serve 1 set of copies on Shivanegowda appearing for R2.
ಅಲ್ಲ ಡೇಟ್ ಕೊಡ್ಬೋದು, small case it can be dispensed.
Next week. Yes, next.
Serial number 43, Ashok Kumar Shetty for appellant.
Dismissing of appeal in view of non-compliance officer.
Compliances, the file is not available. It is of seniors file, my lord. We have to
Week's time
search
is
for the
not-
file. We will comply in a week's time, my lord, because we don't have the file itself. It is of our seniors.
At the request of counsel for the appellant, as a last chance,
2 weeks, 2
each
weeks,
time is granted
a week's time.
to comply of subjects.
Obliged.
Serial number 44, Siddharth P. Muchandi for appellant.
For appellate, my
Devaraju N.
trial court
Kumar.
case has been.
Yes, we'll extend for it. This court, by order dated 21st August 2023, directed the trial court to dispose of the suit not later than 1 year from the date of receipt of a copy of this order. Registry has received communication dated 19/8/2024 from Principal City Civil and Session Judge Bangalore for further extension of the time. For the reason stated in communication dated 17/8/2024, the further period of 4 months has been extended from today.
Serial number 45, P. N. Harish for cross objector.
Council submission regarding that office objection, date of service, ಏನಿದು?
ಅಡ್ಮಿಟ್ ಆಗಿರೋ ಡೇಟ್ ನಾನು ಲೆಕ್ಕ ಹಾಕಿದ್ದೀನಿ ಸುಮ್ಮನೆ. Is admitted on
Main appeal ಇದೆಯಾ?
ಇದೆ
All
MFS
this matter along with that so and so,
MFS 640 of 2018.
640 of
2018.
2023 ನಮಗೇನಾ?
18, sir. 18 main.
Next week ಅಲ್ಲಿ ಹಾಕ್ಬೋದು. Death case
18 ಎಲ್ಲಿ? ಅಲ್ರಿ MFA ಕ್ರಾಪ್ 23 ಅಲ್ರಿ ಇದು. ಅಲ್ಲ main appeal ಬಂದಿಲ್ಲ ಇದ್ರ ಜೊತೆಗೆ. Yes, call this matter along with that so and so.
next week ಅಲ್ಲಿ.
Next week.
Death case ಮುಗಿಸ್ಬಿಡು.
Yes, next week.
Hearing interlocutory application matter, serial number 46, Virupakshaya PH for petitioner.
Appearing for the petitioner.
What is this, Mr. Virupaksha?
My lords, the petitioner, my lord, during the pendency of these civil petitions, he has passed away, my lords. I have filed applications to bring him on record, bring the children on record, my lord. My lord, the petitioner is seeking transfer, my lords, of the regular appeals, my lords, which are pending before the learned first appellate judge. To this honorable court, my lord, there is a RFA, my lords, which is pending consideration. My lords, before the trial court, my lord, there were 5 suits, my lord. A common judgment and decree, my lords, was passed, my lord, in all the suits. My lords, challenging one of the suits, my lord, challenging the judgment and decree.
Who has filed a suit?
My lord, suit, my lord, there are 6 suits, my lord, which were pending consideration.
6 suits is filed by whom?
My lord, by respondents, my lord.
No, all 6 suits has been clubbed together and passed in a single order.
Please, my lord.
Suit for?
My lord, suit for partition and declaration that the sale deeds are not binding. My lord, the suits, my lord, few suits were dismissed, my lord, few suits were allowed, decreed, my lords, in favor of the plaintiff. My lord, in one of the suits, my lord, challenging the common judgment and decree, my lords, RFA is filed, my lords, and the same is pending consideration before this honorable court. Since the valuation, my lords, is coming, my lords, within 10 lakhs to 15
Then
lakhs.
all other has been filed
Other-
in RA.
RA is filed, my lords, before the learned first appellate judge.
Now all has to be clubbed together, Mr. Here only. Otherwise, there is an divergent decision judgment.
Of the new amendment.
ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ್ದು, but
ಅದ್ರಲ್ಲಿ-
I don't think it will, but amendment stay ಆಗಿದೆಯಲ್ಲ ಈಗ.
ಆಗಿದೆ.
ಆದ್ರೆ ಈ RFA ಜೊತೆಗೆ ನಿಮ್ಮ RAನು ಒಟ್ಟಿಗೆ ಹೋಗ್ತಾವ ಅಷ್ಟೇ.
ತಿರ್ಗಾ ಅಲ್ಲಿಗೆ
What is that IS, Mr.?
My lords, the here to come on record, my lords, as LRs of deceased petitioner. In all the matters, my lord, applications are
Same
petitioner, my lord.
Particularly problem.
ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಇಲ್ಲಿ ಬಂದು ಮತ್ತೆ ಅಲ್ಲಿ ಹೋಗೋದು.
ಅಲ್ಲ ಅದು ಸ್ಟೇ ಆಗಿದೆ. ಐ ಥಿಂಕ್ ವಿ ಡೋಂಟ್ ನೋ.
If request to be considered, it will be considered.
No, that see, either it will be heard in that.
Because it is better to come here because see.
No, High Court has to be come. It has to be come. See now,
If this
in that matter where that constitutional validity has been challenged, government will not move that matter because they are not interested, because it will not affect their. ನೀವು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಾರ ಇಯರ್ ಮಾಡಿ ಅಲ್ಲಾರ ಮಾಡಿ ಸಂಬಂಧ ಇಲ್ಲ. ಇನ್ ದಟ್ ಕೇಸ್ ವಿ ಡೋಂಟ್ ನೋ ವೆನ್ ಇಟ್ ವಿಲ್ ಬಿ ಡಿಸೈಡೆಡ್. ದೇರ್ಫೋರ್ ವಿಲ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಲ್ ದಿಸ್ ಟು ಹಿಯರ್. ಎಲ್ಲ ಕ್ಲೈಮೇಟ್ಸ್ ಪಿಟಿಷನರ್ ಒಬ್ರೇನಾ? Who are that LRs?
Not the widow and
ಮಕ್ಕಳು. Yes. ಅದರಲ್ಲಿ IA 1 of 2024 is filed for condonation of delay of 794 days in filing an LR application to bring LRs of ಒಬ್ಬರೇ petitioner.
Please, madam.
LRs of petitioner. Out the learned counsel for the parties peruse that affidavit filed along with that application for the reason stated in that accompanying affidavit. Delay of 794 days in filing an LR application to bring LRs of deceased petitioner is condoned. IA 1 of 24 is allowed. Consequently, 2 of 2024 is allowed. Abatement is set aside. IA 3 of 2024 is allowed. LRs of deceased petitioner is permitted to come on record. Non-filing of paper publication ಏನ್ರಿ ಅದು? Respondent ಎಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿಲ್ವಾ ಇನ್ನು ಎಲ್ಲರಿಗೂ?
The plaintiffs who were my lords before the appellants who were before the learned first, they have all been served, my lord. However, few of the respondents, my lord, since the petitioner passed away during the pendency of the CP, my lord, I could not take out paper. My lord,
You have to process has to be completed.
My lord,
We
sir.
can't dispose of
Please.
this matter.
ಅದರಲ್ಲಿ ಸುಮಾರು ಜನಕ್ಕೆ paper publication, I will take out, my lord.
ಅದ್ ನೀವು ಮಾಡಿ first I will
LR
allow
application,
that
lords.
LR application
Please.
first.
In all the matters, my lord, LR.
ಎಲ್ಲಾ matter ಅಲ್ಲೂ IA same order. Allowed. LRs is permitted to come on record. Learned counsel for the petitioner is permitted to amend the cast title. You do it first.
My lords, I shall do it.
Yes. ಎಲ್ಲದ್ರಲ್ಲೂ ಆರ್ಡರ್ ಮಾಡಿ.
Interim order, my lords, may I?
Interim order granted earlier is extended till next date of it.
Bill number 47, Jagadish HT for appellant, K Nagaraja, Syed Akbar Pasha.
And for the appellant in this case.
I appear for the respondent case RTC. There is a delay.
Ready.
Yes, my lord. There is a delay of more than 6 years in the appeal itself.
2008.
Liability dispute ಇದೆಯಾ?
Liability is not disputed, my lord. Only quantum. He was in
Representation
2010
that
accident,
this
my lord.
appeal has dismissed.
Please.
IFR recalling ಬಂದಿದ್ಯಾ?
ಅದು translation copy ಹಾಕಿಲ್ಲ ಅಂತ previous date.
Will recall that order, Mr.
Action,
Please.
without interest.
IA 1 of 2024 is filed for recalling that order dated 3/11/2023. Alla, IA 1 of 2024 is filed for condonation of delay of 241 days in filing an application for recalling that order dated 3/11/2023. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 241 days in filing application for recalling the order dated 3/11/2023 is condoned, subject to condition. In case appellant is succeeded in this appeal, not entitled for the interest for a period of 241 days for enhanced compensation amount. Consequently, IA 2 of 2024 is allowed. Order dated 3/11/2023 is recalled. The appeal is restored to file.
Please.
Yes.
Next. Any date, my lord.
Next
ಅಲ್ಲ
week.
ಇದು ಇವತ್ತೇ ಮುಗಿಸ್ಕೊಡ್ಬೋದು.
Ready-ನಾ?
Ready.
Yes.
But that 2010 accident, my lord. Case of death. Claimed by 2 wives and children of the deceased, my lord.
ಅಲ್ಲ ಅದಕ್ಕಿಂತ ಮುಂಚೆ 6 ವರ್ಷ ಡಿಲೇ ಇದೆ.
ಅದನ್ನ ಹೇಳಿ ಸ್ವಾಮಿ ಅವರು.
ಅಪೀಲಿಗೆ ಡಿಲೇ ಇದೆ.
ಅಪೀಲಿಗೆ ಡಿಲೇ ಇದೆ. ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ, ಅದಕ್ಕೆ ಹೇಳಿ ಅವರು. ಇಲ್ಲ,
ಎಷ್ಟು ವರ್ಷ ಡಿಲೇ ಇದೆ?
6 ವರ್ಷ ಇದೆ.
What are you doing for 6 years, mister?
The appellant number 213 as the minor at the time of the accident, my lord. Minor idru ಆ time ಅಲ್ಲಿ.
Who are minor?
Cast title 3 and 4.
See, on 40, they are 43, 2016, how they are minor? Wife is there?
Wife is there. Wife
Then
is there.
she is not minor. What is the reason? Where is your application?
Reason for ಹುಷಾರ್ಲಿಲ್ಲ.
Memorandum of facts ಹಾಕಿದ್ರಲ್ರಿ?
ಡಿಲೇ ಇದೆ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಇದೆ.
ಡಿಲೇಗೆ?
ಮೇನ್ ಡಿಲೇ ಇದೆ, ಮೇನ್ ಡಿಲೇ ಫಸ್ಟ್ ಇದೆ. ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಮೀಟ್ ಮಾಡಕ್ ಆಗಿಲ್ಲ ಅನ್ನೋ ಒಂದು ಉದ್ದೇಶ.
Yes, read.
ಫೈಲ್ ಮಿಸ್ಪ್ಲೇಸ್.
It submits that appeal is filed seeking enhancement of compensation so and so. In order to avoid the repetition of actions, I submit I do not file a above appeal within the statutory period. For reason I have suffered from jaundice. I have also, nothing has been explained. 1000 days delays.
Only for
This type of application. You file a better affidavit.
Better of
Yes.
ಅಲ್ಲ, ಸರಳ ವರ್ಮ ಕೇಸ್ ಪ್ರಕಾರವಾಗಿ ಮೇಡ ಐ ಆಮ್ ಆಡಿಯಬಲ್ ಮೇಡ.
Yes, you have no objection for delay condonation.
Madam, I can't say I have filed my statement of objections for condoning the delay. Madam, on merits, Madam, you will worship my kindly see. As per at that time, the prevailing law was only Sarada Varma case. And any judgment to be passed, Madam, in terms of that, Madam, if he has no objection, Madam, same may be considered. Loss of dependency ಒಂದು ಕನ್ಸಿಡರ್ ಮಾಡೋ ಸಾಕು. ಯಾಕೆಂದ್ರೆ ಇದು ಮ್ಯಾಗ್ಮಾ ಕೇಸ್ ಪ್ರಕಾರ ಬರೋದಿಲ್ಲ, ಬೇಡ.
Loss of
ಇದರಲ್ಲಿ ಡಿಪೆಂಡೆನ್ಸಿ 5500 ತಗೋಬೇಕು 2010ಗೆ. 25% ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಮಾಡಿದ ಆ ಇಡಲ್ 3 lakhs ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಬರೋದಿಲ್ಲ. ಅಲ್ಲ, 25% ಮಲಡ್ 25% ಬರುತ್ತೆ ಆ ಇಡಲ್ಲಿ. 5500 ರೂಪಾಯಿ ಇನ್ಕಮ್ 4000 ಹ್ಯಾಸ್ ಟೇಕನ್ ಬೈ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮಲಡ್. ಅದು ತಗೊಂಡ್ರೆ 3,75,000 ಬರುತ್ತೆ ಸ್ವಾಮಿ, ಅಷ್ಟೇ. ಅದೊಂದೇ ಇಟ್ಟು 1/6 ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಸರಳ ವರ್ಮ ಕೇಸಲ್ಲಿ ಇವರಿಗೆ ಬರೋದಿಲ್ಲ ಅಷ್ಟೇ. ಅದೊಂದೇ ಗ್ರೌಂಡ್ ನಾನು. ಆಮೇಲೆ ಇವ್ರು ನೋಡಿ ಸ್ವಾಮಿ, ಒಂದನೇ ತಾಯಿ, ಒಂದನೇ ಹೆಂಡತಿ, ಎರಡನೇ ಹೆಂಡತಿ, ಮೂರನೇ ಹೆಂಡತಿ ವೈಫ್ಸ್ ಇದಾರೆ. ಹಾಗಾಗಿ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ
ಏನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಮೇಲೆ ಇನ್ಕಮ್ ಒಂದು, ಲಾಸ್ ಆಫ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ ಒಂದು, ಅವೆರಡು ಇಡ್ಡಲ್ಲಿ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಲಾಸ್ ಆಫ್
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ 25% ಬರುತ್ತೆ. 5,500 2010 ಆಕ್ಸಿಡೆಂಟ್. ಸರಳ ವರ್ಮ ಕೇಸಲ್ಲಿ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಇಲ್ಲ ಅವ್ರಿಗೆ. ಆಮೇಲೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು 1/6 ತಗೊಂಡಿದ್ದಾರೆ. 1/5 is the should be the deduction. ಅಲ್ಲ, 1 to 8 ಮೆಂಬರ್ಸ್ ಇದಾರೆ ಸ್ವಾಮಿ. 1/6 ಕರೆಕ್ಟ್ ಇದೆ, ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. ನೋಡಿ ಸ್ವಾಮಿ, ಸರಳ ವರ್ಮ ಕೇಸ್ ತಗೊಂಡು ನೋಡಿ ಸ್ವಾಮಿ. 1/6 ಸರಳ ವರ್ಮ ಕೇಸಲ್ಲಿ your lordship may kindly see para number 30 of the ಸರಳ ವರ್ಮ ಕೇಸ್. 1/5 where the number of dependents, family members exceeds 6. More than 6 members malad 1/6 ಬರುತ್ತೆ. ತಾವು ನೋಡಿ ಸ್ವಾಮಿ, ಸರಳ ವರ್ಮ ಕೇಸಲ್ಲಿ ಅವ್ರೇನೋ ಹೊಸ ಥಿಯರಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
No,
8 members malad
6 and above is 1/5.
8 members ಇದಾರೆ ಸ್ವಾಮಿ.
1/6 ಗೆಲ್ಲ ಐತ್ರಿ, 1/6 ಇಲ್ರಿ.
ಅಲ್ಲ, ಕೆಳಗಡೆ 8 members malad
ಅಲ್ರಿ.
ಅದ 1/4 1/5 ಆಗ್ಬೇಕು. ಅದೇ 1/5.
1/5 is that, not 1/6.
ಅದೇ 1/5.
6 ಜನದ ಮೇಲೆ ಎಷ್ಟೇ ಇದ್ರು 1/5 ಅದು. That is what that Supreme Court said.
ಬಟ್ ನಾನು ಅದನ್ನೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ 5,500 ತಗೊಂಡು 25% ಆಡ್ ಮಾಡಿದ್ರೆ 1/5 ಡಿಡಕ್ಷನ್ ಮಾಡಿದ್ರೆ ಒಂದು ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಬರುತ್ತೆ.
ಅಲ್ರಿ, ಈಗ ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
4,000 ತಗೊಂಡಿದ್ದಾರೆ.
4,000
ತಗೊಂಡಿದ್ದಾರೆ.
ಎಷ್ಟು ತಗೊಂಡ್ಬೇಕು?
5,500 2010 ಆಕ್ಸಿಡೆಂಟ್. 5,500
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್
25%. ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ. ತಾವು ನೋಡಿ ಸ್ವಾಮಿ, ಇದನ್ನ ಯಾವಾಗ ಪಾಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ತಾವು ನೋಡಿ ಸ್ವಾಮಿ. ಇದು ಯಾವತ್ತು ಅಂತಂದ್ರೆ 2010 ಆಕ್ಸಿಡೆಂಟ್.
ಬಿಡಿ, ಅದ್ ಬಿಡಿ. 5,000. What is his age?
Blood 49 years. 49 years.
49.
13 multiplier.
25 future prospects. 5,000.
ಇದೆಲ್ಲ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿರೋದು 2017 ಒಂದು ಪ್ರಣಯ್ ಶೆಟ್ಟಿ ಕೇಸು, ಇನ್ನ ಒಂದು 2018 ನಾಲ್ಕನೇ ಕೇಸು. ಅಷ್ಟೊತ್ತಿಗೆ ಇದಾಗಲೇ ಮುಗಿದು ಕೇಸ್ ಮುಗಿದು ಡಿಲೇ ಲಿಮಿಟೇಷನ್ ಎಲ್ಲಾ ಪೀರಿಯಡ್ ಆಗೋಗ್ಬಿಟ್ಟಿತ್ತು. It has already attained finality at that time itself before even coming into the force of the law laid down by the apex court in Magma case and Pranay Shetty case. Therefore, future prospects ಬರೋದಿಲ್ಲ. ಅವೆಲ್ಲ ಕನ್ಸೋರ್ಷಿಯಮ್ ಅವೆಲ್ಲ ಬರೋದಿಲ್ಲ, ಬರೀ 25,000 ರೂಪಾಯಿ 30,000 ರೂಪಾಯಿ ಬರುತ್ತೆ ಅಷ್ಟೇ.
86 5,20,000 ಆದ್ರೆ ಎಷ್ಟು ಜಾಸ್ತಿ ಆಯ್ತು? -5,20,000. ಅದ್ರಲ್ಲಿ -5,20,000 ಮಾಡ್ತೀನಿ ಒಟ್ಟು ಅಮೌಂಟ್ ಅಲ್ಲಿ. ಎಷ್ಟು ಬಂದಿದೆ? ಆಯ್ತು 5,20,000 ಒಂದು 80 6 1 80 8 8 16 2 60 2.6 ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಎಸ್ ಮಿಸ್ಟರ್ 2.6 lakhs ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಅದು ಹೆಂಗೆ ಜಾಸ್ತಿ ಆಗ್ತದೆ? ಸುಮ್ಮನೆ ಇದನ್ನ ತೋಟ್ರುನುವೆ
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್
ಬರೋದೇ ಇಲ್ಲ. ಅದು
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಇತ್ತು ಮೊದಲು 30% ಇತ್ತು. 30% was there before Sarala Verma, before Nisheti.
ಇದು ಸರಳ ವರ್ಮ ಕೇಸ್ ಬಂದಾಗ ಇದು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಪ್ಲೈ ಆಗ್ತಾ ಇದ್ದಿತ್ತು. ತಾವು ನೋಡಿ ಸರಳ ವರ್ಮ ಕೇಸಲ್ಲಿ, ಯಾಕಂದ್ರೆ ಇದನ್ನು ಡಿಲೇ ಇದೆ, ಅದನ್ನು ಸ್ವಲ್ಪ ಗಮನದಲ್ಲಿ ಇಟ್ಕೊಳ್ಳಿ.
Once I have condoned the delay, then law as on today will be applicable to the case. That you have to keep in mind.
ಅಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರನೇ ಅವರು ಒಪ್ಪಿದ್ರೆ ಸರಿ, ಇಲ್ಲ ಅಂತಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಲಿ ಸ್ವಾಮಿ.
Yes, let him file an affidavit. Let him file a better affidavit. Please. Yes. Learned counsel for appellant prays 2 weeks time to file better affidavit for condonation of delay in filing an appeal.
Serial number 48, Shantaraj K for appellant. Pradeep.
His claim petition has been dismissed, my lord. 35 days delay may be condoned, my lord. TCR may be called for.
Delay of 35 days in filing an appeal is IA 1 of 2018 is filed for condonation of delay. Peruse that affidavit. Delay of 35 days in filing an appeal is condoned. IA 1 of 2018 is allowed. Office is directed to secure original records from the tribunal. Yes.
Serial number 49, VC Shivanegoda for appellant, connected matter R Shashidhara.
For appellant, my lord.
Representing
Shivanegoda.
2 weeks time in urgently. For appellant, my lord, 2 weeks in time urgently.
R Shashidhar.
Yes.
Yes, Mr. Shivanegoda, what is this?
It's a case of death, my
ರಿಕ್ವೆಸ್ಟ್
lord.
ಮಾಡಿದ್ರಂತ ಏನೋ ಟೈಮ್ ಬೇಕು, ಫೈಲ್ ಏನೋ ಸಿಕ್ಕಿಲ್ಲ ಅಂತ.
ಯಾರಿಗೆ?
ಇವರಿಗೆ
Yes.
ಶಶಿಧರ್ ಅವ್ರು.
ಶಶಿಧರ್ ಅವರಿಗ. ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗದಮ್ಮ?
And for respondent number 6 from owner.
Owneriga. Then claimant himself is asking time.
No
No problem. Yes. At the request of counsel for the appellant in MFA 444/6 of 2019 is this matter of 2 weeks.
Serial number 50, Gopal Krishna N for appellant, Kailash Shankar PS, B Pradeep.
They have 274 days. This case also delay may be condoned, my lord. TCR is required. Claim petition has been dismissed.
Yes. IA 1 of 2018 is filed for condonation of delay of 274 days in filing an appeal. There is that affidavit for the reason stated in the accompanying affidavit. Delay of 274 days in filing an appeal is condoned. IA 1 of 2018 is allowed subject to condition. In case appellant is succeeded in this appeal, not entitled for the interest for a period of 274 days. Yes.
Serial number 51, Kashinath JD for appellant, HS Lingaraj.
This case,
They are not served the copy of the appeal memo. Today. Now they have received copies, my lord. Next week.
Copy. Yes. Use this matter next week at the request of
Next
respondent.
week, my lord.
Date may be fixed, my lord.
Next week antandre next Wednesday.
After 2 weeks.
Yes, 2 weeks you want.
19 matter.
Yes, leave this matter up to 2 weeks.
Serial number 52, Mahadev Swami P for appellant, connected matter HC Rishabhendraya.
My lord, I am for the appellant in this case. Act policy, Swami. Pillion rider in the act policy. In the two-wheeler, my lord.
Two-wheeler act policy cover ilva?
Act policy.
Yes, Mr. Pradeep.
Two-wheeler act policy.
Act policy two-wheeler pillion rider cover ilva? It is there.
Not covered, my lord.
Not covered.
Lot of statement ಇದೆ.
Several judgments.
Yes.
ನಾವೇ ಮಾಡಿದಿರ ಸರ್. Supreme Court pending, but it has not been decided so far.
I think, yes. Raju ಎಲ್ಲ ಹೇಳ್ದಂಗಿತ್ತಲ್ಲ. It was been referred to larger bench ಅಂತ.
ಫರ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಡಿಸಿಷನ್ ಆಯ್ತಾ ಮೊನ್ನೆ?
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು ನೋಡೋಣ, ವಿಲ್ ಪೆಂಡಿಂಗ್. ಎಸ್. None appear for the appellant in MFA 3572 of 2019. I think this has been reserved for orders. Mukund Devagan.
Mukund Devagan is in respect of driving license, my lord.
That is regarding transport
Endorsement. But here is
Mukund Devagan again referred to the constitutional bench. Last week it has been reserved after hearing that.
ರಂಭಾದೇವಿಯಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಮಾಡಿದ್ರು ಮತ್ತೆ
reference ಮಾಡಿದ್ದಾರೆ.
Now that judgment has been reserved, maybe it will come shortly.
This is the case where there is no, he has not paid the additional premium.
ಅಲ್ಲ ಆಕ್ಟ್ ಪಾಲಿಸಿ ಪಿಲಿಯನ್ ರೈಡರ್ ಕವರ್ ಆಗುತ್ತೋ ಇಲ್ಲೋ ಅಂತ.
ಅದೊಂದು ರೆಫರ್
That
ಆಗಿದೆ.
is also matter has been referred. Let us see. Yes. ಏನ್ರಿ ಸ್ವಾಮಿ?
ಮಲ್ಲ ಥರ್ಡ್ ಪಾರ್ಟಿ ಪಾಲಿಸಿ ಅದು ಎಲ್ಲಿ ಸೇರ್ಬೇಕಾಗತ್ತೆ ಸ್ವಾಮಿ?
Yes.
Act policy.
Office is directed to secure original records from the tribunal. Yes.
Serial number 53, O Mahesh for appellant, connected matter, PV Kalpana.
For appellant, my lord.
Lord, I appear for the appellant. I have sought for Lord, substituted service to R to the owner of the vehicle.
ಹಾಕಿದಾರ?
I will pay process, my lord, during the course of.
Who?
And for the.
In the connected matter? Yes, we'll come first. His matter will, yes. IA 1 of 2023 is filed for substituted service of notice by way of paper publication to respondent number 2 in Samyukta Karnataka
Bangalore edition.
Daily newspaper circulated in Bangalore edition.
Bangalore edition.
For the reason stated in that accompanying affidavit, IA is allowed. Appellant is permitted to take out notice to respondent number 2 by way of substituted service in Samyukta Karnataka Daily newspaper Bangalore edition on or before
25th September,
hearing date
23rd October.
in MFA Krabale, second matter. Learned counsel for the appellant prays weeks time to do the needful.
Yes.
Serial number 54, Muralidhara MB for appellant, PC Shivanegowda. Serial number 54,
Muralidhar MB. Putri. There is a delay of 27 days in filing appeal. IA 1 of 20 is filed for condonation of delay. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 20 days in filing an appeal is controlled. IA 1 of 20 is allowed.
serial number 55 Arjan, serial number 56, Bhatta Ramachandra for petitioner, PM Siddhappa.
Petitioner in this matter. I have filed application, Lord, to recall the order of dismissal of the writ petition dated 14/6/2024, my lord.
Why it is dismissed?
My lord, on 13/6, my lord, I made my sincere efforts to, my lord, to verify the cases posted for me, my lord. Lord, some difficulty, my lord, are there to, in my records, my lord, there I could not ascertain, my lord, the case was posted on 14/6. Therefore, my lord, on 14/6, not a report dismissed for default. There was an interim order granted by this honorable court, my lord.
Now, who are you?
I am the purchaser, my lord.
What has happened to before the DC, AC and DC?
My lord, after 24 years, 1963, my lord, is the purchase. My lord, after 24 years, my lord, they have approached, my lord, for resumption of the 24 years, my lord.
No. When you have purchased, first sale?
63, my lord. 1963, the first purchase.
1963.
63, my lord.
Grant?
Grant of 1946.
46. 63 is the first purchase.
Please, my lord.
When that application for?
My lord, 2016, my lord, they have approached, my lord, the assistant commissioner.
Anyhow, it is-
1981, my lord, first order was passed, my lord, for.
Yes, Mr. Siddhappa, will recall that order.
Your lordship may, after it was dismissed and they not filed any application within the time. The subsequent development, I don't know.
Not subsequently, my lord.
Formally, my objection may be recorded and.
Yes, have you filed an application for stay?
Please, my lord.
Yes,
What is the-
Application, my lord,
For
interim order
which I am
already,
objecting, madam, I will file objection.
my lord,
Because
interim order was already there. And it was granted on 7/3/2017, my lord. After hearing both the parties, it was in operation, my lord, when the order was made.
After dismissal, it will not be in the operation.
not.
My lord, I have not requested for revival of the order also in my application, my lord.
No, then you have filed an application for stay. Let him.
I will have to file objection.
My lord, one more thing. After this, my lord, they started interfering with the possession of the property, and there was an order. I have filed an application, my lord, today, my lord. It's the IA number 3 of 2023-24, my lord, wherein I have sought for stay of that order, my lord.
That is what that. See, now to grant any interim order, in between that period, what has happened, we have to know.
Oh, there is an order, my lord. I have got stay of that order, my lord.
No, after dismissal, how can the stay will be operated?
My lord, that's what I'm saying. After the, my lord, the order of this honorable court, my lord, they approached the assistant commissioner, my lord, to implement the order, stating that there is no the order of the honorable high court. My lord, he passes an order, my lord, that possession should be taken on 31/7/2024. IA number, my lord,
After
IA number
that
3.
position has been taken.
No, not taken, my lord.
What is that? He has to.
I may be given opportunity to file
He'll have
objection.
IA number 3, my lord, I filed, my lord, seeking stay of the order.
After considering my objection,
Consider
your
that,
lordship
yes.
please request me.
IA 1 of 2024 is filed for condonation of delay of 35 days in recalling that order. Filing an application for condonation of delay of 35 days in recalling that order dated
16/4.
6/2024. Heard the learned counsel for the parties. Peruse that affidavit. For the reason stated in that accompanying affidavit, delay of 35 days in filing an application for recalling that order is condoned. IA 1 of 24 is allowed. Consequently, 2 of 2024 is allowed. Order dated 14/6/2024 is recalled. The writ petition is restored to the file. Please this matter next week.
Lord,
For
tomorrow,
consideration of IA 3 of 2024.
tomorrow, there is threat of, my lord, disposition of the property. Since 63, I am in possession of the property, my lord. Kindly be tomorrow, my lord.
Who is dispossessing you?
My lord, the assistant commissioner, my lord, order.
Has he passed an order?
Lord, he has given direction to the, my lord, the village accountant, my lord. That is what IA number 3 of 24, my lord.
You see the rule, how the position has to be taken.
That has not been done, my lord. In spite of that,
If you're doing something else contrary to the
no,
law. then
section
you-
39, my lord, contemplated the procedure, my lord. Ignoring that procedure, my lord, your lordship may kindly see IA number 3 of 24.
Yes, we have to give an opportunity for him to file.
Tomorrow, your lordship may kindly.
Not
How
tomorrow,
can,
Monday.
after 35 days, you know, at least
then-
ನಮಗೆ
ಅಲ್ಲಲ್ಲ ನಾಡ್ದಾಗ ಹಾಕೊಳ್ಳಿ.
verify ಮಾಡಿ.
ಶುಕ್ರವಾರ ಆದ್ರೂ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ. ಶುಕ್ರವಾರ.
ಕೇಸ್ ಕರೆದಾಗ ನೀವು ಇರ್ಲಿಲ್ಲ.
ತೊಂದ್ರೆ ಆಯ್ತು ಸ್ವಾಮಿ.
ಆಮೇಲೆ ಅವತ್ತಿನ ಸಾಯಂಕಾಲ ಅಟ್ಲೀಸ್ಟ್ ಏನಾಗಿದೆ ಅಂತ ನೋಡ್ಲಿಲ್ಲ ನೀವು. 35 ದಿನ ಅಂತ ಅಂದ್ರೆ
ನಮ್ಗೆ ಅದು ನಾವು ನೋಡಿದ್ರೆ ಆ ದಿನ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. ನಮ್ ಕೇಸ್ ಹೆಸರು ತೋರಿಸ್ಲೇ ಇಲ್ಲ, ಆದ ಕಾರಣ ಪ್ರಾಬ್ಲಮ್ ಆಗೋಯ್ತು.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ
ಅಲ್ಲ ಸ್ವಾಮಿ, ಫ್ರೈಡೆ
30 days ನೊಳಗೂ ಅರ್ಜಿ ಹಾಕಿಲ್ಲ.
ಆಯ್ತು,
ಅಲ್ಲ
ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ
ಈ ಫ್ರೈಡೆ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ.
ಪಿಟಿಷನ್ ಇಸ್ ರೀಕಾಲ್ಡ್.
ಈ ಫ್ರೈಡೆ
I don't think he will do anything. Yes.
ಈ ಫ್ರೈಡೆ ಹಾಕೊಳ್ಳಿ.
Yes, mister.
ದಿಸ್ ಫ್ರೈಡೆ ಇವರ
ಮಂಡೇ ಆಯ್ತು.
ಯಾಕಂದ್ರೆ let them not precipitate the issue at least.
Monday we'll see.
ಈ ಫ್ರೈಡೆ ಹಾಕೊಳ್ಳಿ ಸರ್.
Monday. Yes, leave this matter.
31st ಹಾಕೊಳ್ಳಿ. 31st Saturday working day.
Monday. Yes.
Cell number 57.
Yes.
Sridhara PE for petitioner, connected matter, Nishant GK.
That's 57.1 my lords, I appeal for the petitioner. My lords.
Yes.
My lords, I seek a week's time, my lords, to comply with office objections.
IA 1 of 23 for paper publication filed by whom?
That is 57 my lords, even 57.
Yes. Where is IA? Why 2 petition has been clubbed?
We are the purchaser. 7637/2020, we are the purchasers. I am the representing for the petitioner.
In that 757.1, you are also purchaser.
Purchasers.
2 purchaser on 2 different part of the property. Yes. Two, 6 to 8. Who are the 2, 6 to 8? Right. First matter, learned counsel for the petitioner has filed IA 1 of 2023 seeking permission of this court to substituted service of notice to respondent number 2, 6 to 8 by way of paper publication in Vasadiganta Kannada daily newspaper. Ill circulated rings. Yes. For the reason stated in the accompanying affidavit, IA 1 of 2023 is allowed. The petitioner is permitted to take out notice to respondent number 2, 6 to 8 by way of substituted service in paper publication, Vasadiganta Kannada daily newspaper on or before
25th September,
hearing date
23rd October.
Yes, what is this in your case, Mr.?
My case, not.
Second matter.
Amendment of Proceedings.
7637, the interim order may be extended for this. 7637/2020.
You are appearing for
I am for petitioner.
Sridhar B.
Out.
Then which is that Vasadiganta, which is that edition, Mr.? Vasadiganta paper, which edition you have to take? Is it Bangalore or Mangalore, Mysore? You have not said.
Bangalore.
Where is the parties are situated?
Bangalore only.
Then you have not stated that. Where are the parties? Who, Mate?
Respondent number.
2 to 6. 2 is Bangalore. 16, huh? Yes, Bangalore. 6 to 8.
6 to 8.
6 is residing Bangalore. 7 Bangalore. 8 Bangalore. Bangalore edition. Bangalore edition. That's not new. Yes.
Interim order.
Interim order granted earlier, if any, is extended till next date of hearing. What about that second matter?
There are 2 office objections. I'll comply. Your lordship may.
Yes,
fix it.
second matter. Week's time is granted to comply the office objection.
Interim order may be extended.
Interim order granted earlier, if any, is extended till next date of hearing. Yes.
Much.
Cell number 58, Vasudeva Iyengar KT for petitioner.
Memo file, please, my lord, sir. May be dismissed as not press. Infectious.
Dismiss again. IA 1 of 2023 is filed for recalling that order dated 9/3/2023 for the reason stated in that accompanying affidavit. IA is allowed. Order dated 9/3/2023 is recalled. Writ petition is restored to the file. ಅದಾದ್ಮೇಲೆ learned counsel for the petitioner has filed a memo. ಅದರಲ್ಲಿ government advocate is directed to take notice for 1 to 3. Learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this writ petition as not pressed. Memo dated 28/8/2024 is taken on record. The above writ petition is dismissed as not pressed.
B group matter, serial number 59, M.H. Saukar for petitioner, connected matter, V.V.
I appear for the petitioner in this case, my lord. I need some short accommodation, my lord, in this case. In fact, last time also I took time also. This time afternoon I got some inconvenience.
19 years delay.
Same. Yes, Mr. Saukar, you are the purchaser.
Grantee.
I am the purchaser. I am the grantee, my lord. I am the grantee.
Your application is dismissed on the ground of delay.
That's correct, ma'am. On the ground of delay.
Yes, now
But,
that it is all
what has
subject to
happened, my
that
lord?
result of that constitutional
Common
validity.
order has been passed without there being a detailed inquiry with regard to each and
Yes.
individual case. My lord, I will submit.
He said he has got some medical issues. I said I will not oppose.
Yes, no, even then, it is all subject to that result of that. We'll have it after 3 weeks. Leave this matter after 3 weeks.
Serial number 60, adjourn.
ಏನ್ರಿ ನಿಮ್ದು ಸ್ಟೇಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿಲ್ಲ ಏನ್ರಿ ಅದ್ರಲ್ಲಿ?
Lord, now it is posted on 13th for argument of Advocate General.
Yes.
Serial number 60, adjourn. Final hearing matter, serial number 61, Ravi S. Samprati for
Yes.
Appellate.
ಮಧ್ಯಾಹ್ನ 2:30.
With your lordships kindly, my lord, serial number 68 and 69.
Serial number 59.
68 and 69. 68.
68.
Yes, my lord.
68.
My lord, I may be directed to take notice for Reliance, my lord, it is served unrepresented.
Yes. Yes. Respondent number 2 is served unrepresented. ಆಯ್ತು ಅವ್ರಿಗೊಂದು ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಬಿಡ್ರಿ ಅವ್ರು ತಗೊಂಡ್ಲಿ. We'll have it next week.
Any date may be fixed. Any date may be fixed.
ನಾನೇನ್ ಹೇಳ್ದೆ, let the matter may be posted final hearing ಅಂತ. ನಾನು final hearing ಹಾಕ್ಸ್ಕೊಂಡಿದ್ದೀನಿ. ಅದು ವಾಲಂಟರಿ ಆಗಿ ಆದ್ರೆ ಹಾಕೊಳ್ಳಿ. ನಾವು I will not come in there. But ನಾನು direction ಬೇಡ.
No, I will direct. You have any objection? I will direct him to take notice. If you have objection, I will record it and direct him.
I got objection.
Yes.
The matter has been listed for final hearing.
Yes.
It can't be directed.
Yes, learned counsel. The respondent number 2 is served unrepresented. Counsel for the petitioner has objection to directed to take notice for a standing counsel. Objection is overruled. D. Vijay Kumar is directed to take notice. Leave this matter after 2 weeks.
68 and 69, both the matters, my lord. 68 and 69.
69?
Same.
Yes.
Same.
Yes.
My lord,
Much
serial
obliged.
number 16.1 and serial number 16.2, my lord.
16.1
and 16.2. There is a interim order, my lord. It may be extended, my lord.
16.1 and 2. Nodi, if there is an interim order, ಅದು ಮೇಡಮ್ ಇದ್ರು ಅಂತ
Court of sir? Court of sir? ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಏನಾಯ್ತು ಅಲ್ಲಿ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಇತ್ತು, ನಾನು ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೆ.
33. Next week sir, next 1 week time ಕೊಟ್ಟಿದ್ದಾರೆ.
1 week. ಆಮೇಲೆ 35 ನೋಡಿ.
ಇದರಲ್ಲಿ 6 ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಆಟುಗೆ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಇದೆ. ಶರ ಏನಿದೆ ಅಂತ ನೋಡಕ್ಕಾಗುತ್ತಾ?
ಶರ ರೆಕಾರ್ಡ್ ಹೊಟ್ಟೋಯ್ತಲ್ಲ ಸರ್.
ಹೊಟ್ಟೋಯ್ತಾ?
ಡಿಸೀಸ್ಡ್ ಅಂತ ಇಲ್ಲೇ ಹಾಕಿದ್ದಾರೆ ಅವರು. ಇಲ್ಲೇ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ತೋರಿಸಿದಾರಲ್ಲ ಡಿಸೀಸ್ಡ್ ಅಂತ.
ಅಲ್ಲಲ್ಲ 35.
35.
35.
ಫಸ್ಟ್
Court of sir?
ನೀವು ಕೊಟ್ಟೇ ಇಲ್ಲ ಒಂದ್ಸಾರಿನು.
Pardon?
ಫಸ್ಟ್ ಟೈಮ್ ಸರ್, ಇನ್ನ ಒಂದ್ಸಾರಿನು ನೀವು ಕೊಟ್ಟೇ ಇಲ್ಲ. ಫಸ್ಟ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
First time ಸರಿ ಸರಿ. Okay.
Court of sir?
ಹೇಳಿ ಸರ್, ಹೇಳಿ.
Serial number 68 and 69 ಸ್ವಲ್ಪ ಫೈಲ್ ಅಲ್ಲೇ ಇಟ್ಟಿರಿ.
ಸರ್ ಒಟ್ಟೋಯ್ತಲ್ಲ ಸರ್ ಅವ್ರು ಬರ್ಕೊಳಕ್ಕೆ, ಬರೆಯಕ್ಕೆ.
ಹೌದಾ, ತಿರ್ಗಿ ವಾಪಸ್ ಬರುತ್ತಾ ಹೆಂಗೆ ಏನು?
3:30-4 ಗಂಟೆಗೆ.
ಹೌದಾ, ಯಾಕೆಂದ್ರೆ ಅದೊಂದ್ ಸ್ವಲ್ಪ ಇದು ತಗೋಬೇಕಿತ್ತು, ಅಪೀಲ್ ಮೆಮೊಗಳು
ಅಪೀಲ್ ಮೆಮೋ
ತಗೋಬೇಕಿತ್ತು.
ತಗೋಬೇಕು, ಕಾಪಿ.
ಹೌದೌದು. ಇಲ್ಲ ಶಾಂತರಾಜು ಕೊಡಲ್ಲ, ನೋಡಿದ್ರಲ್ಲ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ರು.
ಶಾಂತರಾಜ್ ಅವ್ರು ಅದನ್ನೇ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದ್ ನಾನು.
ಅದೇನೆ ಅದಕ್ಕೇನೆ
ಸಿಗುತ್ತೋ ನೋಡೋಣ ಅವ್ರಿಗೆ ಅಂತ.
ಅದಕ್ಕೇನೆ ಕೊಡಲ್ಲ ಅವರು ಅಪೀಲ್ ಮೆಮೊ.
ಅವ್ರು ಕೊಡಲ್ಲ. ಇಲ್ಲ ಅದನ್ನೇ ಹೇಳೋಗಿದಾರ ಅವ್ರು ಸಾಹೇಬರಿಗೆ.
ಅದೇನೆ
ಕೊಡಲ್ಲ, ಕಾಪಿ ಹೆಂಗ್ ಸಿಗುತ್ತೋ ನಾನು ನೋಡ್ತೀನಿ ಅಂತ.
ಅದಕ್ಕೋಸ್ಕರನೇ
ಹಾ
ಒಂದೇನ ತರ್ಸ್ಕೊಳ್ತೀರಾ, ಅವಲ್ಲಿ ಬರ್ತೀನಿ ನಾನೀಗ.
ಸರ್ ಅವ್ರು ಸ್ಟೆನೋಗ್ರಾಫರ್ ತಗೊಂಡೋದ್ರು.
ಅಲ್ಲ ತರ್ಸ್ಕೊಳ್, ಎಲ್ಲಿ ಯಾರು ಅವ್ರ ಹೆಸರು ಹೇಳಿ?
ಅವ್ರು ಯಾವ ಚೇಂಬರ್ ಅಪ್ಪ ಅವರು? ಯಾವ ಚೇಂಬರು?
ಮೇಡಮ್ ಹೆಸರು?
ಸರ್
ಅವ್ರ ಹೆಸರು?
ಒಂದ್ ನಿಮಿಷ ಸರ್.
ಇಲ್ಲ, ನಾನು ಅವ್ರ ಹತ್ರ ಇಸ್ಕೊಳಂಗಿದ್ರೆ ಇಸ್ಕೋಬೋದಿತ್ತು, ಕೊಡಲ್ಲ ಅವರು.
ಅವ್ರು ಕೊಡಲ್ಲ. ಎಸ್ ಎನ್ ಸರ್.
ಹಾ
SN
ಅಂದ್ರೆ SN ಅಂದ್ರೆ
ಅದೆಲ್ಲ ಹೇಳಲ್ಲ ಸರ್ ಅವರು.
ಓಕೆ ಸರಿ. ಎಲ್ಲಿರ್ತಾರೆ ಅವರು?
ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅದೇ ಕೇಳಿ ಹೇಳ್ತೀನಿ.
ಇದರಲ್ಲಿ
ಓಕೆ ಸರ್.
ಅಲ್ಲ, ಈಸ್ ನಾಟ್ ನಮ್ಮ ಇದಲ್ಲ, PS ಅಲ್ಲ ನಮ್ಮ ಇವ್ರಿಗೆ, ಸಾಹೇಬ್ರಿಗೆ.
ಗೊತ್ತಿಲ್ಲ,
ಚೇಂಬರ್ ಇರಲ್ಲ ಅಲ್ಲ, ಚೇಂಬರ್ ಇರಲ್ವಾ ಅಂದೆ.
ರೆಕಾರ್ಡ್ ಕೊಡಕ್ ಹೋಗಿದಾರಲ್ಲ, ಅವ್ರು ಬಂದಾಗ ಗೊತ್ತಾಗುತ್ತೆ, ನಾನು ಕೇಳಿ ಹೇಳ್ತೀನಿ.
ಓಕೆ ಸರ್, ಓಕೆ ಬರ್ತೀನಿ. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಸೀರಿಯಲ್ ನಂಬರ್ 19ಕ್ಕೆ ಬೇರೆ ಯಾವ್ದಾದ್ರು ಅಪೀಲ್ ಇದೆಯಾ ಅಂತ ನೋಡ್ಬೇಕು. ಮತ್ತೆ 19 ಮೋಸ್ಟ್ಲಿ ಇವ್ರದ್ದು ಅಪೀಲ್ ಇರುತ್ತೆ ಕ್ಲೈಮೆಂಟ್ಸ್. ಏನಾಯ್ತು ಅಂತ ಕೇಳ್ತಾರೆ. ಹೇಳಿದಾರೆ ಕೇಳಲಿಲ್ಲ ಅಂದಿಲ್ಲ ಅಂದ್ರೆ ನಮ್ಗೆ ಹೇಳ್ತಾರೆ. 19 ಬೇರೆ ಅಪೀಲ್ ಇದೆಯಾ? ಇದ್ರೆ ಅವೇನಾಗಲ್ಲ. ಇಲ್ವಾ? Final hearing matter. Serial number 61. Ravi S. Samprati for appellant. Connected matter. PM Chandrasekhar. Harsha V. Amal.
ಯಾವುದು ಸೋಮವಾರನಾ? Yes, at the request of counsel for the appellant, please this matter next week.
Amal, complete. Serial number 62. B. Pradeep for appellant. Murthy DL.
ಇಲ್ಲಿ ಅವ್ರ ಮೂರ್ತಿ ಎಲ್ಲ ಇದ್ರಲ್ಲ. Okay. At the request of appellant, please this. Yes.
Serial number 63 adjourned. Serial number 64. Jagadisha SG for appellant. KJ.
Yes, KJID bank, you have. Notice ಮಾಡೋಣ. Yes. R3 is served unrepresented. Government advocate is directed to take notice. Is this matter next week? Yes, ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ. ಏನ್ರಿ ಮಹೇಶ್ ಅದು ಶಬ್ದ? Yes, this matter on 10th. Some sounds coming, Mr. Mahesh, from your chamber.
ಇಲ್ಲ, ಅದು ಕಾಂಪ್ಯೂಟರ್ ಅದು. ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಫ್ಯಾನ್ ಇದೆಯಲ್ಲ ಅದು ಬರ್ತಾ ಇದೆ. ಅದೆಷ್ಟು ಹೇಳಿದೀನಿ, ಅವ್ರು ಬಂದು ನೋಡಿ ಇದು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಅದು ಏನಾದ್ರಿ? ನೌ ಯು ಸ್ಟಾಪ್. ಏನದು ಮಹೇಶ್ ಅದು?
ಅದು ಫ್ಯಾನ್ ಇರುತ್ತಲ್ಲ, ಫ್ಯಾನ್ ಇದಾಗ್ತಾ ಇರ್ತದೆ.
ಅದೇನೋ ಇದಾಗಿದೆ ಅದು. ಎಸ್.
Serial number 65. Shantaraj.
ನಿಮ್ದೆ.
I appear for second respondent.
Yes.
Appellant O. Mahesh.
Yes, yes. ಯಾವ್ದೋ ಡಿವಿಷನ್ ಬೆಂಚ್ ಕೊಟ್ರಲ್ಲ ಮೊನ್ನೆ ಕೊಡಿ. Yes.
Minor age 12 years.
Yes.
Total amount awarded is 3,17,725.
Yes.
Rounded off to 800. 7% interest ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes, what is the disability? Criminal assessment.
ಅವರು ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಕೇಳಿದ್ದಾರೆ.
Yes. Nice.
Fracture of both the bones of right leg.
18% to that whole body. Yes, Mr. Mahesh, now the division bench has held that now we have to be taken as the notional income.
8,000 ಆಗುತ್ತೆ.
Yes, 8,000.
Date of accident is 28/9/2013.
2013, 8,000.
8,000.
18 multiplier.
Hmm.
Yes, Mr. Shantraj.
ಮೈನರು ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ ಬರೋದಿಲ್ಲ ಅಂತ ಲಾಸ್ ಆಫ್ ಅರ್ನಿಂಗ್ ಕೆಪಾಸಿಟಿ ಬರೋದಿಲ್ಲ.
Disability, yes.
ಅದು ಮಾಸ್ಟರ್ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಕೇಸಲ್ಲಿ ಇದ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
Yelly, where is the discussion?
Master Mallikarjun case may kindly be looked into.
No, that has been distinguished by this court and also subsequent Supreme Court.
Yes.
It is not in a straight jacket formula. Then Kajol case alala, it is. Now that our division bench has held, even in the 12 years minor this thing, they have taken that notional income.
What I'm saying, my lord, because he is a minor, minor cannot be gainfully employed.
Yes, I will consider your, Mahesh, I will consider your submission. Let him complete.
Yes.
Yes. £29 lower limit. The whole body is 10%. Yes. 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 Yes, in hospital idru.
ಅದು ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಬರ್ತಾ ಇಲ್ಲ ವಿಡಿಯೋ.
ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ. ಮೈಕ್ ಆನ್ ಆಗಿದೆ ನೋಡಿ.
ಆನ್ ಆಗಿದೆ ಸರ್, ಮೈಕ್ ಹತ್ರ.
ಇಲ್ಲ, ವಿಡಿಯೋ ಬರ್ತಾ ಇಲ್ಲ ಅವ್ರಿಗೆ. ಎರಡು ಕೋಡ್ ಬರ್ತಾ ಇದೆ.
ಮಾತಾಡಿದ್ರೆ ಬರುತ್ತೆ ಸರ್. ಅವ್ ಮಾತಾಡಿದ್ರೆ ಬರುತ್ತೆ ಸರ್.
ಆಯ್ತು.
ಆಯ್ತು, ಅವ್ರು ಅಷ್ಟು ಮಾತಾಡ್ತಿರು ಬರ್ತಾ ಇಲ್ಲ ಅಲ್ರಿ.
ಇಲ್ಲ, ಬರ್ತಾ ಇಲ್ಲ.
Yes, just you make some submission, Mr. Shantraj. It's not displaying. Now mic.
ಆನ್ ಆಗಿಲ್ವಾ?
Mic.
ನನಗೆ ಆನ್ ಬೇಕಾಗಿಲ್ಲ ಅನಿಸ್ತದೆ.
Now we can see that Shantraj is appearing. Yes.
Disability has been assessed by the doctor PW2 at 29.52%. As permanent physical impairment. When he has stated permanent physical impairment, question of taking 1/3 does not arise.
Yes.
Therefore, disability ought to have been taken at 29.52%. Adding future prospects ought to have been awarded the compensation.
Yes. How many days he was in that hospital?
Hospital 14 days. Patient readmitted at 28/3/2024, 29/3. Examine. Totally 9 days. 2 times he has been admitted.
9 days. What are that injuries, sir?
Fracture of both the bones of right leg.
Yes. Yes, that's all. Yes, Mr. Mahesh.
Yes. But my respectful submission, my lord, the injured is age 12 years
Yes.
and is still a student studying, my lord, in a 6th standard.
Yes.
He cannot be considered, my lord, for gainful employment till he attains majority.
Yes.
Because there is prohibition that minor cannot be employed, my lord. One thing.
Yes.
Then, my lord, this disability spoken to by the doctor, whole body disability has been taken.
Yes.
So therefore, my lord, the limb disability is not a criteria.
Yes.
Fracture of both the bones, my lord, when he grows up, my lord, he will overcome any disability.
Yes.
Therefore, my lord, therefore, my lord, the disability as canvassed by the council, my lord, cannot be considered.
Yes.
Therefore, my lord, minimum, my lord, what has been taken, my lord, 10% is reasonable.
Yes.
And question of future prospect does not arise when he is not gainfully employed at all.
Yes.
In what job he will be this thing, whether he will work or not, all in conjectures, my lord, not
Yes.
in. Therefore, my lord, what has been granted, 1,70,000, my lord, for injury, pain and suffering and loss of community supply, 1 lakh for disability,
Yes.
and 32,725 for medical expenses.
Yes.
For parent assisting, my lord, 15,000 has been granted
Yes.
with 7% per annum. It
Yes.
should have been 6%. Therefore, my lord, considering the overall this thing, my lord, what has been awarded by the, my lord, the tribunal is reasonable.
Yes. So learned counsel appearing for climate has contended that due to that accident, climate has suffered grievous injury. He has examined. The doctor has doctor evidence put right? Has assessed disability of 34% to right lower limb, 10% to that whole body. Tribunal has instead of considering the disability 34%, has assessed 10% is on lower side. He further contended that even though climate was a minor, aged about 12 years, division bench of this court in MFA 8572 of 2018, after considering that Master Mallikarjun and subsequent Supreme Court judgment in Kajal versus Jagdish Chandra and others, has considered that notional income and consider that multiplier as 18 and assess the compensation. He further contended that due to that extent, climate has suffered a grievous injury. He was inpatient for a period of 9 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Hence, he sought for enhancement of compensation. Per contra, Shri Mahesh, learned counsel appearing for insurance company, has contended that at the time of the accident, claimant was minor. He was studying in 6th standard. He was not employed. He was not earning. He is not an earning member of the family. Since the claimant was a non-earning member of the family and the minor, the apex court in case of Mallikarjun has issued in view of the apex court in Mallikarjun case, if the disability, considering that tribunal has rightly assessed the compensation, future prospects. He further contended that in respect of future prospects is concerned, the claimant is a minor. He is not gainfully employed. Therefore, he is not entitled for future prospects. Lastly, he has contended that considering that age and injury suffered by the claimant and medical records, the overall compensation awarded by the tribunal just and reasonable. The interest awarded by the tribunal 7% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 28/9/2013 due to rash and negligent driving of rider of motorcycle bearing registration number KA12 L7467. Due to that accident, claimant has suffered the following injury. Dr. Venkatraman Kumar has been examined as PW2. In his evidence, he has deposed that claimant has suffered 34% disability to right limb, right lower limb, and 10% to the whole body. Considering that evidence of doctor and medical records, I am of the opinion that whole body disabilities has to be assessed 10%. Even though claimant has the minor at the time of the accident and he was aged 12 years, division bench of this court in para 18 extract made. Considering that judgment of Master Mallikarjun and Kajol versus Jagdish Chand and others has granted a loss of income due to the disability by taking notional income. The accident is occurred in the year 2013. As per that chart prepared by Karnataka Legal Service Authority, notional income has to be considered as 8,000. The multiplier applicable to that age group is 18. Accordingly, loss of future earning has been reassessed as follows.
8,000 into 12 into 18 into 10%, 1,72,800.
Yes. Due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 9 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant is entitled for pain and suffering for 60,000. ಎಷ್ಟಾಗಿತ್ತಲ್ಲಿ 1 lakh?
1,72,800.
And loss of immunities is granted 50,000. The medical expenses ಅದು ಎಷ್ಟಾದ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ
ಎಲ್ಲ ಸೇರಿಸಿ ಪೇಯ್ನು ಅಮ್ಯುನಿಟೀಸ್ ಎಲ್ಲ ಸೇರಿಸಿ 1,70,000
ಅಲ್ಲ ಅದನ್ನ ಸಪರೇಟ್ ಮಾಡೋಣ. ಇದು ಎಷ್ಟು ಬಂತು 1 lakh? Plus 60. Plus 50. 82,000. ಆಮೇಲೆ loss of amenities. Attendance, nourishment and conveyances charges 20,000. Medical expenses ಹಾಕ್ರಿ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ರಿ. Medical expenses 32,725. Towards loss of income of the parents, towards loss of ಎಷ್ಟಾಯ್ತು ಅಲ್ಲಿಗೆ? Towards loss of income of the parents petitioner during the later period and rest period, 40,000. Marriage prospects, towards loss of marriage prospects, 50,000. ಎಷ್ಟಾಯ್ತು? Yes. Is there any evidence regarding future medical expenses?
But fracture ಇದೆ.
ಡಾಕ್ಟರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ಅದರಲ್ಲಿ ಒಂದು ಕೆಲಸ ಮಾಡಿ. Pain and suffering 75,000 ಮಾಡಿ. Yes, the enhanced compensation amount carries 6% interest.
Number 66, Banu Prakash HP for appellant, Rumpi Shrikant.
Respondent Insurance Company, my lord.
Yes.
Case of death, my lords. Date of accident to 12/6/17. The appellant number 1 is a husband and 2, 3 are the children's. The tribunal has taken the 4,500 rupees per month. Age of this is 55 years. my lord.
55 years.
Tribunal has taken 56 years.
What is that document to show that 55 years?
There is no documents.
Tribunal ಎಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ? Where is that?
56 ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ.
56.
56, but multiplier they wrongly used as 11.
ಎಷ್ಟು ಬರುತ್ತೆ 56?
9 ತಗೋಬೇಕು.
55 ಗೆ?
55 ಗೆ 11 ಬರುತ್ತೆ.
Mostly maybe 55. Where is the discussion?
Discussion
Para number
10. Para 10. Sorry, page 10, para 2 minutes. In page. The petitioner in her evidence, she has deposed that when the accident took place, her mother was aged about 56 years. She was well and healthy, and the deposed that the mother was working in the hospital, was earning rupees 10,000 rupees.
Her mother was aged 56, she was hale and healthy, further so and so. ಅಲ್ಲಿಗೆ capacity so and so deposit 56 years. You yourself have submitted it is a 56. 56 ಗೆ ಎಷ್ಟು ಬರುತ್ತೆ?
9.
9 madam.
11 ತಗೊಂಡಿದ್ದಾರಾ?
11 ತಗೊಂಡಿದ್ದಾರೆ.
That is wrong.
But instead of 4,500, 11,000 has to be taken.
4,500
11,000 ತಗೋಬೇಕು.
11,000. ಯಾವುದು ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್?
Plus 10%. Future prospect 10%.
ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ಯಾವತ್ತು?
17. 2012.
2017.
12/6/17.
11,000 ಡಿಡಕ್ಷನ್ ಎಷ್ಟು?
1/3.
1/3 ಕೋರ್ಟ್ ಆಫೀಸರ್ 11/3 1/3 ಡಿಡಕ್ಷನ್ 11,000. 10% ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ 10%. Multiplier 9.
9.
Yes, 30. So and so learned counsel appearing for. The claimant has contended that tribunal while assessing notional income has considered 4,500 per month. 4,500, 4,500 per month is on lower side. Even as per that Loka Adalat chart, the notional income for the accident occurred in 2017 is 11,000. Secondly, he has contended that In view of judgment of apex court in case of Pranay Sethi, 10% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. For contra, Shrikant, learned counsel appearing for insurance company, has contended that the claimant has not produced any document to establish his income. Considering his age and avocation, tribunal has rightly assessed notional income of the claimant as 4,500. Secondly, he has contended that since claimant has failed to establish his income, tribunal rightly has not granted future prospects. Lastly, he has contended that interest awarded by the tribunal 9% is on higher side. Considering that age and avocation of the deceased, the overall compensation awarded by the tribunal just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. What is the name of the deceased? Siddha Gangabai died in road traffic accident occurred on 12/6/2017 due to rash and negligent driving of driver of tanker bearing registration number KA16 C8140. Even though claimant has not produced any document to establish that income, the notional income has to be considered as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, notional income has to be considered as 11,000. At the time of the accident, deceased was aged about 56 years. The multiplier applicable to that age group is 9. In view of judgment of apex court in case of Pranay Sethi, 10% of the income of the deceased has to be added for future prospects. The 1/3 of the income of the deceased has to be deducted for personal expenses. Accordingly, loss of dependency has been reassessed as follows.
11,000 plus 1,100 at the rate of 10%, 12,100 minus 4,033 at the rate of 1/3, 8,067. 8,067 into 12 into 9, 8,71,236.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, who is first claimant?
Husband.
Second? Husband
Second,
already, huh?
Son and daughters.
Son and daughter, huh? First claimant is entitled 40,000 for spousal consortium. 2 and 3 is entitled 40,000 each for parental consortium. Enhanced compensation amount carries 6% interest.
Bill number 67, B.C. Tippeswamy for appellant, H.S. Lingaraj.
60?
67.
Yes, Tippeswamy? Yes, none appear. Leave this matter next week.
Serial number 68, 69 urgent, serial number 70, Sridhara Murthy for petitioner, connected matter, Muniyappa.
Yes. Yes.
My lord, I'm appearing at serial number 1, my lord.
Yes. You are appearing for?
My lord, I'm appearing at serial number 1, my lord. I'm sorry, my lord.
I beg to appear for the.
You are for petitioner.
Petition.
Yes, Mr. Yes, ready, both of them.
Yeah, we have engaged them, senior counsel, Kumar. In the meantime, we will.
Yes.
Let them stop.
Yes, you are ready. Yes.
This is a matter arising out of
restoration, my lord, proceedings commenced under Scheduled Caste, Scheduled Tribe, PTCL Act.
Yes.
My lord, one Chandrayappa is the propositor. Your Lakshmi kindly write the Chandrayappa is the propositor.
No, he is the grantee.
He is the original grant.
Yes. Chandrayappa.
Chandrayappa.
Yes.
My lord, he was granted 2 acres of land.
Yes.
According to petitioners, my lord, grant is of the year 1939. Though decision to grant was taken, my lord, in 1929-30 or 30-31. But actual grant was made according to the petitioners was in the year 1939.
Yes.
The grant certificates are not available. But original IL and RR, the copy of which we had been produced before the authorities.
Yes.
And according to that,
Yes.
my lord, there are 2 things, my lord, in 1930-31, grant proceedings initiated,
Yes.
which culminated, my lord, in 1936, whereunder it was brought for assessment of land revenue. And ultimately, my lord, the grant came to be finalized in the year 1938-39.
Yes.
This is the, my lord, finding of the assistant commissioner originally.
Yes.
According to me, preliminaries, be it 30-31 or 38-39 will not loom large. It may loom large, my lord, I'll explain it subsequently. After the grant of these 2 acres of land, my lord, in 1953, my lord, namely on 3/8/1953,
Yes.
this Chandrayappa, my lord, executes a sale deed
Yes.
in favor of one Chinnaswamappa.
Yes.
This is, according to the petitioner, is a sham document not intended to be acted upon. It was a loan transaction between.
No, you are appearing for the grantee.
I am appearing for the grantee.
Yes.
According to the petitioner, there was no transfer of title. Yes, there was a sale deed.
Yes.
Which was registered, never intended to be acted upon. The grant was for 200 rupees. My lord, the sale is for 200 rupees or so. In 1974, the Chandrayappa's family repurchases the land.
Yes.
At the time of repurchase, 1 acre 5 guntas, my lord, came to be registered in the name of Timmakka, who is the second wife of Chandrayappa.
1 acre?
5 guntas. $35 guntas, my lord, came to be registered in the name of Timmakka. 1 acre 5 guntas came to be registered in the name of Akkayam.
No, you said 1.5 in Timmakka.
No, I'm sorry, I stand corrected.
Yes. Timmakka guest.
Timmakka, 35 guntas came to be registered in the name of Timmakka, who is the second wife of Chandrayappa.
Yes.
First wife, my lord, Akkayamma.
Yes.
In her name, my lord, 1 acre 5 guntas came to be registered. This was in 1974 under 2 separate registered sale deeds.
First wife, 1 acre?
5 guntas.
Yes.
Now, these are all the
transaction of the year
1974. That is 10/10/1974.
Yes.
This becomes relevant for the reason that the Act came into force in 1978.
Yes.
As of the date when the Act came into force, the title continued with, my lord, the Chandrayappa and his family members. Notwithstanding the interregnum sale before whomsoever it has taken place, which was not intended to be acted upon or otherwise. And it was a sham transaction, and there was no statutory prohibition for sale or listing of land for their personal purposes, unlike, my lord, as the restriction as brought about under the Act.
Yes.
In 1978, Act comes into force. Under the Act, after coming into force of the Act, my lord, the family members of this thing, that is, the property was sold in favor of Ramachandra. 1 acre 5 guntas came to be sold in favor of Ramachandra on 30/6/1992.
Yeah, who has sold that Akkama? He sold to Ramchandra.
Akkayamma son Chennappa.
Is that property belongs to Akkayamma has sold now?
Was sold by Chennappa, her son.
To whom?
To Ramachandra.
When?
This on 30/6/1992. 30/6/1992.
Yes.
This is the subject matter of the first writ petition. The second writ petition, my lord, Timmakka in 1994 sells 35 guntas of land.
Yes.
That is the subject matter of the second writ petition.
Yes.
92 upon sale, my lord, the application, my lord, for restoration came to be filed. My lord, by Shardamma, the wife of Chennappa.
When?
This application came to be filed, my lord, which is numbered as case number 77 of 95/96.
Yes.
Somewhere in 95/96, this application for restoration came to be filed.
Yes.
Originally, the assistant commissioner allowed the application, which was carried in appeal. Appeal gets remanded. Upon remand, the assistant commissioner confirms the restoration order, against which deputy commissioner, my lord, has set aside this thing, stating that the application for restoration is not maintainable on 3 grounds. One is the land is not granted to an SC/ST as such, though there is a grant. The second ground on, because of the fact that in 1953 you have sold the land, Act is not applicable.
Yes.
These are the 2 grounds on which, my lord, the deputy commissioner, my lord, rejects the application for restoration.
Now, see, if they say the grantee is not SC/ST.
No. The finding is, the argument advanced by the respondent is that these are the persons who got converted to Christianity. Therefore, my lord, the act is not applicable.
No. Now that that has been accepted by that authority.
Authority proceeds on that basis.
No, if once it is accepted, you are not a scheduled caste and scheduled tribes member, then the question of that whether violation of the grant would not arise us to
Correct.
decide.
The fact that conversion to Christianity is to be proved by them. There is no such evidence adduced. When once they come out with a contention that they are converted to Christianity, it is for them to prove. Assuming that I have converted to Christianity, my lord, under the act, would I not continue to be a Dalit? There are 2 things. On the issue, my lord, the apex court has held that assuming, my lord, there is some conversion, my lord, he can always go back to the set caste and they are to be treated as such. This has been rendered under while interpreting the service law. Yes. My lord, while interpreting a social welfare legislation, one need not go to that effect. The conversion otherwise does not matter. Yes. What matters is originally whether the social status, even today, there's a judgment. I'll place all those judgments on record. Therefore, when once they plead the conversion, they have to prove the conversion. They have to lead evidence on what date I got converted, what happened subsequently, so on and so forth. Assuming that there is no such this thing, even then, even today, they are called Dalit Christians. That hardly matters, and that cannot be brought into to see that the social welfare legislation is kept out of the purview of this. That is one aspect of the matter where authorities have not applied their mind and have not addressed it on this issue. The second ground is sale in the year 1953.
Yes.
is irrelevant. For two reasons. What is required under the Scheduled Caste, Scheduled Tribe Act is that as on the date when Act came into force, there should have been an alienation which is, my lord, under challenge under the Act. Otherwise, the Act, my lord, 4(1) rigor will not apply. Earlier, if I sold and I purchased,
Yes.
that according to me is a nominal sale deed never intended to be acted upon. If that is, my lord, accepted, there is no sale at all. The title always remained with him. And there was no statutory restriction as such from sale. There two issues would arise. Supposing your lordships come to the conclusion that the grant was of the year 38-39, then the sale is within 15 years. The grant, according to them, in 38-39, my lord, according to it, there is a permanent non-alienation clause.
Now that what is the finding of the authority regarding that grant, when it is granted?
According to the present one, the grant, my lord, is of the year 30-31.
That is the finding of the
That
authority.
is the finding of the deputy commissioner. Assistant commissioner holds otherwise.
What is said?
38-39.
38-39. What is that condition in 38-39?
38-39 permanent non-alienation clause.
No, but 38-39 finding has not been challenged by them.
They are not challenged. No, deputy commissioner is the final authority, which says that the grant is of the year 30-31.
30-31. 30-31, what is the condition?
30-31, there was no condition at all. It was the grant certificate which contemplated. Or 20 years or some such thing like that.
10 years.
10 years.
What is that sale?
53 is the first sale. My lord, I have two twin submissions as I was making it out.
Yes, yes.
53 sale does not, my lord, affect
That you have any records, mister?
original records are to be summoned because
Get the records. Now that basic thing first we have to find out when the grant. Then conditions and all.
Correct.
See, suppose if this court come to the conclusion that this grant is that on 31, then condition is 10 years. Even whether he has sold it or not, anything, that sale is after that condition. We need not go to that all this.
which sale, my lord? Which sale? First sale.
Yes.
First sale has no application. According
It is
to
an
the-
absolute sale deed, my lord.
Maybe.
Wait,
Sorry,
wait.
absolute sale deed.
Even assuming
No recital is there.
No, that's all right.
Absolute sale deed.
All right. We will go to
No.
the extent of saying that it was an absolute sale deed.
Yes.
Would it go out of the purview of the granted land is the question of law. For the reason that as on the date of the act coming into force, the title vested with the applicants. If as on the date when the act came into court, title vested with the applicants of which there is no dispute,
Yes.
there is no question of going prior to say that the act is not applicable. After coming in, as on the date when act came into force, if the original grantee had no title to the property and he is seeking to avoid the sale deed, taking shelter under the act, then only act will apply. That is for the purposes of section 4(1). Now what comes into operation, if your lordships, my lord, agree with my contention, that without prior permission, could there be a sale because sale is after that?
Now that we have to find out, is there any sale in that year 1953?
There is sale. I don't dispute that.
See, if you make out in a case that there was no sale in 1953, then after 1979, permission is required. Now, condition is not immaterial.
Supposing I purchased before the act coming into force.
Yes.
First, by contention.
Now, your contention is that you have purchased that property back, then it is again that it is a granted land in your hand.
The character of a granted land.
Yes, that point has to be considered. Yes.
That is the first time this case has arisen, this issue has arisen. My lord, we are all waiting for your lordship decision on that.
Get that records, mister.
That is the first thing.
Yes.
The second one is whether it is a nominal sale deed not intended to be acted upon. This I will establish for the reason that after the sale in 1953.
No, now
What is it?
that both of them has to be addressed. even assuming that there was a sale in the 1953, that now that subsequently you have purchased that property,
In 1974.
whether you have become that absolute owner of the property or as it is to be in a granted land
Correct.
under that
I
SC.
I am obliged.
That point has to be
That
addressed.
point has to be addressed by your lordship. The second point is, though there is a registered sale deed, I can always establish before a court that is a sham document, nominal document, not intended to be acted upon, as held by the apex court. If that
Was
will-
no any judgment on that point that subsequently grantee has purchased,
no judgment. I tried my level best. I've
Yes.
been, my lord, trying.
whether then he can apply under SC/ST Act or
Yes,
not. That is
there
the,
is no judgment. To my knowledge, I have not come across it. I
anyway,
will,
first you get
I will
that
further
records.
research, my lord, but that is the
Because I think conversion of that Christianity would not arise just because grant is for SC/ST. If it is not goes to you, it will goes to government.
Government. That is one thing.
The intention of that to see that it should be goes to that government.
Therefore, original record will have to be looked into by your lordships to satisfy your lordships as to the year of grant. And just because in the original grant, it is stated as DD, Darkhast grant.
No, DD, Darkhast grant, deprived class grant, Darkhast grants, yes.
Darkhast grant.
Yes.
It has not stated as grant in favor of a scheduled caste. That's the reading of the deputy commissioner.
We can see that grant certificate.
Therefore, grant certificate itself would be the original grant. That is one.
Lordship kindly, the earlier courts have made any attempt to bring the record.
I don't know,
It
my
is
lord.
not
I'm not
available.
available.
He has came recently on the record.
No, without records, they can't decide that. DC and DSC, how they have come to the conclusion it is 39 without that records.
On the basis of the revenue records.
That all that, whatever that original records which is pursued by that DC and DSC, we have to be seen. You secure that records when you have decided that there should
The
be.
argument of the respondent itself is that there is a grant. It is, but there is a conversion. That the case,
Now that they are not disputing grant in your favor,
they are not,
their contention is that
I'm converted to
converted.
Christianity.
Now, if they are not disputed the grant, now I have to know when it is granted.
Correct.
Yes. And
Or there
it
is
is
no-
an absolute sale deed. There
That's
is
all
no,
right.
That is second question.
that is second.
There, my lord, preliminary submission of mine is subsequent to the sale of the year 1953, possession was not handed over to them. I continued in possession. All the revenue records are in my name only.
On oral
This is
submission.
one of the indications to.
Without there being any document.
I have
No,
put it-
instead of that, whether you are in the possession or not,
Yes.
once you sold it, again you purchase by market price, whether still you hold a grantee or not.
Granted land or not.
That is the point you have to.
That is, no, if it is, if your lordship hold that, that is a sale, nominal sale deed, not intended to be acted upon, there is no sale at all.
No, when you have purchased, why you have purchased?
Correct. Because it was a security for the loan. My lord, many times it happens.
No
in our-
such class has
All that you
mentioned.
see that in the sale.
Correct.
No such class has been mentioned.
Sale.
And sold is by somebody, purchased by
The
somebody.
Honorable Supreme Court has held, Honorable Supreme Court has held that a person can take a defense that the sale is never intended to be acted upon, notwithstanding the registered sale deed. If when once there is a sale deed and repurchase in my favor, I can always say the title always vested it me.
That will-
After 25 years.
I will bring home that point.
Yes.
Because the
After
ultimate
25
issue
years.
is, my lord, the effort to take out from the rigor of SC/ST Act cannot be, my lord, undone by
No, no,
this.
see, I think for conversion, it will not give any this thing. Only thing is that once you have purchased, whether you are losing the title of a grantee or not.
Correct. Yes, that's one.
That is the point, because what is that PTCL Act says that land which is granted to that scheduled caste, if any persons is purchased, either you grant it to that original grantee, if they are not available LRs, or go to that government. If you are converted, it is proved, then it will go to the government. Because it is a government property.
It's a government property.
But now the contention is that it is After purchasing, you are losing the title as a grantee. That we have to be.
Would I lose or not is the question.
Yes, that we'll see that.
That you lost.
Yes, your executive. If you are getting records tomorrow, I will give the date. What is the use if you are not getting? Yes.
Next week.
Leaves this matter. Next week, our in Tarsala on 18th. Yes, get that records. Yes.
It's an interesting issue. First time it has
Yes,
cropped
yes,
up.
yes. We'll also examine that. Yes. I have also not come across.
I have not
this.
come across this kind of a fact situation.
Sale deeds have acted and it is an admitted fact. After 25 years, there is no recital. Absolute sale deed, very clearly. Correct.
Even Muniappa, even assuming that he has purchased, whether the title of grantees goes or not,
Goes or
we have
not,
to
yes.
see. Even you are
Sold by somebody, purchased
The
by somebody
original-
after 25
My lord,
years.
original purpose.
He claims that no title
The
has
grant, my lord,
there is no,
I
and in the
submit,
sale
my lord,
deed he says it is a self-acquired
but
property.
it doesn't.
No, the point is that he has no right because it is in a government property.
Government
On the
property.
other hand, it is, you can give it to somebody, but title still vested with the government. That has to be seen.
They are sold in 1953,
Hmm.
73 purchased by others. No, not
By own
the
children.
same person who has sold.
My own
Not
children.
the same person who has sold.
Even if it is purchased
And then
opening,
further they have sold
all,
it.
all transaction is contrary to the law. Whether it will sustain or not,
yes.
we'll see that all.
Whether the first sale deed is in contravention of the act or not, that is the question. Right?
Yes, we'll see that. You
Your
get the record.
Lordship's permission. The
To
first
see that first still the sale deed is not contrary to that condition,
Yes.
we have to find out the original grant date.
Yes.
That is that now authority has to establish before the court saying that this is the actual grant date. If the
Even
date is not.
He
forthcoming-
relies on, how can he relies on two grants, my lord? One in the year 1932, one in the year 1939.
That now that it is for the authority.
My lord, a
The
decision of
person
the
who comes to
authority
the
to
court,
grant is one thing.
a person who has
Actual
filed
grant
an
is another
application
thing.
under section 4, he has to prove that he belongs to SC/ST and
That is
the
accepted
land has been
because
granted.
Their
All
case
that
is that I
things-
got converted.
Primary issues on him to prove that all that facts.
Yes, we'll see that.
Your
We'll get that
Lordship's
record.
permission, the name of the first matter, only Muniappa is there. K. Ramesh Raman Muniappa should come.
ಯಾವ್ದು?
First 13,806. ಎರಡನೇ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಬಂದಿದೆ.
ಅಲ್ಲ ನಿಮ್ದು ಯಾರಿಗೆ?
We are for the R3, third
Respondent.
respondent. We both are appearing together.
Respondent Muniappa and
K. Ramesh Rao.
yes, office is directed to show the name of K. Ramesh Koda along with that Muniappa
Yes.
for R3. Yes.
Much obliged.
ಇದ್ರಲ್ಲಿ ಅದರ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ ಇಲ್ಲ R3. K. Ramesh Rao and Muniappa.
Yes.
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇದೆ.
Second matter.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅದೇ ತರ ಮಾಡಿ.
First our matter, serial number 1, Sappannan our Basavaraj for petitioner.
My lord, I am appearing for petition, my lord. My lord, it is a PDCL case, my lord.
Yes, Mr. Rappanna.
My lord, the land measuring 2 acres was granted in favor of our father by virtue of grant certificate dated 5/4/1956, my lord. Annexure A, my lord. Annexure A is the grant certificate dated 5/4/1956, by virtue of which the land was granted to my father. And my lord, thereafter respond number 1, behind our back, has managed to get the sale deed from my father, that is Annexure B. He got the sale deed on 1/3/1978. Thereafter, my lord, I have filed I have raised the dispute before the respond number 2, that is Assistant Commissioner. Thereafter, in the proceedings before respond number 2, a compromise petition came to be filed. Annexure C, my lord, that is a compromise petition, page number 35, that has been filed by the petitioners and the respond number 1. In the said compromise petition, the respond number 1 has clearly stated in page number 35, my lord, paragraph number 3 and 4, it is a nominal sale deed. He has got it for nominal sale deed amount, and it is not.
Government advocate, what is this? No, that you are a grantee or a purchaser.
I am the grantee, my lord. I am the
No.
land has been granted in my favor.
What has
My
happened to
case-
that DC?
DC
Assistant
has
Commissioner?
the assistant commissioner has allowed my case, allowed my application. He has set
then-
aside the sale deed, land has been restored to me.
what
Thereafter,
DC?
or annexure, my lord, DC has allowed the appeal preferred by the respondent number 1
On what ground?
on limitation, my lord. Your lordship may kindly have a look on page number 58, last portion, page number
Yes.
58, last 4 lines, my lord. Accordingly,
Nikanti
he has-
Rama Lakshmi case ಮೇಲೆ ಮಾಡಿದಾರಾ?
he
Yes.
has relied upon a certain. My case is that, my lord, now, as
Yes.
lord knows, amendment has
Government-
to section 5 of the
Yes.
act by inserting clauses C and D.
Yes.
Clause
No,
C
that-
clearly says that notwithstanding anything contained in any law, there shall be no limitation of
Yes,
time.
yes, yes. Yes, Mr. Issue is pending before this court regarding constitutional validity. Yes.
Yes, my lord.
Now that on Nikanti Rani case, they have decided.
A time
The,
limit.
DC. Yes.
Yes, my lord.
Government advocate is directed to take notice for 2 and 3. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate, issue emergent notice to 1.
My lord, respondent number 4 to 9, 11 are the former parties. I have stated therein because they are all my brothers and sisters. Respondent number 4 to 11. Respondent number 4 to 11, my lord.
Who are there?
They are my brothers and sisters, my lord. Respondent
Then
4 to 13.
who is the purchaser?
Purchase respondent number 1, my lord.
Purchaser?
Respondent number 1 is the purchaser. Respondent number 1, my lord, Srinivasa is a purchaser.
Yes.
4 to
Issue
7,
emergent
11
notice
are my family members.
Respondent number 1. Learned counsel for the petitioner. He filed in a memo, Mr. Filed in a memo.
I will file memo, my lord. I have stated in my petition, but I will file a memo, my lord. I have stated in my petition in para number 18, my lord.
Yes. For 4 to 11 filed in a memo for seeking a dispensation of notice. Memo is taken on record. Notice to respondent number 4 to 11 is dispensed at the risk of the petitioner. Stay of annexure E dated 31st. What is this, Mr.? When that DC has passed an order?
31/10/2018, my lord. That
2000?
I have sought for stay of that order, my lord.
No, when the order is passed?
31/10/2018, my lord.
Then you are seeking a stay for the order passed by the DC after 4 years. Why? No stay, you take notice, Mr. Yes.
Till then, there may be an order.
No, Mister. We don't know what has happened after 8 years. Yes.
Obviously.
Yes,
Sri
notice.
Shankar Reddy.
Stay, bada. Yes.
Was not present in the morning, Lord.
Yes, Reddy, what is this?
Lord, grantee is before this court, Lord.
Yes.
Lord, Muniramaya, Lord, is the original grantee.
Yes.
Lord, the grant is of the year 1962, 7/9/1962. Lord, he sells the property on 9/5/88.
62, what was the condition?
Lord, non-alienation for a period of 10 years.
10 years. Yes, when it is sold?
Lord, 9/5/1988.
88.
After the act came into force.
After that came. Yes.
Lord, subsequent to the death of Muniramaya, Hanumakka, my lord, the wife, filed a petition for restoration.
Yes.
Assistant Commissioner allows the same. And the purchaser, my lord, the 4th respondent before this court, files an appeal before the Deputy Commissioner. Deputy Commissioner, on the ground of limitation, allows the same.
On Supreme Court judgment.
And 1 month before the death, before the order passed by the Deputy Commissioner, the respondent is dead. Against a dead person, order is passed without the LRs being brought on record.
Yes.
I placed on record the death certificate indicating the date of death that your honor can find, your lordships can find at page 18, 18.
Page, where is the DC order?
Not DC order. Is that annexure. Annexure J, may not, page number 61.
Who has dead?
The claimant, not the grantee's wife, who had filed a petition before the assistant commissioner. Assistant commissioner.
Anmaka is dead.
Anamaka is the respondent before the deputy commissioner. She died.
When is that date of death?
Your honor, your lordships can get it from page 18, 18. Death certificate 4/2/2023.
23.
1 month before the order came to be passed.
Yes, mister, then order has to go back. It is against the dead person. Who is that, this thing?
Not this coming for the first time.
No.
The respondent.
Govind Raj has to serve, wala? Yes, government advocate is directed to take notice for respondent number 1 to 3. Counsel for the petitioner is directed to serve 3 sets of copies. Issue emergent notice to respondent number 4. Stay of annexure J. Dated so and so till next date of hearing. Grateful.
Serial number
My lord,
4.
my lord, beg to be excused, my lord. Yes, serial number 1, it is dated 31/10/2022, my lord.
22 ne? Nodade nan 22. It is already 2 years over. Yes.
Serial number
Obliged,
4.
Yes.
Veemareddy as per petitioner.
Yes. Veemareddy. None appear for the petitioner. Leave this matter after 4 weeks.
Serial number 10. Avani Chokshi for petitioner. VD Raviraj.
Appear for the petitioner in this matter, your lords.
Where is the
The
Raviraj?
respondents are not appearing in this matter, your lords.
Stay is there.
Stay is granted, your lords.
To enjoy that.
It's a simple matter, your lords. If
Appear
your
for
lords
the
is right.
respondent. As a last chance. Week's time is granted. Interim order granted earlier is extended till next date of hearing. Use this matter of 2 weeks. Yes.
Grateful, your lords.
Serial number 19. B Palakshaya for appellant. SV Hegde.
None appear for the respondent. Please this matter after 2 weeks. Interim order granted earlier is. Yes.
Serial number 19. B Palakshaya for appellant. SV Hegde Mulkon.
19. Yes, Palakshaya Elli. Yes. ಬರ್ತಾರ ಅವರು ಪಾಲಾಕ್ಷಯ ಅದೇನು 20,000 ರೂಪಾಯಿಗೆ ಅಪೀಲ್ ಹಾಕಿದಾರಲ್ರಿ ನಿಮ್ KSRTC ಇಲ್ಲ ಯಾವ್ದು ಇಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು 20 ಬರೀ 23,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ ಅಪೀಲ್ ಹಾಕಿದ್ರು ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರು ಕೇಳೋಣ ಏನಾರ ಕನೆಕ್ಟೆಡ್ ಇದಾವ ಏನೋ ಅಂತ ಹೆಗ್ಡೆ ಸೆಡ್ ಕೊಡಿ
ಅಪೀಲ್ ಮೆಂಬರ್ಸ್ ಅಲ್ಲಿ ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಏನೋ ಇದ್ದು ಇದು ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಏನೋ
ಅಥವಾ ಬೇರೆ ಬೇರೆ ಎಲ್ಲಾರು ಹಾಕ್ಬಿಟ್ಟಿದ್ರೆ
ಅದೇ ಹಂಗೇನ ಇದ್ರೆ ಆ ಗ್ರೌಂಡ್ಸ್ ತಗೊಂಡಿದ್ರೆ ಓಕೆ
ಆತರ ಏನು ತಗೊಂಡಿಲ್ಲ
ಮತ್ತೆ ಹಂಗಾರೆ ಏನ್ ಬಿಡಿ
20,000 ರೂಪಾಯಿ ಅದಕ್ಕೋಸ್ಕರ ಬೆಳಿಗ್ಗೆ ಹೆಗ್ಡೆ ಸೆಡ್ ವಿಲ್
ಜಸ್ಟ್ ಆನ್ ರೀಸನಬಲ್
20,000 ಕಾಂಪನ್ಸೇಷನ್ ಅಲಾಂಗ್ ವಿತ್ ದಟ್ 9% ಇಂಟ್ರೆಸ್ಟ್
ನಾನು ಬಾಡಿನಲ್ಲಿ ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಏನಾದ್ರು ನಮ್ಮ ಮೇಲೆ ನೆಗ್ಲಿಜೆಂಟ್ ಇಲ್ಲ 2 ವೆಹಿಕಲ್ಸ್ ಇನ್ವಾಲ್ವ್ ಆಗಿದೆ ಅಂತ ಏನಾದ್ರೆ
ಫೈಂಡಿಂಗ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ rash and negligent is contrary to the evidence. Learned judge's error not properly appreciated. Judge, however, total compensation 20,000, 9% bad in law. Learned judge has failed to notice that driver is not rash and negligent. No tribunals bad in law. Aಷ್ಟೇ view of the judgment.
ಅಲೋ ಮಾಡ್ಬಿಟ್ಟು 9% ಇಂದ 6%.
That can be done. But anyhow, that will give one chance tomorrow.
ಸುಮ್ನೆ ಅನ್ನಸರಿ ಬೋರ್ಡ್ ಬರ್ಡನ್ ಏನಿಲ್ಲ.
That is what that I am thinking that I
ಹೇಳೋದು ಅಷ್ಟೇ ಇದೆ.
ಮತ್ತೆ ಇನ್ನೊಂದಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರಿಕಾಲ್ ಆಗ್ಬಾರ್ದು ಅಂತ ನಾವು ದಟ್ಸ್ ವಾಟ್ ದಟ್ ಐ ಆಮ್ ಥಿಂಕಿಂಗ್
ಏನಾಯ್ತು ಗ್ರೌಂಡ್ಸ್ ತಗೋಬೇಕು
ತಾಂಡಿಲ್ಲ
ಮತ್ತೆ ಇಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗ್ಬೇಕು
ಎಸ್
ಬೇರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್
so learned counsel appearing for so and so Shivamogga Bhadravati near so and so being driven by that don't same in rational negligence bypass road dash to that so and so learned counsel appearing for the corporation has contended that the accident is occurred due to the negligence of rider of the motorcycle bearing registration number KA 14 KJ 6986. The tribunal is error held that driver of the bus is negligent in causing that accident. Contended that it is very clear from that spot measure, rough sketch and IME report, the rider of the motorcycle is negligent in causing that accident. Secondly, he has contended that in view of judgment of this court, the interest awarded by the tribunal 9% is on higher side. The respondent claimant is served. Sri Hegde Learned Counsel appearing for insurance company has submitted that they are only a formal parties. Heard the Learned Counsel for the appellant. The specific case of the claimants that on 11/9/2015 at 10:45 AM, husband of the petitioner, the husband of the claimant, being a rider of the motorcycle bearing registration number KA 14 EJ 6986, was going to Shimoga. When they reached near MRC Circle on BH Road, the driver of the KSRTC bus drove the bus in rash and negligent manner, dashed against the motorcycle. As a result, this is for damages vehicle. Involvement of KSRTC bus, claim the compensation sustained motorbike. Yes, claiming compensation footage to repair. Yes, repair. Yes. Due to that, rash and negligent dashed against the motorcycle. As a result, motorcycle was severely damaged. To prove the case, claimant has examined herself as PW1. See, idರಲ್ಲಿ motorcycle damages claim ಆಗ್ಬಿಟ್ಟು idರಲ್ಲಿ they are not mentioning that rider is dead or not. Is there any other claim for death? ಅಲ್ಲಿ ಏನು ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಅದನ್ನ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಿತ್ತು, ಇಲ್ಲ ಅಂದ್ರೆ
ಯಾಕೆಂದ್ರೆ ಇದರಲ್ಲಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ, ಡ್ಯಾಮೇಜಸ್ ಇದು ಅದಕ್ಕೆಗೋಸ್ಕರ ಮಾಡಿದ್ರ, ಅದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅಂತ ಇದ್ರಲ್ಲಿ ಮಾಡಿದೀವಿ ಅಂತ. ಬಟ್ ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ಮೆನ್ಷನ್.
ಕ್ಲಬ್ ಮಾಡ್ಕೋಬೇಕಿತ್ತು ಕೇಸ್.
ಇಲ್ಲ ಅಂದಿದ್ರೆ ಮೋಟರ್ ಸೈಕಲ್ ಇದಕ್ಕೆ 20,000 ರೂಪಾಯಿಗೆ ಶುಡ್ ನಾಟ್ ರೈಸ್ ದ ನೆಗ್ಲಿಜೆನ್ಸ್ ಪಾಯಿಂಟ್.
ಕರೆಕ್ಟ್.
ವಿಲ್ ಸಿ.
ಪ್ಲೀಸ್.
Yes. None appear for the appellant. Leaves this matter on Saturday.
Serial number 22, Gopal Krishna and for appellant, Dev Jay Kumar.
Yes.
Claimant's appeal. Lordship heard this matter last week for some time. Case of injury.
Why it's urgent?
Because Lordship that day has
yes, I have to go to somewhere else. Yes. So, yes, what is this?
Appellant suffered severe head injury and fracture of both right lower limb and right upper limb. And orthopedic surgeon assessed disability whole body 63% and neurosurgeon assessed cognitive is 100%.
Where is that finding?
Lordship would get at page paragraph 16 onwards, internal page 14.
Yes.
It is evidence of PWD that in spite of best and available treatment, his son did not come to normal position. Now his right upper limb is functionless and it is solely cosmetic value. There is no sensation and power in the right upper limb and it's just hanging.
His son cannot do any work, including day-to-day activities through his right upper limb. Due to severe fracture to the right femur and split up surgery and implants, he cannot walk, sit, and squat and climb the stairs. He cannot do any physical activity in the right leg. The right leg is deviated. He's lost his memory as well as judgment, making power and slurred speech. His son is neurologically deficient. Further, he is suffering from giddiness and frequent headache. He is physically and functionally 100% disabled. In respect of disability suffered by his son, he examined Professor and Head of Department Orthopedic, Aral Jalap Hospital, Kolar. He was given the evidence before the tribunal as PW1, and he has spoken in detail about his test conducted and also the diagnosis made by him, and ultimately opined that petitioner suffered right upper limb disability 90%, lower limb disability at 63%, whole body disability 51%. He has produced exhibit P1 to P4 in patient record, upper limb disability calculation sheet, lower limb calculation sheet, and digital X-ray and CD. During the cross-examination, he admitted that he has successive disability for the injuries sustained by the petition other than neurological disorder. In the aspect including orthopedic department, Dr. Murthy, neurosurgeon, also stated the petition. He deposed that surgery was done and at the time of discharge from the hospital, his general condition was moderate. Further, he admitted that during the treatment period, petitioner was responding to the treatment. He deposed that due to the injury to his upper limb, there is no sensation and movement in the hand after shoulder joint till the end of his said hand. He deposed that no bone grafting is done and there is no shorting. Traction, those fixed temporarily, the petition at the time of surgery are not continued. Deposed that it is very difficult to the petitioner to walk even with the help of crutches or walking stick. He also deposed that there are no chances of improvement in his physical condition. Since there are no movement and activities in the petition, he advised to leave the implants in situ. He deposed that he cannot say anything about mental condition of the petitioner, but if it comes to physical condition, now he is in the state of monoplegia. Further, he deposed that according to the petitioner, he is carpenter by profession, but now he cannot continue his profession anymore. This witness denied the disability assessed by him at his right side. In respect of disability suffered by petitioner, Professor Neurosurgery, Department Clinical Psychology of Niman's Hospital is examined as PW2. She has produced exhibit P5, Neuropsychological Assessment Performa. PW2 reports that she examined the petition on 29/11/2000 for the assessment of neurological disability. On clinical examination, patient was conscious. Petitioner was alert but did not respond to the questions asked by the examiner. No eye-to-eye contact was made. It was difficult to establish report. His attention could not be aroused but difficult to sustain. His comprehension for very simple items had to be repeated several times. For complex items, this poor is hence a complex neurological so attempted cannot be commented upon him. Vineland social maturity scale was attempted. He gets an IQ of 9, indicating severe mental retardation. According to Government of India Gazette notification on disability, he gets cognitive disability of 100%. During the cross-examination, she admitted that she personally treated the petitioner. She deposed that at the time of assessment of disability, the petitioner sustained frontal left parietal and sustained compound fracture. She admitted the loss of IQ is assessed by some other neurosurgeon and did not see the document with regard to line of treatment taken by the petitioner. She denied the disability assessed by her at higher side. Considering the nature of injuries sustained by the petitioner, line of his treatment, opinion of ortho and neurosurgeon, as well as the present condition and advice for future treatment in the light of the above documented oral evidence, the disability is taken 50% whole body, it would be justifiable without assigning any 150% disability is taken.
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
ಅದೇ 50% ಅಷ್ಟೇ ತಗೊಂಡಿರೋದು.
Okay.
Neurosurgeon says 100%, ortho 63%. Tribunal without assigning any reason taken only 50% on that basis, computed loss of future running capacity. Lordship, can you see this?
What was he?
Carpenter.
Carpenter.
Evidence of PW1, Lordship, can you see? Sir, evidence of PW1.
PW1 you have read now first.
ಇಲ್ಲಿ separate ಆಗಿದೆ.
ಪಡಿ.
Tribunal omitted some injuries.
Yes.
He was inpatient for 203 days. He was treated as inpatient 203 days. Hence, on examination, he had the following injuries. One, open type 3B supercondylar fracture of right huge femur with intra-articular extension. Two, comminuted fracture of right patella. Three, closed fracture of shaft of right humerus with brachial plexus injury without any movement of in the right upper limb. Head injury, plus with left frontal bone. Depressed fracture in the anterior leg. These are the major injuries. And underwent several surgeries. And evidence of PW2, neurosurgeon said with disability patient need help in all his activities of daily living. Evidence of Lordship can see evidence of PW2, neurosurgeon.
Yes.
I submit 31 is report to Department of Neurological Department, neurosurgery. We that on clinical observation, patient was conscious, he was alert, but did not respond to the question asked by petition. Not eye-to-eye contact was made. It was difficult to establish rapport. His attention could not be aroused, but difficult to sustain. His comprehension for very simple items had to be repeated several times. For complex items, it was poor. Hence, a complete neurological though attempted cannot be commented upon him. Fine line social maturity scale was attempted. He gets IQ of 9, indicating severe mental retardation. According to the Government of India, he gets cognitive disability 100%. With the above disability, the patient need help in all his activities of daily living. I submit the patient cognitive disability 100%.
Yes.
So tribunal has taken only 50% without considering all the aspects, both the evidence of PW1 and PW2.
Yes.
That to have been 100%. Total loss of, it is a total wreck, my lord.
Yes.
And, and an income taken at only 5,000 rupees, accident of the year 2012. And future prospect not been considered. And thirdly, future attorney charges not been granted since it involved that evidence of PW2, he needs patient cognitive disability. Patient need help in all his activities of daily living. So without help of support of attorney cannot live. So tribunal not awarded any compensation towards future attorney charges. And compensation granted towards pain and suffering loss of is also inadequate.
Pain and suffering
regarding
food and nourishment. Loss of income during the treatment period. ಎಷ್ಟು ದಿನ hospital ಅಲ್ಲಿ ಇದ್ರಿ?
203 days.
Yes. Loss of future earning, loss of immunity.
Exhibit P15 is the photographs, my lord.
Yes.
You produced
I've seen last time. Yes. Yes, Mr.
Right. With great respect to my learned friend, I have got a serious dispute about the condition of the petitioner.
Yes.
My lord, first of all, my lord, he has not produced before the court. Court has not observed the physical condition of the petitioner, whether he is going to examine or not, whatever the thing. Court should have observed the physical condition before going to the merits of the case. My lord, here, let me kindly see, as per the photographs produced. Kindly see the photographs, man.
Yes.
You don't think like any attendant is required, he is a living vegetable, that thing, this thing, he is on the stretcher or whatever it is.
Yes.
Absolutely nothing, he is perfectly all right.
Yes.
Perfectly all right.
Now that
Kindly see the
PW2 cross examination putting. How you have
full
cross
records illa. Then, my lord, the main important thing, kindly see the photograph, man.
Photograph I have seen last.
Very active. Our ಮುಖದಲ್ಲಾಗ್ಲಿ ಬೇರೆ ಆಗ್ಲಿ ಏಕೆ ಅಂತ ಹೇಳಿದ್ರೆ you ask me kindly see one important thing. My lord, kindly see the date of accident, my lord.
Yes.
According to them, it is on 8/11/2012. Kindly see the date of petition,
When?
2016.
What?
2016. The date of accident, the date of filing the petition, 3/2/2016. If really, my lord, the claimant has sustained such a serious injury.
No, but all the delay has been condoned, tribunal, now that.
That has not been considered at all. First of all, my lord, tribunal is not at all going deep into the matter of that delay aspect at all.
I am in appeal for
Even now, my
enhancement.
lord, even now, in view of the amendment to the Motor Vehicles Act, my lord, tribunal, my lord, even without issuing notice in the beginning itself, they are condoning the delay.
Sir, I am in,
Petition act ಸ್ವಲ್ಪ ತಾಳಿ ಮಾಡಿ ಆಮೇಲೆ ರಿಪ್ಲೈ ಮಾಡಿ. Even before issuing notice, even at the time of registering the case itself, the claimants are filing an application and the tribunal is allowing the application for condonation of delay and permitting them to prosecute the case.
You can challenge that.
The cases are pending before the High Court. Several
We
petitions-
can examine
several-
only if you challenge before us.
Yeah, several petitions are pending before the court and my lord, stay has been granted, but stay is granted only to those particular cases. It is not granted.
No, you have to show before the tribunal saying that similar matter, what has happened, it is stayed by the court.
No. Before issuing notice at all, they have done.
Yes.
Therefore, they are filing application under Order 7, Rule 11 to dismiss the petition. Even that also being dismissed. Petition ಹಾಕಿದ್ಮೇಲೆ ಹೆಂಗಾನಾಗ್ಲಿ ಕೊಟ್ಬಿಡ್ಬೇಕು. That is the concept of the thing, whether there is a negligence, there is a bind by, ಯಾರ್ negligence ಇದೆ, accident ಆಗಿದೆಯೋ ಇಲ್ವಾ, limitation ಇದೆಯೋ ಇಲ್ವೋ ಅಂತ ಹೇಳಿ. But if you have sustained such a serious injury.
Yes.
But why they should wait till 2016 to file the claim petition?
I can't examine now all this.
Yes. Why I am telling is only to justify what, because we should have filed an appeal. Satisfy ಮಾಡಿದ್ರೆ ಕೊನೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಅಮೌಂಟ್ ಏನೋ
No, last occasion you have shown that somewhere tribunal has observed. When he was been cross-examined, he has not, ಎಲ್ಲ ಒಂದ್ ಕಡೆ ತೋರ್ಸಿದ್ರಲ್ಲ?
ನನ್ನ ಹತ್ರ ಫುಲ್ ಪೇಪರ್ಸ್ ಇಲ್ಲ. Because after going through this thing.
they have satisfied me.
They are satisfied.
Side ಅಲ್ಲ?
How my learned can raise all
Fact, they should have
such
filed.
issues in my appeal. I have come in appeal for enhancement.
Yes.
They are not challenged.
It is the duty of the tribunal to see the physical condition.
Yes.
Court has not observed it and there is nowhere in the judgment.
Even cross examine.
ಸ್ವಲ್ಪ ಮಾಡಿದ್ರೆ ಬರೀ ಇಲ್ಲ ಸುಮ್ಮನೆ ಯಾಕೆ
ಹೇಳಿ.
ಮಾಡಿ ನಾನು ಮಾತಾಡ್ತೀನಿ.
ಮಾಡಿ.
ಇಲ್ಲ ಬಿಡಿ, ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಿಲ್ಲ, ಸಾಹೇಬ್ರಿಗೆ ಬಿಡ್ತೀನಿ ಏನ್ ಬೇಕಾ ಮಾಡಿ. If you don't want to argue me, what shall I do?
Yes, let him complete, Mr. Yes.
ಪೂರ್ತಿ ಕಂಪ್ಲೀಟ್ ಮಾಡೋದ್ರೆ ಮಾಡ್ಬಿಡಿ, ಇನ್ನೇನೋ ಇದ್ರೆ ಬಾಕಿ.
ಆಯ್ತು ಹೇಳಿ.
I will have it
Sorry.
this matter of 2 weeks.
I am sorry.
Yes, leave this matter of 2 weeks. I will hear of 2 weeks.
ಅಲ್ಲಲ್ಲ, ನಾನು ರೆಡಿ ಇದನ್ನು ಮಾಡೋಣ ಬಿಡಿ.
No, that. This
ಅಲ್ಲ,
is the thing.
ಇಂಟರ್ಫಿಯರ್ ಆಗಿ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ.
I leave this matter of 2 weeks.
Serial number 27, B. Pradeep for appellant, B. Mahesh.
Yes.
Appearance for the appellant in this case.
Yes, Mr.
This case, my lord, challenging the quantum of compensation
Yes.
ordered by the tribunal, my lordship. The claim petition filed by the wife and major son of the deceased, my lord.
Yes.
As per the income tax returns, my lord, they have produced 2 years income tax returns, my lord. That average income has to be considered, my lord. Last income tax 2016-17 has been considered with it.
No, last 3 years has to be considered.
2 years has to be, only 2 years they have applied.
ಆಯ್ತು, ಅದ್ರಲ್ಲಿ average ತಗೋಬೇಕಾಗುತ್ತೆ.
Average ತಗೋಬೇಕು ಅಷ್ಟೇ. ಅಷ್ಟೇ average ತಗೊಂಡ್ರೆ ಆಯ್ತು.
ಎಷ್ಟು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು?
ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್
ನಮ್ದೇ ಯಾವ್ದೋ ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ?
ತಾವೇ ಮಾಡಿದ್ರು.
ಡೇಟ್ ಆಫ್ ಡೆತ್ ಇಂದು ಲಾಸ್ಟ್ ಇಯರ್ ತಗೊಂಡಿದ್ದಾರೆ. ಇಫ್ ಇಟ್ ಇಸ್ ಕನ್ಸಿಡರ್ಡ್ ಪ್ರೀವಿಯಸ್ ಇಯರ್, ಅದನ್ನ ಅವರೇಜ್ ಅಲ್ಲಿ
ಈಗ ಏನಾದ್ರೆ ಡೇಟ್ ಆಫ್ ಡೆತ್ ಇಂದ ಕಡಿಮೆ ಇದ್ದಿದ್ರೆ ಏನ್ ಮಾಡ್ತಿದ್ರಿ? ಹಿಂದಿನ ವರ್ಷ ತಗೊಂಡ್ರಿ ಅಂತ ಇದ್ರಿ. ಅದಕ್ಕೆ ವಿ ಸೆಡ್ ಟೇಕ್ ಇಟ್ ಅವರೇಜ್. ನಾವು ಯು ಸೆಡ್ ಮಿನಿಮಮ್ 3 years.
ನಾನು ಇನ್ನೊಂದನ್ನು ಹೇಳಿ, ಇನ್ನೊಂದು ಏನ್ ಕೇಳಿದ್ರೆ ಸ್ವಾಮಿ,
ಅಂದ್ರೆ 2 years ಅಷ್ಟೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ಟು, ದಟ್ ಇಸ್ ದಿ ಡಿಫಿಕಲ್ಟ್.
ಹೌದು, 2 years ಅಲ್ಲಿ ಅವರೇಜ್ ತಗೋಬೇಕು.
2 years IT ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ರೆ, ಅದ್ರ ಪ್ರೀವಿಯಸ್ ಇಯರ್ ಕೊಟ್ಟಿಲ್ಲ.
ಇವ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ 2 ವರ್ಷದ್ರಲ್ಲಿ ಅವರೇಜ್ ತೆಗಿತೀವಿ.
ಹೌದು.
ನೀವು 5 ವರ್ಷದ ಕೊಟ್ರು ನಾವೇನ್ ಹೇಳಿದ್ರೆ ಮಿನಿಮಮ್ 3 years ತಗೊಳ್ಳಿ ಅಂತ.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಏನಂದ್ರೆ ಸ್ವಾಮಿ ಸೋರ್ಸ್ ಆಫ್ ಇನ್ಕಮ್ ಬಂದ್ಬಿಟ್ಟು ಅಗ್ರಿಕಲ್ಚರ್ ಪ್ಯಾಡಿ ಕ್ರಾಫ್ಟ್ ಮಾಡ್ತಾ ಇದ್ವಿ ಅದರಿಂದ ಬರ್ತಾ ಇತ್ತು ಸೋರ್ಸ್ ಅಂತ. ಸೂಪರ್ವೈಸರಿ ಹಂಗಂತ ಹೋದ್ರೆ ಸೂಪರ್ವೈಸರಿ ಚಾರ್ಜಸ್ ತಗೋಬೇಕಾಗ್ತದೆ. ಯಾಕಂದ್ರೆ
ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಅಸೆಸ್ ಅವೆಲ್ಲ ಲೆಕ್ಕ ಬರೋದೇ ಇಲ್ಲ.
ಇಲ್ಲ ನಾನು ಜಸ್ಟ್ ಅವ್ರಿಗೆ ಎಕ್ಸಾಂಪಲ್ ಹೇಳ್ದೆ ಸರ್. ಈಗ ಸೋರ್ಸ್ ಆಫ್ ಇನ್ಕಮ್
ಈಗ ವಾಟ್ ಇಸ್ ದಟ್
My lordship,
ಇನ್ಕಮ್?
kindly turn to page number 17 of the judgment. Internal page.
Yes.
My lord, first year, my lord, 2,09,880.
17. Yes,
First
year,
line itself shows, my lord, 2,09,880.
2,09,880.
880. Next,
ಅಲ್ಲ 15 and 16, 16 and 17
ಹೌದು,
2 lakhs.
only 2 years, sir. First year, 2,09,880.
343 is next.
Next year, my lord, after paid the tax of 2,462, 341,048. ಇದೆರಡನ್ನು ಅವರೇಜ್ ಮಾಡಿ
ಐದು ಕೊಡ್ರಿ. Which is that exhibits?
ಎಕ್ಸಿಬಿಟ್ my lord,
9, 10.
P9 and 10, my lord.
Huh?
P9 and 10.
P9 and 10.
15, 16, 16, 17.
Only 2 years.
15, 16, 16, 17 ಅಷ್ಟೇ.
ಹೌದು ಅಷ್ಟೇ ಸರ್.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಅವಾಗ?
My lord, 17, my lord.
ಡೇಟ್?
17, my lord, date 23/11/2017.
23/11/2017.
Before the accident itself, they have filed.
Yes, then there is no manipulation. ಅಲ್ಲಿಗೆ ಎಷ್ಟು ಬರುತ್ತೆ?
My lord, I read it, my lord. Average ಅವಾಗ 12,85,498 ಆಗುತ್ತೆ ಡಿಪೆಂಡೆನ್ಸಿಯಲ್ಲಿ.
ಇವ್ರು ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
ಇಲ್ಲಿ ಅವ್ರು 3 ಲಕ್ಷ ಚಿಲ್ಲರ ತಗೊಂಡಿದ್ದಾರೆ.
ಅದು ಅವರೇಜ್
ಟೋಟಲ್ ಅವರೇಜ್ ಮಾಡ್ತೀನಿ ಸರ್.
3 ಲಕ್ಷದ
2 lakhs.
3 ಲಕ್ಷ
3,41,000.
2,41,880 ಪ್ಲಸ್
3,41,048.
ಟ್ಯಾಕ್ಸ್ 43,510.
ಅಲ್ಲ
41,048.
ಅದು
They have paid a tax, my lord, 2,460.
Tax 41,048.
Please.
Divided by 2 into 12 ಏನೋ.
ಹೌದು, divided by 2.
by 2 ಮಾಡಿ. 2,75,000 ಬರುತ್ತೆ.
ಹೌದು ಸರ್, 2,75,464
ವರ್ಷಕ್ಕೆ ಡಿವೈಡೆಡ್ ಬೈ 12.
ಇಲ್ಲ ಅದನ್ನೇ ಮಲ್ಟಿಪ್ಲೈರ್ ಮಾಡ್ಬಿಟ್ರೆ
ಅದನ್ನ
ಒಂಥರ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಮಲ್ಟಿಪ್ಲೈರ್ ಮಾಡಿ.
ಅಲ್ಲ, ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಆಡ್ ಮಾಡ್ಬೇಕು.
ಇಲ್ಲ ಇದರಲ್ಲಿ 65 ವರ್ಷ.
65.
65 ಅದಕ್ಕೆ ಬಿಟ್ಟಿದೆ.
Yes. ಅದೊಂದೇನಾ?
ಅದಾದ್ಮೇಲೆ ನಾನು ಅದು ಅದರ್ ರೇಟ್ಸ್ ಅದರ್ ಗ್ರೌಂಡ್ಸ್ ಐ ವಿಲ್ ನಾಟ್ ಪ್ರೆಸ್ ಬಿಕಾಸ್ my lord, ವೈಫ್ ಅಂಡ್ ಸನ್ ಆರ್ ದ ಕ್ಲೈಮೆಂಟ್. ಒಂಥರ ಡಿಡಕ್ಟ್ ಮಾಡಿಯಾರೆ, ಅದನ್ನ 50% ಮಾಡಬೇಕು ಅಂತ ಕೇಳಿದೀನಿ ಗ್ರೌಂಡ್. ಬಟ್ my lordship has already decided.
1/3 ನಾವು ಮಾಡ್ತಾ ಇದೀವಿ.
ಮಾಡ್ತಾ ಇದೀರಾ ಸ್ವಾಮಿ?
Wife
ಹಾಗಾಗಿ ಆಮೇಲೆ ಇಂಟ್ರೆಸ್ಟ್ my lord 8%
ಸನ್ ಅಂತಂದ್ರೆ ಇನ್ನೊಂದು 40 ಆಡ್ ಆಗ್ಬೇಕು.
ಅದಾಗುತ್ತೆ 1,10,000 ಮಾಡ್ಬಿಡಿ ಸ್ವಾಮಿ ಟೋಟಲ್ ಕನ್ವೆನ್ಷನ್ ರೇಟ್.
ಇಂಟ್ರೆಸ್ಟ್
8 ಇರೋದು 6% ಮಾಡ್ಬೇಕು.
Yes, that's all, Mr.
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
So and so learned counsel appearing for. ನಮ್ದ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಾ?
ಅದು ಜಸ್ಟಿಸ್ ಅರಾಕರಾದೆ ಸಾಹೇಬ್ರು ನೀವು ಮಾಡಿದ್ರಿ ಸರ್.
ಅಲ್ಲ,
ಅದು
ನಾನು ಜಸ್ಟಿಸ್ ಅರವಿಂದ್ ರೀಸೆಂಟ್ ಆಗಿ ಬರೆದುಂಟು.
ಧಾರವಾಡದಲ್ಲಿ
ಗುಲ್ಬರ್ಗದಲ್ಲಿ.
ಗುಲ್ಬರ್ಗ.
ಅದೊಂದು ತೆಗೆದಿಟ್ಕೊಳ್ಳಿ. ಅದು ಇದೆ ನೋಡ್ರಿ, ಅದು ಅವರೇಜ್ 3 years.
ಅವರೇಜ್ 3 years. ಅದೊಂದು ಮತ್ತೆ ಇಲ್ಲಿ ತಾವು ಮಾಡಿದ್ರು ನನ್ನ ಹತ್ರ ಇತ್ತು.
ಅದು ಹಿಂದೆ ಮಾಡಿದ್ದು ಇದು, ಬಟ್ ಸ್ಟಿಲ್ ಇವ್ ಹ್ಯಾವ್ ರಿಪೋರ್ಟ್ ಮಾಡುದು ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಅದಕ್ಕೆ
ಅದನ್ನ ನೋಡಿದೆ ಸರ್, ಮತ್ತೆ ನನ್ನ ಹತ್ರ ಇದು ಸಿಕ್ಕಿಲ್ಲ.
Contended that the claimant has filed an income tax returns of the deceased for the year 2015 and 16 and 16 and 17. Tribunal, instead of taking that average income as assessed, only income tax returns filed for the year 16 and 17. In support of his contention, he has relied on judgment of so and so. ಸಿಕ್ತ ನಮ್ದು ಅವ್ರು ಗೋಪಾಲ್ ಕೃಷ್ಣ ಕೊಟ್ಟಾರಂದ್ರ
ಕೊಡ್ತೀವಿ. ಇನ್ನೊಂದು
ಅದಲ್ಲ,
ಅಲ್ಲಲ್ಲ
ನೀವು ಕೊಟ್ಟಿದ್ದು ಇದ್ರದ್ದು ಯಾವ್ದು ಅಂತ ಅಂದ್ರೆ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಅಲ್ಲ, ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ಸ್ 3 ವರ್ಷ ತಗೋಬೇಕಂತ
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಕಳಿಸಿದ್ರು. ಅದನ್ನ
ರೀಸೆಂಟ್ ಆಗಿ ಅದು ರಿಪೋರ್ಟ್ ಏನೋ ಮಾಡಿದ್ದು, ನಂದು ಅರವಿಂದ್ ಅವ್ರದ್ದು ಇದೆ. He has relied on that judgment so and so. Secondly, he has contended that In view of judgment of this court, the interest awarded by the tribunal 8% is on higher side. So and so learned counsel appearing for the claimant has contended that the accident is occurred on 23/11/2017. For the years 16 and 17, the deceased has filed an income tax returns of rupees 3,41,448. Accordingly, tribunal has rightly assessed the income of the deceased as 3,41,048 per annum. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable.
ಇನ್ನೊಂದ್ ಕೇಸ್ ನಲ್ಲಿ ಓನ್ಲಿ ಲೇಟೆಸ್ಟ್ ಡೆತ್ ಇಯರ್ ಅಲ್ಲೇ ಒಂದೇ ಒಂದು IT ರಿಟರ್ನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿರ್ತಾರೆ. That was taken into consideration, but not 3 years because he has not even filed previous years.
Anta case bandaga it's in a special
Because
circumstance.
he was less
to
age
see.
also, less age.
When you have filed 2 years, then you have to take an average.
Yes, that is.
ಅದು ಕೆಲವರು ಏನಾಗಿರ್ತಾರೆ ಅಂತ ಅಂದ್ರೆ ಜನವರಿ ಫೆಬ್ರವರಿ ಸತ್ತೋದ್ಮೇಲೆ ಮಾರ್ಚ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡ್ತಾರೆ ಮನೆ.
Advance tax ಮಾಡಿ that shall not be considered.
Heard the learned counsel for the parties, peruse judgment and award and original records. It is not in dispute. What is the Ningachar?
Yes,
died in
Ningachari.
Died in road traffic accident occurred on 23/11/2017 due to rash and negligent driving of driver of the bus bearing registration number KA 16 B529. The claimant has filed income tax returns submitted by the deceased for the year 15 and 16 as exhibit P9 as shown as 2,09,880, and for the year 16 and 17 exhibit P10 sum of rupees 3,41,048. In view of judgment of this court, the average has to be considered for assessing the income of the deceased. Accordingly, for the average income of the deceased has to be considered as
2,75,464.
2,75,464. 464. The annual income of the deceased has to be considered as 2,75,76.
75,464.
75,464. That multiplier applicable to that age group is 7. Accordingly,
1/3 personal expenses.
1/3 of the income of the deceased has to be deducted for personal expenses. Accordingly, loss of dependency has been reassessed as follows.
12,85,498.
Like 83,637 into
12 into
7 multiplier.
7 ಅಲ್ಲ, ಬರೀ
12 ಬರಲ್ಲ sir,
12
12 ಬರಲ್ಲ. 1/3 deduction.
1/3 deduction ಮಾಡ್ರಿ.
ಆಯ್ತು.
Into 7 ಅಷ್ಟೇ.
7 multiplier. 12,85,498.
Yes. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. Claimant number 1 is entitled 40,000. Yaru 1?
Son. One son ಮೇಲೆ second mother. ಅಲ್ಲ wife.
Yes, 1 is entitled 40,000 for parental consortium. 2 is entitled 40 for spousal consortium. In view of judgment of this court, the interest has to be scaled down to 6% from 8%. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The amount in deposit is transferred to the tribunal.
ಅಲ್ಲಿ only petitioner number 2 ಅಂತ ಆಗ್ಬಿಟ್ಟಿದೆ. Release the amount only in favor of petitioner number 2, mother.
ಮದರ್ಗೆ ಅವ್ರಿಗೆ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಮದರ್ಗೆ ಜಾಸ್ತಿ
ಇಲ್ಲ,
ಕೊಟ್ಟಿರಲ್ಲ.
ಇವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲಿ ಕೊಡಿ?
ಲಾಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 24 ಅಲ್ಲಿ petitioners ಅಂತ ಹೇಳಿದ್ದಾರೆ.
40% shall be.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದಾರಲ್ರಿ?
ಇಲ್ಲ 40%
Together with
national,
40% shall be declared.
national bank, entire amount.
One and
Only
two are
petition.
jointly severally liable to insurance. shall be-
Petition against second
ಅಲ್ಲ
respondent.
next page ಅಲ್ಲಿ
24
The petition respondent number 2 is hereby dismissed. Who is Arto?
one of another vehicle.
Arto is that owner. Another-
Page number 24 ಅಲ್ಲಿ ನೋಡಿ. Second para. And deposit the compensation amount together with interest, 40% shall be deposited in the name of petitioner number 2 for a period of 3 years, and remaining 60% shall be released in favor of petitioner number 2. Only 2, madam.
On deposit of compensation amount together with the.
ಸನ್ನಿ ಕೊಟ್ಟಿಲ್ಲ, wife ಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ಅಷ್ಟೇ.
ಸನ್ನಿಗೆ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ, wife ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸನ್ನಿಗೆ now he is entitled only for the 40,000 what
estate.
I have granted.
ಹೌದೌದು, loss of estate ಅಷ್ಟೇ.
Shall be deposited ಪೂರ್ತಿ wife ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. He has not entitled that.
ಆ 40%
ಹೇಳಿದ್ನಲ್ಲ 40,000. 40,000 for so and so. The 40,000 is directed to be released in favor of
with interest.
first claimant. Yes.
Number 19 ಏನಾಯ್ತು ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತಲ್ಲ?
ಬ್ಲಾಕ್ ಬ್ಯಾಗ್ ಇದೆಯಲ್ಲ ಅದ್ರ ಮೇಲ್ಗಡೆ ಒಂದು ತೆಗೀರಿ.
ಎರಡು ಗಂಟೆ ಎಣ್ಣೆತ್ತೆ ಆರ್ತಿ ಸಪರೇಟ್ ಎಣ್ಣೆತ್ತೆ ಒಂದೇ ಒಂದು ಸ್ಕೂಟಿಗೆ ಅಲ್ಲೇ ಬಂದಿದೆ.
ಅದ್ರದನ್ನ ಬೇರೆ ಅದ್ರದನ್ನ ನಮಗೆ ದೊಡ್ಡದಾಗಿ ಅದು ಕಟ್ಟಿರ್ತಾರೆ.
ಎಲ್ಸಿಆರ್ ಬ್ರಾಂಚ್ ಇಲ್ಲ ಹಾಕ್ತಾರೆ, ನಿಲ್ಸಲ್ ಮೇಡಮ್ ಮಾಡ್ತಾವ್ರೆ ಅಷ್ಟೇ. ಫೈನಲ್ ಇದ್ರೆ